Yeah. For sake of brevity, can we stipulate as to the authenticity of the easement agreement, the vesting deeds, and the surveys that have been produced?
Yes.
Okay.
We stipulate as to the authenticity, and we have no objection to those being in the record. I do object to them going back with the jury, but we'll talk about that later.
Right. Okay, excellent. All right, I think we're almost set up here.
That is an unfortunate sound. I'm not on.
What's this one?
All right, Mr. Williams, let's get on the record. And if you could, when you get a chance, let me know what time your breaks need to be today, so I can keep track of those. We are back in the matter of the Andersons versus the Davids. It is Tuesday, around 9:20, and we now have all our jurors. A couple of them wandered in a little bit after 9, but I think the jurors are ready to go. Mr. Edwards, anything we need to cover from the Anderson side before I bring the jurors in, swear them in, and give them a preliminary or initial charge?
Well, the only thing would be the preliminary or initial charge if you're going to give some version of what we've requested so that I don't step on my toes in the opening.
Okay, I'm not going to. I read that last night, and it is the type of thing that I'll give if I'm going to give something like that in my final charge. I don't think that prevents you from talking about any of that in your opening, but my initial charges to juries in criminal and civil cases are light on the law and much more on the here's what to expect. And that you'll hear about the law from the lawyers and from me, but that'll be at the end. So if in your opening you were going to say, like you heard the judge say, I wouldn't say like you heard the judge say, because I won't be saying it. Not because there was any legal issue with the charge you proposed. It's just not what I give up front. Okay.
Understood. We'll cross that bridge later as to whether you give it.
Yeah, definitely. Well, Ms. Niles is already working. There are many jury charges bouncing around out there. She's trying to put her arms around them. Ms. Sturm, anything we need to cover from the David side before the jurors come in?
No, Judge.
Okay. I'm trying to remember where we put that screen for the jurors. Where it is right now, the jurors won't be able to see if there's a,
like right in the middle.
okay, is there a cord? Is the cord that long? Because I'm guessing with your first witness, Mr. Edwards, or at least your first few witnesses, you'll be wanting to get things up on a screen for the jurors to see.
Yes,
And that's not in a great spot right now.
right. And also have a PowerPoint that I want to use in my opening, and I don't want to have to be standing in front of that or turning my back to the jury.
Yeah, so I'm gonna just acknowledge up front, this is a suboptimal setting for digital stuff. This courtroom is older than anyone in courtroom right now.
So I still just push it on.
Well, I don't need to see that screen because I'll have it here. Mr. Logan, why don't you sit in the jury box and let us know whether you can see that screen?
Is it
It'd be
raise
tough
up?
for folks who are, the podium is gonna block it.
Not from here. Kind of from here.
You see everything from here and presumably,
Okay.
so.
What if you move it forward? Can it go forward more? I don't know how long the cable
It's
is.
got a few more feet.
And then, all right, so try that
There's enough seats in this after box, but they'd all just kind of be.
for the 12. Yeah, but we may tell them just leave those others.
I can turn this around and just deal with it as I can.
Well, I think we may have, if the cord goes that far, I think we may be good there.
Yeah.
I'll roll way over here to make sure those.
Yeah.
Okay. Why don't you, move it against the podium, where I have maximum view of the
You
exit.
ever had that happen?
Okay.
Ever fall asleep in the middle?
Oh, yes.
And Mr. Williams, I think you'll be okay because jurors won't be talking. The witness is to your right.
Very
So we'll
comfortable.
see if this works. All right, we can always adjust the monitor if we need to. All right, let's bring the jurors in, please.
All rise for the jurors.
Oh, that was amazing. Not a good job.
I'll do the president of the county floor.
Thank you, Deputy Gordon. You all can be seated. Good morning, ladies and gentlemen.
Morning.
Welcome back to 9J. Are you able to take your dark glasses off? Thank you.
My eye's been bothering my right eye,
Okay.
like it itches and.
Hopefully, no one had too much difficulty getting here this morning. As will always be the case, we cannot get started until all 13 of you are here. So as you're working through who's showing up right at 9, a little past 9, you can let them know, hey, we're waiting on you. But I also know that getting around in Atlanta can be complicated. We are ready in a few moments to start the trial. I need to cover some logistical things. The most obvious logistical thing is that this screen blocks my view of some of you and you of me. I'm not the important one in the case, but when I'm talking to you, I'll probably stand up over here so I can see all 13 of you. Number two, there are no assigned seats, so you don't have to sit in that seat right there. You're welcome to, but don't grab a seat and say it's mine, or if someone's sitting in what you think is your seat, give them a mean mug because it's not your seat. These are all juror seats, and I actually encourage you to sit in a different seat each time you come out because you'll get a different perspective. The witnesses are going to be sitting right there. So the 6 of you are going to see the witnesses up close. You're going to be kind of far from the witness and you may see something different the closer you are or the further you are from a witness. If at any point you have trouble seeing what's on that screen or hearing what people are saying, let me know. There is not a rewind button. You will not get a recording of anyone's testimony or a video of these proceedings for your deliberations. So if at any point you have lost an ability to hear, or we've got a witness who's talking like this, I'll make sure the witness speaks loudly into the microphone, but I'll need to know from you if you're having trouble seeing or hearing. Follow up to that is if you're having trouble keeping track of what's going on because we've been going on too long and I haven't thought to take a break, let me know about that as well. You may have just reached a saturation point, like, Judge, it's been an hour and a half and you don't need to editorialize, but has been real boring testimony and I need a break. That's okay. We'll take a break. We will take breaks regularly, but sometimes those breaks don't hit quite on the cycle that you might need a break. And I can sort of read minds. If I see you sleeping, then I'll know we need to take a break. But you may actually be staying awake, but fading. Like, I just can't keep up with what this witness is saying. And then let Deputy Gordon or me know, and we will take that break. We will break once in the morning, once in the afternoon, and always for lunch. And then any more times that you need it. So those are the logistics. Please be here on time. Sit wherever you want. Don't always take the same seat unless you are one of the jurors who said, you know what, because of my hip, my back, whatever it is, I need to be able to stretch in a certain way. And then you own the seat that lets you do that. You don't want to be stuck in the middle if you have to get up and kind of ease by people to do that stretching. You are free to take notes. You're not required to take notes. But as I mentioned, you will not get a transcript of witness testimony or a video of what happened. So if there's something that you thought was important and you think it would be helpful to you to jot it down, go for it. Do not try to take down word for word what's being said. There's only one person in the courtroom capable of that. That's Mr. Williams. He is a paid professional. He is making a transcript. It's not a perfect transcript right now. He'll make it a perfect transcript for appellate purposes if there is an appeal of whatever happens in here. But if you try to take down everything that's said, you're going to miss important things that happen. One important thing could be that a witness, when he's answering questions from one side, is all smiles. But the moment the questions start to get tricky, he starts to sweat and not look at you anymore and has different physical manifestations of how he's handling this. And that may mean something to you as you're weighing the credibility or evaluating the believability of the witness. And you miss that if you're buried in your notes trying to write down every single word that is spoken. It's not possible. Your notes are private until you begin your deliberations. So don't go back there and say, hey, here's what I wrote down about what this witness said, and here's what I think about it. You actually don't begin your deliberations, your group discussion of what this case has shown or failed to show until you've heard all the evidence and you've heard the charge that I give you, the law that you have to apply. Then you will, as a group, talk about your thoughts and feelings, who met their burden of proof and who didn't. Then you can rely on your notes. You can share your notes with each other. But until then, your notes stay private. Finally, about the notes, they'll be destroyed after the trial. So if you're writing down, judge is a blowhard, don't worry. I will never see that. They get shredded. And then whatever's left in the pad, we reuse for the next trial. So we've had jurors who draw pictures and this and that, and you can sketch anything you want. They'll be, they won't show up on the Fulton County website or anything like that. They'll be destroyed. Before I give you the charge that I need to give you to get things rolling, I need you all to stand and raise your right hand. There's one more oath for you to take. Yesterday, you took the voir dire oath that made you potential jurors, but you're about to take the juror oath that will make you actual jurors. Ready with those right hands? Do you swear or affirm that you shall fairly try this case and provide a true verdict according to the law that I give you and the opinion that you form concerning the evidence to the best of your skill and knowledge without favor or affection to either party? Please say yes if you so swear or affirm.
Yes.
Does anyone not so swear or affirm? All right. You are all officially jurors. Thank you. Take a seat. One more logistical thing, and it actually may have happened yesterday some as well. From here on out, you are in a little bit of a cocoon. If you're going to hear anything about the case, see anything about the case, it's with all 13 of you in the room, the lawyers here and their clients here and me here as well. What that means is that if you are out in the hallway heading to lunch or it's a break and one of the lawyers is walking by and you're not sure, hey, which way is the restroom or what's a good place to eat lunch? They're going to treat you like you have the plague because they're not supposed to interact with you outside the four walls of this courtroom. Because you could imagine if lawyer for one side sees three of you yucking it up with lawyer for the other side, like what's she saying to these jurors? That's not the type of interaction that should happen. If a lawyer is going to address you, it'll be all 13 of you here in court with me watching. So the other side could say, wait, objection, or have an opportunity to say what they want to say about the case. So these are very nice lawyers, and they probably could tell you where to have lunch, but they won't during the trial. They'll say, I'm sorry, I can't talk to you. Or if you get on the elevator and they're already on it, they're going to get off the elevator. And it's not because you didn't shower. It's because they shouldn't ride on the elevator with you, because the other side might see 4 of you step off the elevator laughing, and the lawyer for the other side gets off the elevator. And then there's a question of, wait a minute, what kind of interaction just happened there? So we try to have no interaction other than inside the courtroom. All right. Ladies and gentlemen, you are about to hear the case of Tracy and Claire Anderson versus Stacy and Jean-Noel David. Before we dive into the trial, I need to talk to you a little bit about the law, and more so about my role, your role, and the lawyer's role in a civil trial. Most of you have not served on a jury before, and what you know, think you know about trials is from TV, and it's not like on TV. There will not be a point in the trial where someone bursts through the door and says, I killed Mr. Jones. 1, there's no murder in this case, no one's dead. And 2, that's just not how it plays out. We're going to have witnesses testify, there'll be evidence, and you all will decide how this case needs to sort out. We've already talked about notepads. Feel free to take notes if you're, we can only provide pencils. That's the county budget. You're welcome to use a pen. It's not required to be number 2 pencils. It's not a Scantron situation. But if your pencil gets dull, we do have sharpeners and more pencils, but we don't have pens. And if you run out of paper, we can get you another pad. In civil cases like this, the plaintiffs have the burden of proving their claims, and they must prove their claims by what is called a preponderance of the evidence. Now, the Davids have brought counterclaims, so they have claims against the Andersons. The case is Andersons versus David. So the Andersons have claims. They have the burden of proof as to those claims, but there's some counterclaims. The Davids have that same burden of proof, preponderance of the evidence. And what preponderance means in the context of a civil trial is superiority in weight. And what a preponderance of the evidence means is the greater weight of evidence upon the issue involved. To be a preponderance, the weight of the evidence must be sufficient to incline a reasonable and impartial mind, so your minds, to one side of the issue rather than the other. And this is where that image of the scales of justice can come into play. A preponderance of the evidence is enough evidence. We've got one dish in the scales that says Andersons and one dish that says Davids, and you put all the evidence on there and is leaning in this way. That's all it takes. It doesn't have to lean this much. It doesn't have to lean that much. If you perceive that the weight of the evidence causes you to incline, to lean in the direction of one side or the other, that's the side that has prevailed. Now, if it is even, exactly neutral, then the defendant on that claim prevails. And so the main claims, the claims that the Andersons are bringing against the Davids, if you call it a tie, I just can't decide, then that would be a verdict for the Davids. The Andersons must have a preponderance of the evidence, cause you to lean, your reasonable and impartial mind, lean in their direction. Similarly with the counterclaims, when you're thinking about the claims that the Davids have brought, the evidence must be, if you're going to find for them, a preponderance in their direction. So again, tie or anything in the opposite direction would be a verdict for the defendant of that claim. I'll talk about that at the end of the trial as well. The basic structure of the trial is that in a few moments, you will hear opening statements from the lawyers. An opening statement is a preview of what this case is about. It is not evidence. In fact, nothing the lawyers say is evidence. Evidence is going to come to you in 2 forms: witness testimony and exhibits, pictures, documents, whatever the lawyers may be propounding. But what the lawyers say is advocacy. It's not evidence. They're going to tell you what they think the evidence is going to be. This witness is going to say this, this witness is going to say that, and they may be exactly right. Often the forecasts are correct. But the purpose of an opening is to let you know what the case is about and to understand preliminarily what the 2 sides' contentions are. It's not proof of anything. When the openings are done, then the plaintiffs, the Andersons, Mr. Edwards and the other 2 lawyers, will begin presenting their case. They'll do that by calling their first witness. Could be anyone in the courtroom or a witness waiting outside. Once that witness is sworn in and answers the first question, you've begun to receive evidence. But a lawyer's question isn't evidence. Sometimes the questions are long and they sound like evidence. Isn't it true that it was rainy that day? If the person says no, the evidence you have is that it wasn't rainy that day, even though the lawyer said, isn't it true it was rainy that day? Now, the lawyer may end up undercutting the credibility of that witness who said, no, it wasn't raining. But again, it's not what the lawyers say, it's what the witnesses say. When the plaintiffs have presented all of their evidence, at some point, I'll say, Mr. Edwards, call your next witness. And they'll say, Judge, plaintiffs rest. They will have completed their case in chief. And then I will turn to the lawyers for the Davids to see if they have any evidence they want to present in opposition to the Andersons' claim or in support of their counterclaims. And it's going to get a little muddled together. It won't be confusing so much as just it overlaps because we're talking about one easement, easement number 2, and there are competing claims as to those easements. So it may well be that Mr. Edwards calls a witness, and in that witness's testimony, you're hearing a bit about counterclaims that the Davids have brought, because the claims and counterclaims all involve easement 2. But at some point, Mr. Edwards will say, we rest, and I'll turn to Ms. Sturm and Mr. Snyder. They'll have an opportunity to present evidence as well. In the same way, call witnesses, present exhibits, etc. Eventually, the lawyers on both sides will say, we're done. We don't have any more evidence. The evidence will be closed. The lawyers will have an opportunity to present closing arguments. That is when they will argue, not with you, but to you, here's what you ought to do. Because of this evidence, or this lack of evidence, or this conflict in the evidence, you should decide in our favor. And they are free to advocate, and you are free to be persuaded by what they say. But what they say is not evidence. If the lawyer just getting red in the face telling you it was rainy that day, and you're like, I've seen the pictures, there was no rain. You decide whether it was rainy or not. But it is okay to be persuaded by what the lawyers have to say. You are the determiners of what the facts are. And when those closings are done, I will get back up and give you the law that you must apply to the facts that you find. You are the fact finders. I give you the law. You lay that law on top of the facts to say, okay, now that I understand what the Andersons needed to prove by a preponderance, they did it. Verdict in their favor. They didn't do it. Verdict not in their favor. And same with the Davids' counterclaims. During trial, and this you've seen on TV, parties may object to something that's going on. Someone stands up, objection, hearsay, this whole court is out of order. I don't think we'll hear that second one, but they're free to object. My job when there's an objection is 1, to pause things, and then 2, to rule on the objection. If I sustain the objection, that means that whatever question was asked needs to be unasked, and the lawyer opposing it needs to ask it in a different way or move on to something else. If I overrule the objection, we keep on going in exactly the way we were going. Every once in a while, when there's an objection, if it is sustained, the lawyer who made the objection may say, Judge, I move to strike that testimony. And it may be appropriate for me to do that. And I'll tell you, hey, you need to disregard what that witness just said. If you wrote it down, cross it out. And that may seem to you like a kind of an artificial exercise. Like I heard what he said. He said that the light was green when the car went through the intersection. How am I going to unremember that? Well, I want to reassure you that if what was said that's being asked to be struck, and I'm telling you to strike, is fundamental to you deciding the case, I don't just tell you to strike. We have something called a motion for a mistrial. And you have to leave the room, and I talk with the lawyers. And if someone said something that they weren't supposed to say that is so central to the case that you can't really unring that bell, you probably have to do the trial all over again. This probably isn't that kind of case. This isn't one where there's a confession that was suppressed. So I don't think we'll run into that. But every once in a while, there may be something I tell you, hey, you need to disregard that. And your job is to do that. And if during deliberations, someone in your group says, hey, remember that guy who said the light was green? Judge told us to disregard that. So just, we don't have evidence in front of us that the light was green. I mentioned motions. Parties are also able to make motions. Motion to you basically means break time, because a motion is an objection that is sufficiently complicated that we need to speak freely about it outside your presence. The lawyer needs to be able to say, hey, I think this is about to happen, and I don't think it should happen. and he or she can't articulate that in front of you without it getting out of the bag. I don't know that there'll be a ton of motions in this case, and sometimes I'll ask the lawyers to hold that motion until a natural break point, because often we can work it that way. But just let me apologize in advance if things get a little choppy. If there's a motion, sometimes I do need you to step outside, as in go to the jury room, and we'll work through that as quickly as we can. Now, I have to rule on motions and objections. Nothing that I say in ruling on a motion or an objection or at any other point in the trial should be construed by you as me offering my opinion as to who's got the better case or the believability of the witness or the strength of the evidence. I'm merely applying the law as I understand it to the objection or the motion that was made. If I sustain an objection, all that means is that was a good objection. It doesn't mean, ooh, that's a great lawyer, or the other side was doing something illegal or anything like that. It just means that, sort of like a foul in basketball. The whistle was blown, foul, we got to move on. But I'm simply trying to apply the law to the situation that arose. My goal in this case is simply to see that it is efficiently tried and tried consistent with the laws of Georgia and the constitutions. So I'm not here trying to weigh in any way on either side. Your job is to determine the facts of the case from the evidence that you see and hear. I've already talked to you about the way that will come to you: witness testimony and physical exhibits. One of the things you'll do as the fact finder is determine the credibility or believability of witnesses. It's for you to decide which witnesses you believe and which witnesses you don't believe, if there are any that you find to be not credible or not worthy of belief. In determining the credibility of a witness, you're free to consider all the facts and circumstances of the case, the manner in which the witness testified. That's what I was alluding to when I said don't get buried in your notes. It may tell you something if a witness gets real sweaty when we get to a particular topic, but otherwise is happy talking about other things. You're also free to consider the witness's interest or lack of interest in the outcome of the case. We call that bias sometimes as well as the means and opportunity for the witness to know the things about which she is testifying. You are free to believe all, some, or none of a witness's testimony. You determine what's worthy of belief and what isn't. You may find that at times the evidence in this case is in conflict, that people are saying things that are inconsistent. It was raining, it wasn't raining, whatever the situation may be. If you do find conflicts in the evidence, you should try to reconcile the conflicts as if each witness has spoken the truth. As you know, very often one person will recall something differently from another, either because they saw it from a different perspective, that parable of the elephant, three blind people and someone's holding the elephant's tail and saying it's like a snake, and someone else is rubbing his side. They're all talking about the same thing, but they have a different perspective on that. So the fact that evidence is in conflict doesn't mean that witnesses were testifying untruthfully. It may mean that recollections or perspectives differ. But if you do find that some parts of the evidence are in such conflict as to make it impossible for you to reconcile that evidence, you should believe the evidence that seems most reasonable, probable, and truthful to you. During trial, you will be permitted to submit questions. At the close of each witness's testimony, if you have questions that were not answered through the lawyer's questions, you will use those note cards, and you see a bunch of note cards on that shelf in front of the jurors in the front row, and we can pass them out. But you should feel free to jot questions down. At the end of each witness's testimony, I'll have Deputy Gordon collect those cards from you if you have any. You don't have to ask any questions at all. But if you do, you'll write them down and he'll collect them. I'll review them, and the lawyers will have a chance to look at those questions as well. Because in the same way that a lawyer's question can be objectionable, a juror's question can be objectionable. If your question calls for hearsay, I probably can't ask it of the witness. Doesn't mean you should write it down. You shouldn't write it down. If it's something you're curious about, do write it down. And the reason why we do this is to prevent this from happening. Hey, I don't know what that word means. I'm going to look it up. Or I'd like to see what the house on Habersham looks like. I'm going to go to Google Maps and take a look at it. You must not do that. Outside research is usually grounds for a mistrial because the lawyers in this case aren't able to mediate that to say, well, wait a minute, we know that picture of the house on Google Maps, but it's old. Here's a new one, and they'll put it up on the screen. So if there's something you feel is missing that you want to know about, please scratch that itch by writing down on the note card whatever your question or questions are. It is forbidden to engage in outside research. No online research, no going home and asking a significant other, a friend or whatever, hey, have you ever been in a situation like this? Because I'm in this trial and these lawyers keep talking about an easement and I'm just curious what an easement is. Being curious is fine. The way you satisfy that curiosity has to be limited to writing the questions down there if it isn't satisfied by the good work of the lawyers as they examine the witnesses. A reminder that questions are not evidence. So you may write down a question you think is a humdinger of a question, and I end up not asking it. You should draw no conclusion from that other than that was not a legally proper question. It's not evidence that a question's not asked because questions aren't evidence. It would just be the answers that the witnesses give to your questions. Please, as an extension of this rule that you engage in no outside research, there are no field trips. If you don't normally drive by Habersham and West Andrews, don't drive by there between now and the end of the trial. I promise you, you'll get plenty of footage and pictures and whatnot of what we're talking about. And if you're not getting enough, you should ask for more. And if the lawyers have it, they'll put it up on the screen for you. Unless the lawyers ask for a site visit where we take a field trip, we all get on a bus and roll on out there, don't do it. I know some of you have reason to be kind of near that area. I don't want you to skirt it because that then takes you out of your way. But if you do have to drive by there, don't go real slow and take a look because that's outside research and that is forbidden. Before you start your deliberations, which is at the very end of the trial, it's important that you not discuss the case amongst your group or even in small groups. When you go to lunch, you can go as a group, you can go individually, and you may break up into little groups. Don't talk about the case. Talk about anything else you want. And that may seem a little counterintuitive, like, Judge, that's last witness. He ended up crying. We want to talk about it. We're processing it. You can process it internally. But what's not appropriate is to start saying, I think I know where this case is going. I've heard 3 witnesses now who all say the same thing. I pretty much made up my mind. Well, you don't even know what the law is yet. You don't know what it is the Andersons need to prove by a preponderance or the Davids need to prove by a preponderance. That comes at the end. And there's a reason for that. So you don't already start saying, hey, I'm done. I'm checking out. I heard those 3 witnesses, so I'm going to do Wordle for the rest of the time. Don't. You need to stay focused and resist that temptation to have solved it. It's not a whodunit. It's a what's going on here, and you all are going to decide what the consequences are, if any, for either side based on what's going on. So that's what I have for you. When the trial is over, it will be fine to get online, to talk to people and whatnot, but you're in this little cocoon. When you go home tonight and someone says, how was your day? The answer is, it was super, and I look forward to the next day. But you don't want to say anything more because hey, when I was in trial, when the judge did this, that's what, that means it's not going well for the other side. Different case, different experience. This is your case, and you need to keep it just amongst the 13 of you until it's done. When it's over, if you want to write a book and you want to write a song and you want to do a computer code, go for it. But don't, between now and then, get real public about it. There won't be any media coverage, but in the off chance you turn on CNN and it's like, courtroom 9J today, Andersons versus Davids. Change the channel quickly and figure out what happened. Today's election day in Georgia. Follow the election results instead. So that's what I have for you all. Final reminder, if you can't see or hear, wave your hand or do something so we can crank the volume up or move this monitor around, and we will accommodate you as best we can. And with that, Mr. Edwards, if you are ready with your opening, if you're going to give an opening.
1 second, Judge. Let me try to share my screen. Already. There we go. All right.
Can you help them get around? Yeah, I have a little IT. You should get going, but
Okay.
don't be surprised. This guy's gonna appear here to deal with a little
Okay.
IT.
Thank you, Judge. Morning, ladies and gentlemen. Obviously, next door neighbors should be able to resolve their differences without having to bother judges and juries who have better things to do. But here we are. So why are we here and what do we need y'all to do about it? What brings us here today are the rules that allow property owners to use and enjoy their property in peace, quiet. And the first rule is this: don't go out of your way to annoy, harass, cause harm, and inconvenience to your neighbors. That's called a nuisance. And the second rule is, for property, use it or lose it. And what that means is, if you don't use your property for long enough, we're talking years and years and years, decades, you can lose the right to that property. And it also means, and that applies to people that you bought your property from. If they didn't use it for a long enough period of time, what you bought from them is not what you thought you bought. So let me tell you the story of why we're here and what happened. Next. So Mr. Logan and I are trying to do this, and it's sort of like a quarterback, put it in motion. Hit the next slide, down button. There you go. Next. Keep going. So next. John Noel and David and Stacy David moved in next door to the Andersons. We're talking about these two properties, keep going, at the corner of West Andrews and Haversham Road. And that's the David property here on the left and the Andrews property here that fronts on West Andrews. Next. So the timeline is that the Andersons bought their property in September of 2018 and the Davids bought their property in March of 2020. So the Andersons lived there for a few years before the Davids did. Next. When the Davids bought their property, before they moved in, they started doing construction on their property, which obviously they have every right to do. Did some painting, did some work on the interior. We don't know, they've obviously never had the Andersons over for dinner or cocktails. But the problem started immediately with the construction. Next. What happened is, keep going. What happened is the Davids workers who were working on their house, they didn't park on Haversham, they didn't park in the Davids driveway. They parked here on the frontage of West Andrews, in front of the Andersons' house. Next. And in order to get from West Andrews to the Davids property, they walked all over the Andersons property. Okay? So why'd they do that? Well, it turns out that the Andersons' property has a couple of easements on it. Next. The first is what we call easement 1, which is parking pad, and actually the Andersons own the parking pad. The Davids have an easement to use the parking pad. And then there's also this easement down here, which we call easement number 2, which is the main issue of dispute in this case. So in theory, the workers had the right to use easement 2 next. But they didn't. They used virtually everything other than easement 2. Next. So going back to the timeline, what we see is in April of 1996, 24 years before the Davids bought their property, this lady named Martha Reeves Smith created these easements. Why? That's not for y'all to worry about. That's construction of an easement. The judge is going to tell you what the easement means. So you don't need to speculate as to why she did it or what she meant or what the purpose is. The judge is going to tell you all that. Okay. So we started having encounters almost immediately. The first encounter was over these construction workers. The Andersons tried to reach out, send an email. Don't know if it was the right email, but they tried to complain about it. Nothing happened. Next. And then there was an encounter over trash. The Andersons or someone from the Andersons' house had the audacity to put a piece of trash in the big construction roll-off dumpster in the DeVete property. And they did this because these workers, when they're blocking West Andrews, they're blocking access to the Andersons' trash cans. In the city of Atlanta, when they come by and they see a truck blocking the trash can, they're gonna go on down the road. So the Andersons' trash wouldn't get picked up like it should have been. So they put some trash in the DeVete dumpster. Mr. DeVete came over, saw Mr. Anderson's cooking something on the grill, complained about it. Mr. Anderson explained why they did that. Oh, okay. And that was it. That issue went away. Next, the Andersons were doing some work on their garage. They have a detached house. They have the house here and the garage over here, detached garage. They were cleaning out the space above the garage. They were going to finish it and maybe make it into a bedroom or something like that. Which they have every right to do, obviously. Mr. DeVete disagreed. He came over, knocked on the door. Claire Anderson answered the door, and he told her, "You have no right to do that. People can't live above your garage." And she's like, "Okay, thank you very much," and closed the door. Next, we have disputes over fence and a sod. Go to the next one. So as a result of the construction workers going across the Andersons' property, they built this fence that divides their property. And we see sod here, and we see pine straw here, and we see these big bold stakes and pink and yellow ribbons. This is the Andersons' property. This is easement area 2. These big bold pink and yellow ribbons have been placed there during this litigation by Mr. DeVete to make sure that the Andersons know, don't step on my property. But the problem is, and the reason we're here is because February 21st, 2021, the Andersons were doing some landscape. They were having sod put on their property. This is their property, no easement whatsoever. None, no easement. And they're planning to do some landscaping here in the easement, but they never did. We'll get to that. So that morning, Mrs. DeVete sees these workers, these landscapers, delivering sod, pallets of sod. And the sod is placed on the street and in the yard in front of the Andersons' property. She does not like it at all. She gets in her car, drives down her driveway, turns right on Haversham, turns right on West Andrews, drives down there, rolls down her window. And Mr. Anderson is working in his basement office. His basement office kind of faces the same way as this part of the garage. He's facing all of this. He can see what's going on. And he can hear the noise. He hears Mrs. DeVete yelling at his workers, telling them, "That's my property. You can't put sod on my property. I'm going to call the police if you don't stop." And Tracy gets up and he's on his way to talk to her, and she storms off. He has to go to a meeting at the office. He comes back around lunchtime. He's up in his dining room. He sees Mrs. DeVete driving in the driveway, because the driveway is about 10 feet from the Anderson property. So he's mad. He's also received a phone call from the landscaping boss. I'm not going to tell you what it said, but he was very mad as a result of that phone call. So he goes out to talk to Mrs. DeVete about this. And he walks out there and take that down. And he says, he starts walking up to her like this. Wants to talk to her. She rolls down her window. She's on the same side. And he says, "You can't yell at my workers like that. Don't yell at my workers." rather than saying, I'm sorry, apologize, explaining, she says, you're a horrible man. You're a horrible man. You've had multiple wives, which is not true. Claire is Tracy's one and only wife, but she calls him a horrible man. You've had multiple wives, and he lost it. He lost his temper. He was mad when he got there, and she added fuel to the fire, and he lost it. He called her a fat bitch. And he regrets it. Well, number one, he's going to admit saying it. He's also going to explain to you that he regrets it. He's apologized. Not his finest moment. All of that stuff. Does not matter. Next. So this is, on my timeline, this is in red. Because this is why we're here. Because of that. Next. 2 days later, Ms. Sturm sends a letter to the Andersons. Next. Next. It's a 3-page letter, and it's a very, clearly it's a cease and desist or else letter. She tells him, go back. The Davids have sole and exclusive use. Unfortunately, you continue to engage in conduct that intentionally and blatantly disregards and tramples upon the Davids' exclusive rights to use and enjoy the easement areas. Next. She says you have trespassed, engaged in unlawful clearing and cutting of trees without an arborist permit, which I think is a crime in the city of Atlanta, I'm not sure, and other vegetation. She says this. She says you've also installed illegal surveillance cameras on your property. He says down here, please be advised that such conduct is not only illegal, but constitutes criminal conduct. Is accusing him of multiple crimes in this letter. Next. She concludes by saying this, if you don't give me everything I have demanded, we are going to sue you. We're going to seek all damages, we're going to seek an injunction, and she finishes by saying this. Next. Including placement of any and all appropriate liens on your property. That's pretty serious letter from a lawyer. Now, bear in mind, all this other stuff we've heard about, the removal of the trees, removal of the vegetation, the surveillance, they've been there for 11 months. We haven't heard one word about any of that. This is all raised for the first time 2 days later, 2 days after what I call the incident. Next. In response, Mr. Anderson, as a lawyer from Alston and Bird, a very, very big, very well-recognized firm here in Atlanta. Mark Rushi writes a letter, brushes back on everything. Tracy thinks it's resolved. Doesn't hear anything for the better part of the rest of the month. Next. Little did he know that the next thing that happens is Ms. Sturm's office prepares what is called a verified petition for stalking temporary protective order. Basically accusing Mr. Anderson of committing the crime of stalking. And Mrs. DeVee verifies this. She signs it. It's a verification. She takes an oath, just like the witnesses who testified in front of you are going to take an oath. She's swearing that everything in here is true and correct. Accusing Mr. Anderson of crimes. Next. But they don't file it for a few weeks. The next thing they do, and we didn't know this at the time, we have since learned it, on March 18th, 2021, Ms. Sturm has a discussion with a fellow named David Shostak. He is an arborist. And what they are talking about is building a claim for damages for the removal of vegetation and trees from the easement. Next. The petition. Keep going. Next, the TPO petition is filed. on April 2nd, and these things, I don't know if y'all know anything about it, but you can get a temporary protective order, 30-day order. It's ex parte, meaning it's just you and the judge. The other side doesn't know about it, doesn't have an opportunity to respond or be heard. So this is issued ex parte by a judge and is served on Mr. Anderson by the Fulton County Sheriff. That's when we get involved. So we have to defend the TPO petition, but we know beyond any shadow of a doubt that a lawsuit is going to be filed between these parties over this relationship. So we filed a lawsuit on April 12th of 2021 because we have a joke around my office. What do you call somebody who threatens a lawsuit? You call them a defendant because we want to go first and last. Now, so we filed this lawsuit against the DeVeeds for three things at the beginning. Number one, we wanted a declaratory judgment as to whether the DeVeeds were right that they have exclusive use to the easement, meaning if this is the easement line, Mr. Anderson steps across it, he can be arrested for criminal trespass, even though he owns the property and pays taxes on it. So we wanted to get the court to rule on that. And that's an issue of law for the court, just like these objections and other things Judge McBurney said. And I don't know exactly how he's going to phrase it, but I'm confident that at the end of this trial, he will tell you as a matter of law that the Andersons have the right to use their easement areas as long as they don't actually interfere with the Davis uses. Next, we wanted a jury to tell us whether the easements had been abandoned or extinguished, because Mr. Anderson will tell you when they moved in 2018, though that easement was a complete hodgepodge. It was a junkyard. There wasn't any beautiful landscaping. It was a dumping ground for yard waste. His prior owners had some railroad cross ties that they used as a walkway. Whenever those would rot, they'd pick them up and throw them into the easement. And also that easement area, which the DeVeeds will tell you is beautiful in nature, we loved walking on it. It was a snake pit. It was filled with copperheads. Mr. Anderson killed 14 copperheads, but now that's a trespass. So we also filed suit over the trespass by the workers. That's not really that big a deal. If none of this had happened, we wouldn't be here about that, I guarantee you. Next. Now, by this time, April, when we filed the lawsuit in April, it didn't appear that the Davids had actually done any uses of the property that we could tell. But starting in August of 2021, after the lawsuit's been pending for a few months, the Davids actually start using the easements. Next. Now, I've got 3 videos here I want to show you. They're just a few seconds each. This first video is the frontage of West Andrews, the easement area, the frontage area. But you can see that there's no path. There's no way for workers to carry their tool belts and heavy equipment to get back there to do construction. It's in the path that somebody uses for their morning runs. It's impassable. Hadn't been used in decades. You see here we have the ribbons showing up. So that's the entire frontage of the easement. That video is taken August 12th, 2021. Next video is literally a few hours later that very day. Here's Mr. DeVee. Decides to install some sports nets on this wet, mushy ground. He sees Mr. Anderson videoing him. He picks up his phone and calls somebody. Who does he call? We do not know. We asked him, he doesn't remember. We put his lawyer on notice to preserve his call log. Disappeared. Don't have it. Next video. No, all right. Black spot. we go. A few hours later,
Here's the net thing they put up.
Mr. Anderson there, Ed.
They're over there cleaning out something. Don't know what, but they're tearing up my property.
Okay. Next slide. So the first time we actually see any uses is during the lawsuit, and all of this happens on August 12th. Over the weekend, this is a before picture, Friday, August 12th, after picture, August 15th. Next. They've cleared the easement and left a nice little thank you here for Mr. Anderson and the city of Atlanta. That's not the only way they've used the easement during this lawsuit. Next. Next. Mr. David has put the lawn chairs out there because he supposedly likes to use easement too for ingress and egress for his runs, and he likes to sit here afterwards and have his morning coffee after running. Put these big sports nets up in this mushy, worthless area.
So you're doing some closing argument here as well? If you want to give a preview to the jurors of what the evidence may show, you can hang adjectives on those potential facts in your closing.
I apologize for them.
It's okay.
The evidence will show that the Davids have installed these nets in the easement area. We'll also show that the Davids have a very nice, well-manicured lawn in their backyard, which some people might think would be a better area for this type of work. We've complained about these nets. They're still there this morning. Next. So after this, we amended the complaint and we added a claim for nuisance because of the intentional actions in putting these nets up there for what we contend is not a legitimate purpose. Next. Next slide. Now, the Davids filed some counterclaims against us. Mainly trespass. And the trespass, as I understand it, I stand to be corrected during the trial if necessary. But as I understand it, the trespass, or one of the trespass claims, relates to throwing trash in the dumpster. Next. Well, somebody in the David household was so upset about the trash in the dumpster that they actually took a picture of the trash in the dumpster. A couple of pictures, and I don't have it on this, but they zoomed in and you can see that this is actually addressed to Tracy Anderson. So we didn't hear anything about this before the lawsuit, but now it's a big issue. Next is they say that Mr. Anderson has removed all sorts of vegetation from their yard. Remember, next slide, before the TPO petition was filed, next, Mr. was having these discussions with this arborist about their damages model. And the arborist prepares a report, next. And he's claiming down here $87,000 in damages to replace the landscaping that has been removed. And of the 87,000, 65,000 of it is to replace this one 10 by 15 bush, 10 by 15, one. He's going to replace it with 2,250 3-gallon plants, potted plants. Next. So it's the ratio for that is 2,250 to 1. That's in Mr. Showtack's report. We don't know if he's going to come in here and tell you, I made a mistake. It should have been 250 or 225. We'll just wait and see. But next. What we do know from his report is he calculated the area of what we're talking about. The area was approximately 1,800 square feet. So he's planning to put 2,250 3-gallon buckets of this stuff. And that doesn't count all the other stuff that he's calculated. 2,250 3-gallon buckets in an 1,800 square foot area. So we'll see. We'll see. Next. Now, we'll see if or how they can continue to use the easement for the sports nets and their walkways that they've cut in, if they put 2,250 of these buckets in here. Next. So when you look at the timeline of key events, the evidence will be, I believe, at the end of this trial, you'll agree, that none of the trash removal, none of the putting that FedEx box in the dumpsters, that's not why we're here. Next. We're here for one reason only. Because Tracy Anderson, after being provoked, lost his temper and used a bad word. He's apologized to it or for it multiple times. He owns it. He's the CEO of a company with 265 employees. He'll tell you he referees fights all the time. He's not proud of this, but that's why we're here. Mrs. David, I doubt if she will accept any responsibility for what happened here. Next. At the end of this trial, we're going to ask you for several things. First, we're going to ask you to extinguish easement 2 for two simple reasons. Number one, factually, it was extinguished because it was formed in 1996. It had not been used in the 24 intervening years. So it was gone. They had nothing to buy. Now you're going to hear, I anticipate, from the prior owner, Mr. or Mrs. Darby, maybe both of them, who may tell you, oh yeah, we loved it, we used it for its peace and beauty and this, that, and the other. But we will prove actual adverse use by using it as a dumping ground. And Micah used to own the Anderson's property. She will testify by Zoom tomorrow. She will tell you that their landscaper used it as a dumping ground, and she never saw the Darbys use it. Now, Miss Darby, Mr. and Ms. Darby, they both tell you, oh, we loved it, we used it. They moved to Florida in 2001, became permanent full-time tax residents of the state of Florida, meaning you have to live there for at least half a year plus a day. So we think that's sufficient to prove abandonment and adverse possession. The other reason is this: we all know if they continue to have rights to this easement, you are not the only jury who's going to have to spend 2 or 3 days of your lives refereeing a fight between the Andersons. Next. Next, we want a jury verdict in our favor on the nuisance claim. And the measure of damages for that is the enlightened conscience of a jury. So whatever y'all think is fair. Next, for compensatory damages for that. And also, we have a claim for bad faith attorney's fees and for putting these nets up in the course of this litigation. We think we will prove that they did so with the specific intent of trying to escalate tensions between the parties as opposed to trying to de-escalate tensions between the parties. So we think that's bad faith in the underlying force of the conduct. And finally, you're going to have a box on your verdict form for punitive damages. It says if they've acted intentionally or with conscious indifference to the consequences of their actions, yes, and we can get punitive damages against them. And on their counterclaims, obviously, want to reject all counterclaims. Or on the off chance that you think putting that cardboard FedEx box and that chimney screen in this big old, whatever it is, 15-foot dumpster, actually did interfere with their use of that dumpster, give them $1. We don't care. But as for the interference, next. There's, because on the Bush's claim, the $65,000 to replace that one bush, you're going to see lots of pictures that the DeVeeds took of the Anderson property and the easement and all this stuff when they got mad. When they thought the Andersons were doing something they shouldn't do. You're gonna see lots of pictures of that. What you're not going to see is a picture of this beautiful 8x10 bush that used to be there and has been removed. Pure speculation, pure speculation. So you're gonna have to, we're gonna ask you to reject that. And the trash and dumpster, I've talked about that. So at the end of the trial, we're gonna ask for a verdict in our favor on all counts and ask for a verdict in our favor on all of their counterclaims. So before I sit down, let me say this. Go ahead next. You know, I'm a lawyer, and I know a lot of people don't like lawyers, but I'm proud to be a lawyer. I take an oath to do what I do. And our job here this week is to help you find the truth and do justice between these parties who can't figure it out for themselves. And y'all got a jury summons and you're here and it's a big inconvenience for you. Some of you have travel plans later in the week. I understand that. We certainly appreciate you being here. My job is not to make your job one bit harder than it needs to be or take one bit longer than it needs to be. And if I do, I want you to hold it against the Andersons because I'm their lawyer. I represent them and I speak for them. So if I do something wrong, hold it against, if I intentionally do something wrong, hold it against them. And my friends here on the other side, they're lawyers just like I am. They take the same oath that I take. They have the same duties and responsibilities to you that I have. And I'm sure they will agree with me that if they waste your time, if they make your job harder, if they try to make up a claim out of whole cloth, you should hold it against them.
Yeah, I hate to object to someone's opening statement, but this is a closing argument.
Well, I think he's closing, so
I'm
we
done.
don't have to do any more closing in his opening.
I'm done, Your Honor, so
All right,
thank y'all.
we will pivot to counsel for the Davids.
Yeah.
Sir.
Thank you, Judge. Good morning. I'm Casey Sturm. Along with my colleague Jeff Schneider, we represent Jean-Noel and Stacy David. I do not disagree at all that all of us probably sitting here believe that neighbors should be able to work things out. That you should be able to knock on that door, on your neighbor's door, and say, "Hi, I'm your new neighbor." That's not what happened, and that's why we're here. Let's also be real clear, just like we tell our kids. We know there are always two sides to every story. And I'm going to talk to you about what really happened here. Okay? And that's on March 27th, 2020, my clients, they bought their dream home. Okay? We all can envision what that may be like. We're going to take that next step, right? We're about to open that new chapter in our life. We're full of hope. We're full of excitement, right? They've got two young teenage kids at the time, and they're ready, right? We're going to make this place our home. We are excited. At this time, they don't know the Andersons. They don't know their next door neighbors. They've never met them before. They're excited though. They could have never have fathomed what was about to take place. Okay. This is not your normal, oh my goodness, what have I walked into with my next door neighbor? Okay, you could never fathom what was about to happen. It started almost immediately after they moved in. And yes, they bought the house, they had plans to renovate it. They started renovation shortly after they moved in. What happened though is not the picture Mr. Anderson wants you to see. What happened is there was a pattern of abuse, of aggression, of willful disregard for their new neighbors. They haven't even said hello to. Their new neighbors who have just moved in. You heard Mr. Anderson, Mr. Edwards admit his client yelled at Mrs. David. He called her a fat bitch. He also said, "You're going to die." Mrs. David's husband travels internationally. He's gone almost every day of the week, Monday to Friday. You think about how those kind of comments would make you feel if you just moved into a house. Can hear me. They make me feel like that. How does that make you feel when you just move in? You are scared. What am I living next to? How do I handle this? Do I need somebody to protect me? So since shortly after they moved in, what we will show you is that there is a pattern of this aggression, of this abuse, of this harassment. Let's make no mistake about it. They're going to admit several things. They admitted they cleared easement 2. They will admit that they attempted to fence it off completely so that the Davids could not access it. They yelled rude comments. I'll tell you more about that because Mr. Edwards said, "Oh, Mr. Anderson regretted it." You didn't hear him say, "Hey, he went back over to the neighbor's door and knocked on it and said, 'Hey, I'm real sorry about that. Can we start over?'" Didn't hear that, and you won't hear that. Didn't happen. This harassing continued from the day they purchased to today. It's ongoing. That's why we're here. So as you can see, this dream home has for them become a living nightmare. This is their day to day. What is this man going to say? What is he going to do next? Let's talk about a few things. This case, it involves easement rights. These are property issues. The judge is going to talk to you about the law on that. Easements generally, layman's terms, the right to use somebody else's property. The facts surrounding the grant of these easements, they're not in dispute. Easements were created by prior property owners in 1996. You're going to see the easement agreement. It's going to say it's a perpetual easement over and across what is now the Anderson property, 2 separate areas, easement 1, easement 2. Right? You're going to hear, you heard from Mr. Edwards. The Andersons bought their property from Ann Nykirk. Ann Nykirk's a real estate agent in Atlanta. She sold the property to the Andersons. Their deed says your property is subject to the same easement agreement. Certainly, if this easement agreement had been extinguished or easement 2 no longer was in existence, certainly Ann Nykirk, a real estate agent, a prominent one in the Atlanta area, wouldn't have put into the deed that this property is subject to these 2 easements. The closing attorneys, same closing firm for both sides. Andersons buy their property in September of 2018. A year and a half later, the Davids buy their property, March 27, 2020. Same closing firm. Their deed also mentions your property is subject to the same easement agreements, giving you rights to the use of 2 easements on what is the Anderson property. You're here that not only did they have the same closing firm, but the understanding that was provided to the Davids when they asked about the easements was, you have the sole and exclusive use.
Object, she's getting to legal arguments. She's giving legal advice as to what closing attorneys may have said, that's improper.
I'm not here, this was one of the issues we talked about before as to what the understanding of the clients were when they purchased the property.
Okay, just make sure it's not coming from the mouth of the closing attorney.
Sure. So the understanding of the Davids when they purchased sole and exclusive use of these easement areas. What does the easement agreement say? You're going to see it. It's tiny, so hopefully we'll be able to also show you it blown up in size. 2 easement area. This easement agreement is recorded. That means it's in the Fulton County property records. If you look it up, you're going to see hey, here's reference to this easement agreement, and then you can go find the recorded and filed easement agreement. Easement 1, it consists of a brick parking pad. It's part of the natural drive parking turnaround area for the Dobbies. It's built in the same characteristic and style as their home. They use it to park. Okay, it's surrounded by a brick wall. It specifically says in the agreement, and again, you can read it, the Andersons are not to interfere with the use of that by the Dobbies. Easement 2, language in the easement agreement. Sole, and it says, for any legal purpose, you can use this area for any legal purpose whatsoever in the easement agreement. Both sides have, both sides got. Both sides knew about. Those are the rules under which we're operating. Those are the rules under which these parties come to this property. Despite those explicit rules in the agreement, and both, I should say, both easements also say, easement 2 in the agreement says the same thing. Andersons, you have no right to interfere with the Dobbies' use of easement 2. And despite that, that is what has continued to happen throughout this case. Since the day the Dobbies purchased their property. I want to take a moment because what you heard Mr. Edwards say is they want to distract you really from all their conduct and activity. They want to say, hey, look, this was extinguished. Don't be fooled. The judge will give you the law, but don't be fooled on what they're saying. Again, they bought this property subject to this easement agreement. It was sold to them from a real estate agent prominent in this area with the full understanding that that easement agreement was there. There is no evidence that they can offer that anybody has modified this agreement or anybody has rescinded it. Has not happened. Evidence will also show that my clients, before they purchased their property, they walked through easement 2. I know, crazy, right? That wooded area that has ivy in it. They hiked right through it. Went through the woods up to the back of their property. You'll hear other people have done it too. There is no extinguishment here. Even if they did use it to throw refuse in, it doesn't defeat the purpose of it. It says you can use it for any legal purpose. You will hear from the Dobbies that for them, it was one of the selling points. One, we've all heard Atlanta, it's the city in the forest, right? They really liked the fact that it was wooded. It gave their backyard this sense of real privacy and shielding. They also liked another feature of it. The fact that you could get to West Andrews. Haversham is a busy road. They have young kids. This concept that you can park on West Andrews, you can go up through the woods and you can get to the house. You've got options. They like that. That was attractive to them in the purchase. And so don't be fooled about this concept, oh, it was extinguished and so we had every right. They bought it knowing full well there was an easement agreement on it. Also want you to pay attention to the fact that, you hear me say, Andersons bought in September 2018. The Dobbies purchased their property a year and a half later. The Andersons made no use of easement 2 until after the Dobbies moved in. Let's talk about a few things that came up. The Dobbies were renovating. They had workers. They had workers that parked on West Andrews. West Andrews is a public street. You can park on West Andrews. They had workers who knew you could go up through the woods to our house. We all understand how construction can go. It's annoying, sure. And it's annoying when a neighbor does it and we live through it and we try to work through it. And the thing to do is knock on the door. right? You got a problem, knock on the door. So I didn't hear about these workers. The storyline that's been passed for you is not the same. The trash. Yeah, they threw trash in their dumpster. Anybody that's done a construction project knows you pay by what goes in there and you pay for the new dumpsters. Was the trash really a big deal? No. They would have liked for the Andersons to have asked, hey, are you cool with us throwing, these are kind of big things, can we throw them in your dumpster? You got it next door? Yeah, sure, probably would have been fine. What happened, Mr. David went next door and knocked on the door to try to, he thought, this would be a good chance to maybe go and introduce him, say, hey, found your trash in my dumpster, I'm your neighbor type of thing. You'll hear from Mr. David, that did not go well. That did not go well. His neighbor did not want to talk about that. Shortly after the Davids moved in, shortly after these incidents, these supposed incidents that the Andersons talk about with the workers, the Andersons decide they're going to clear easement to a portion of it. They don't contact the Davids. They don't notify the Davids. They just go in and clear it. The Davids are upset by that. I mean, they purchased it. One of the features that they liked was this wooded area. No notice, no contact. They didn't just do that. They put up a fence. You can put up a fence. You can fence your property line, right? They didn't just put up a fence on their property line. The intent was to run it all the way down, not just their property line, but the easement too, so that it would block via a fence any access the Davids would have to easement too. You heard Mr. Edwards say this all started in February of 2021 when there was the yelling, Mr. Anderson yelling at Mrs. David. And I'm going to show you their landscape plan from August of 2020. The Andersons' landscape plan for their property shows them using all of easement 2. It shows them extending a fence down all of their property to block easement 2. It shows them putting a fence along the easement area and West Andrews, so that you're really fencing off this whole easement area that they knew and the Davids know the Davids have the right to use. So this didn't start in 2021 with the yelling incident. This was an intentional design and pattern by the Andersons. And they may have been angry. They may have been angry that there were workers. They may have been angry that there was construction. But this type of action is not justified for such anger.
I'm sorry, justified for, I'm sorry.
Such anger.
Thank you.
The Andersons, there was some mention of sod. Davids have no problem with the Andersons sodding their property. Again, look at the landscape plan we're going to show you. 2020. It clearly shows that the intent was to sod easement 2 as well. They admit they sodded the area. They admit they put in an irrigation system. Oh, it just so happened that one of the irrigation head sprinklers is on the easement. That's what they're going to tell you. It just so happened, but it's a plan. They have a landscape plan. It says we're going to do this. They put lighting in trees in the easement area. This all happens. This all happens before there's any legal action. This all happens, and then Mr. Anderson yells, "You fat bitch, you're gonna die," at Mrs. David. But again, he said, Mr. Edwards says he regrets it. He's sorry. You did not hear anyone knocking on a door. You did not hear any apology. But it's not the first time Mr. Anderson has made remarks. They want to try to claim, hey, look, I lost my cool. It happens. It's not the first time. It continued. After this lawsuit was filed and you saw the videos, you will see that the Andersons have taken it upon themselves to film the Davids when they're out on the easement area. You're going to see Mr. Anderson filming the Davids' teenage son. You're going to hear from the son in that video. I don't like it, I'm 13. Please don't do that. It's weird. Who does that? Who films a kid out on an easement? He's got a little cross strike and a lacrosse ball. You're going to see him film Mr. David. You're going to hear from Mrs. David. And again, keep in mind, her husband travels for work. So he is gone Monday to Friday most of the time. You're going to hear from Mrs. David that on 2 occasions, Mr. Anderson yelled racial slurs at the Davids in front of their son. He called them Algerian niggers. Who says that? Who says that? This is not a man that yelled at a lady one time, calling her a fat bitch. This is a repeated conduct and disclosure. Does not like his neighbors, and he wants them to understand that they are not welcome near his property. He does not want them to use easement 2. You will also hear that at one point, Mr. Anderson, he owns a shotgun. You will hear that he took that out of his car, supposedly carried it to his garage. You will hear that that was done in front of one of the David's children. Again, these folks are already on edge. Their new neighbors are not at all what they had envisioned when they purchased that home to be. This is not the neighborly situation they were hoping to walk into. And what we will show to you through this pattern of activity and conduct that has happened is that this is intentional. It is designed to prevent them from accessing and using these easement areas. It is designed to interfere with the rights that they acquired under that easement agreement. It says you can use easement 2 for any legal purpose. That can be for woods, that can be for walking, that could be for playing ball. Regardless of how they want to characterize the area, the Davids have the right to use it for any legal purpose. And there is a pattern to what is going on here with the conduct of the Andersons. Make no mistake about it. Nobody yells those kind of things at their neighbors. Nobody behaves in that kind of way. What we hope is for that knock on the door. That is not what Mr. Anderson has done here. And then they sued us. They sued us. You heard Mr. Edwards. Yeah, we got your letter. We decided to sue you, right? You heard him. We don't want to be the defendant. We want to be the plaintiff. And so we're going to sue you. So here we are with all of you all, hoping that you can help us put an end to this living nightmare. Yes, we hired someone to assess value of a cleared area. Mr. Shostak. You'll hear that he did what anybody would do when at the time you don't have information about what was actually cleared. Okay? If you have information, you use the information. If you don't have information, is there stuff on the ground? If you don't have stuff on the ground, is there another way to do it? And so he'll tell you why he did the appraisal analysis he did and why he came up with the analysis he did. The reality here is that the focus is on this blatant and constant barrage against the Davids that has interfered with any right to use easement 2. We are blocking you from this. We want to end this nightmare. We need you all to help us. You heard Mr. Anderson, Mr. Edwards talk about some property stakes, survey markers. It's pretty common when you have property and you want to know where the boundaries are. You have somebody flag it, stake it, and put up markers. What you'll hear is that Mr. Anderson took those down. Again, we've got young kids. So the fact that somebody went out there and take back up, that is to be certain, right? That is to be clear. You are on the easement and you are not on the Anderson property, right? There's nothing untoward about that. The purpose of those stakes and those markers is to make sure everybody knows this is easement, this is Anderson property. Don't go on Anderson property, you can be on easement 2. But apparently, that's unsightly. And so the Andersons pull it down multiple times and the parties attempt to put it back so that everybody can be real clear. I will close with this. Again, my clients didn't bring this lawsuit. The Anderson product, the conduct, the pattern of conduct, the reprehensible yelling, name calling, what have you. It's not neighborly. It's not kind. It's not a way any neighbor should act regardless of whether you lose your cool. The Davids need your assistance in making this stop. And after you've heard all the evidence in this case, and the judge explains the law to you, we are going to be asking you to return a verdict in favor of the Davids. We appreciate your time and attention this morning and throughout this case, and for your service. Thank you.
Thank you, Ms. Sturm. Ladies and gentlemen, before I ask Mr. Edwards to call the first witness on behalf of the Andersons, I'm going to give you the morning break. We've been focused on the openings, and I want to make sure you're refreshed. We'll go. Our lunch break is going to be just a little bit before 12:30. It will be an hour. Lunch will always be at least an hour. I have a meeting back in my chambers at 12:30, so we're going to need the break a little before 12:30. Take that hour lunch, and then
May we approach?
She wants to do her brief opening.
Oh, you don't even need to approach.
Okay.
There's a funny third. It's not funny as in funny, haha. There's a necessary third piece to the openings because Ms. Medwick has a specific role on the team with the Andersons. She is handling the defense of the counterclaims. I mentioned to you all that even though the Andersons are listed as plaintiffs, it's Andersons versus Davids. I didn't mean to leave you out of this. The Davids brought counterclaims. They are the plaintiffs, if you will. They have the burden of proof, preponderance of the evidence as to the counterclaims. And the way that the Andersons team has divided this up is Mr. Edwards is focused on, if you will, prosecuting, proving up the Andersons' claims. And Ms. Medwick is much more defending against the Davids' counterclaims. And so it is appropriate for her to speak as well. Don't apologize. I forgot the way we're going to flow. So you may we may every once in a while have a witness where both Mr. Edwards and Ms. Medwick ask questions of that witness, even though, wait a minute, the lawyers are all right there. It will only be one lawyer from the David's side who gives an opening or handles a witness, but the Andersons have this kind of dual role because the counterclaims were brought. And so I didn't mean to shortchange you at all. You'll still get your morning break, but we are going to hear from Ms. Medwick. She said it's super brief. Let's hold her to that.
Yes.
Her opening statement about the David's counterclaims. Ms. Medwick, if you would, please.
Thank you. I'm sorry to interrupt you, Ron.
No.
Good morning, and I am going to be very brief. What I cannot impress upon enough is what you're going to be asked to decide in this case concerns easement 2. You're not going to be asked to decide if these neighbors should like each other, if they should like each other. You know, you're not going to be asked to decide that. You're not going to be asked to help them like each other. That's not what this case is about. And when it comes to the counterclaims that the Davids brought, it's about easement 2 and whether or not anything that the Andersons did interfered with their reasonable use of it. So I want you to look out for evidence that talks about what was easement 2 like? What was easement 2 like when the Andersons bought it? You're gonna hear evidence. Weeds, poison ivy. If you don't know what railroad ties are, they're wood. So I did have to look that up at one point in time, so I'll admit that. And that it was rotten, thrown back there, trash, plastic bottles, venomous snakes. You'll hear evidence that it was like that for a long time. And so that's why they cleaned it up. Did cleaning that up interfere with the David's use? You can decide for yourself about that. Pay attention to evidence about who didn't use easement 2. When people did start using easement 2, and by people, I do mean the Davids, when they started using easement 2, when did they start using it? How did they start using it? How often did they start using it? And clearly there's one very uncomfortable interaction that has been admitted by the Andersons that was addressed to you. Other interactions are disputed as to if they ever took place, what, if anything, was ever said. So that'll be something for you to decide. But look at the timeline, look at the evidence. If there was continued use after uncomfortable conversations, decide for yourself. Was that an interference? It didn't stop somebody from using it. Did it interfere? So look out for evidence about that, because it's not about I didn't like something, I don't like you. It's about interference. So when it comes to the counterclaim, that's really what it's about. It's about interference. It's not about liking, disliking somebody. Certainly everybody's entitled to their feelings, but we need to stay focused on what this trial is actually about, what the evidence really says, and that'll help you make your decision. And one of the most important things that you have with you as you're listening to the evidence, as you're making your decisions, is your common sense. You answered a lot of questions yesterday. You're here. Thank you. You all have common sense. It's a really wonderful guide. So let it help you determine everything, determine the evidence you believe, apply the law when Judge McBurney gives it to you. And, you know, this decision is going to be your collective decision. We really do appreciate your time today. So I know you want that morning break. So I'm going to stop talking. Thank you so much.
Thank you, Ms. Medwick, and I apologize again for
I'm
making any
sorry.
decision that could be deemed as not acknowledging your right to address the group as well. I appreciate it.
Thank you.
So now we are going to take our morning break. This is your first break since the trial has started. You haven't heard any evidence yet, so there's really not a whole lot to talk about back there about the case, but you shouldn't do that anyway. Don't talk about the case. No outside research. If you didn't know what a railroad tie is now, Ms. Medwick has told you what she thinks one is. Still not evidence, but don't research anything. Enjoy as best you can the space back there. If you are low on any supplies back there, let us know and we will do our best to restock. You are free to bring water back out here. Don't bring any beverages that if spilled would mess up the carpet, but water, is there water back there for them? There is. That water's for you. It's not my normal jury space, so I don't know what supplies we brought over, but
Now it's brought water.
okay, so that bottle of water is for you. It may not say jurors on it, but it's for you. I'm gonna try to get you back out here probably in a little less than 10 minutes, but if Deputy Gordon heads back there and you're not ready yet, you just tell him we're not ready. It's your clock, not ours. But we'll try to get you back here by around 11:10, okay? Thank you.
All right, the jurors.
Yeah.
We'll be sitting in the same seat.
Get a picture of that. I know, it's gonna have you close it up like that. Stays yet. No. Have we given them ours?
Yes. Okay.
Mr. Edwards, anything we need to discuss before we take the morning break?
No, just logistically, you had asked for multiple notebooks of the exhibits to use, and there's some exhibits that I want to show the witnesses, but not necessarily show the jury or offer into evidence. How do we handle it?
It's helpful if I have what you're showing the jury, just in case you show it, because you'd need to, I'm sorry, what you're showing the witness, because you'd need to show that to defense counsel first. And if all of a sudden Ms. Sturm says, this is crazy, it's helpful for me to have it as well.
It's either gonna be in the notebook, or if it's not in the notebook,
Great,
I have.
that works.
copies. So should I put the note, a copy of the notebook up there for the witness and for you?
Yes, please. And when you say notebook, this would be exhibits just for that witness, or it's all your exhibits and you'd be telling the witness, hey, turn to tab 6.
Yes.
I'm fine with that, as long as you all don't have an objection. It's more efficient that way. Okay, great. So over the break, you can do that. Anything from defense before we take our morning break?
No.
Okay,
Thank you.
I'll see you all. I'll be back out here in about 6-7 minutes.
Okay.
Thanks. Yes, sir. Good for you to stand up for a second.
Young minister.
Yeah.
Some of them now she's gonna be. Zoom.
One only, and when we do that, we may have you relocate that, and it won't be till
Yeah,
tomorrow.
okay.
So witnesses today, all the witnesses except one are gonna be in person, so they'll be right there.
Okay, that's.
I may have Deputy Gordon adjust that monitor a little bit, because once we have witnesses testify, I switch the Zoom so it's focused just on the witness.
Okay.
Thank you.
That's good.
So,
So the one tomorrow.
yeah, so it'll be sometime tomorrow afternoon, because we don't start till 1:30 tomorrow. When do we need to break today?
Say one, you know, I think it's 1:46, but if we do 1:45 again, I think it's still. Let me just check. Looking at it this morning. Yeah, okay, yeah, actually, yeah, 2 minutes, 1:47, so we break at 1:45.
1:45?
Yeah.
Okay. And then, any other break today? When is
If
the
we
next
go
one?
past 5,
We'll end 5-ish.
That's fine.
But I can't, I have a call at 5:15, so the latest we could go would be like 5:05.
that's great.
That won't be an
Yeah,
issue.
that's
Okay,
perfect.
great. So 1:45 today.
Thank you.
Okay.
I'll just still, if I can just still make that last prayer before they close the courtroom, I'd appreciate that.
Well, we can leave the courtroom open for you.
Okay.
I'll just need to head over to my office right at 5:05, because I gotta hop on
Thank
something.
you. Okay, all right, that's.
Got to sort this. I've got to sort this.
What did he say now?
No, I couldn't, no. Yes. It's actually. What are you talking about?
I don't know. Just the.
Downstairs. What's your notes?
No, they were just up there.
Access to that.
Oh, well, actually, they are the.
Yeah, those aren't mine.
Yeah, Scott.
Oh, that's yours. There. Oh, my notes, yeah. So, all on behalf of Andy.
I've got to figure out this PowerPoint or this, share thing.
Well, that's why those other boardrooms that you can just like plug into the podium are so awesome.
Well, okay, so what I could do is this. See, I have all mine right there. Oh, that works.
What
So-
did you do?
So I hit the share button
See, I had to open them.
and then I
Yeah.
opened all of my,
Right. I think that's what I had to do because then you can go,
right.
and then you can do.
Yeah.
I think that's what we ended up doing.
I'm panicking less. I swear to God, I am gonna, if I ever get fabulously wealthy, I'm buying Zoom and I'm putting it out of business so that I never have to do it again.
So,
I wonder if we can just, you know, it might make it easier to. Is I'm on this one, right? We both are.
Mm-hmm.
But we don't really need. You know, like you don't really need the second one,
Okay.
which may make it easier to get to. I guess it does. I don't know if it matters.
My eyes look less swollen on that one.
It just seems like there should be a simpler way to do it. Like, but it's almost like, because you can't go like to the document location. You have to open it.
What were we doing on these videos? This one, I can't, tell me how you've got to be more like in depth than I
I
do.
asked if I care about the comments on YouTube. No, but tell them anyway. That'll be the good ones.
Now how to. I'm just trying to watch it because then we're gonna agree or disagree on whether to the authenticity of these.
Mm-hmm.
really bad, that's all it
So how are you showing the witness these documents?
So I think what you have to do is this is why I think there's paper. So at the last trial, one of the big issues was remembering. So that was Elmo,
Yeah,
but remembering to give it to the witness beforehand, before you put it down. So I think the key here is you're going to give them the paper
yeah,
and do all of that.
That was my
And
thought.
then you
Right.
publish to the jury.
got it. So what I would do is if I were using defense exhibit number 3, I'd have the folder, I'd have hand her, do you identify this? I'd hand out everybody a hard copy, authenticate it, and publish it. It depends. I mean, Vanessa does a number of different.
She has got to. I mean, it's like, it's just untenable.
Yeah. Hmm? Yeah. Yeah, I've tried a bunch of cases where she's been mine.
Yeah.
And that's why I reduced doing it greatly to myself. Who does that?
You're sorry.
What's that?
Yeah.
Here's the no name thing. Then when I pull it up, it just brings up my exhibits.
Absolutely. Very nice.
You guys don't listen to what Deputy Gordon says. Repeat what you said, Deputy Gordon. There you go. Logan is the only one who listens.
Judge,
Sir.
as I recall from yesterday, you told defense counsel that they should approach before we raise this issue of the Algerian N-word, the verbal harassment. Ms. Sturm obviously did not do that. I just want to let everybody know, in my opinion, and you can correct me if I'm wrong, obviously.
Okay.
She's opened the door to the timing of when this claim was first raised. I have the very first email from Ms. Sturm where this issue was raised, which was November 9th, 2023, which is 2 days after the Supreme Court denied cert. So I intend to go into that with Ms. Rangers.
Okay, so two things. One, I don't recall saying that we needed to discuss again anything about any defense evidence that one of your clients said something racially insensitive. We talked about it, and my ruling was if it's coming in not as hearsay, obviously it's a statement alleged to have been made by Mr. Anderson. That part's not hearsay, but it's not Mr. David saying, my son told me that Mr. Anderson said that, then it can come in if that's where the defense wants to go. So I don't believe that Ms. Sturm crossed a line that I drew, but I understand what you want to do. And I guess you're where you'll need to be a little careful is getting into lawyer communications and what the significance of the Supreme Court's ruling was.
Just something to the effect of when's the first time you heard it? Does this refresh your recollection?
Yep.
Yes. Is there anything significant that happened in this case around that time? Yes, the Supreme Court ruled in our favor.
Okay. I mean, as long as I don't have an issue with that. I'll hear from defense counsel in just a moment, but I appreciate you managing it that way as opposed to diving into, well, they ruled in your favor on what? What did this? Actually, the Supreme Court just said we deny cert.
Well, that's,
That would then, but there's nothing wrong with you characterizing it that way. And that kind of shorthand is helpful because what I want to avoid is the lawyers diving into, well, here's what the Court of Appeals said or didn't say. And that's really not a jury matter. But the significance of that to what people or the connection of the procedural timeline with what's going on substantively, I think is fair game for you to explore.
Thank you.
Ms. Sturm, any issue if Mr. Edwards handles it the way more or less he described?
If it gets handled that way, that's fine. My big concern again is the kind of cherry picking of council communications. And I guess we'll just have to pay close attention.
Sure, and I don't know that there's an objection to Mr. Edwards picking exhibit X, because then you'd be able to say, look at exhibit Y, Z, A, B, and C. If you think that that paints a more complete picture in terms of refreshing recollection. I didn't hear Mr. Edwards say, and I'm putting any of these up. These are all, let me refresh your recollection, or I'd like you to refer to witnesses can look at things. If he's going to want to tender it, that's a different discussion. And I didn't hear him say he was going to tender it.
Correct.
That we would need to be much more careful about. Okay.
And that's fine. I guess my concern a little bit is around this concept that, you know, there's some kind of settlement discussion happening and they're claiming that that's the first time they heard it. But I will just pay close attention to what's going on.
Okay. Got it.
And Judge, by all means, if she has another email, settlement discussion or otherwise, before November 9th, where she used that, accused Mr. Anderson of using that language, by all means, offer it. I mean, actually offer it. I'm glad to have the jury see it
Okay.
because it doesn't exist.
Okay. All right. Let's bring the juror. Was there anything, Ms. Sturm, from the defense side? Okay. Anything from the counterclaim defense side?
No, Your Honor.
No. Okay. Let's bring the jurors in, please.
All right, the jurors.
Thank you, Deputy Gordon. Welcome back, ladies and gentlemen. I'm gonna give you kind of a D plus on picking different seats when you come back here. Do well in the back, you shuffled around a little bit. Front row. Maybe after lunch, you'll mix it up a little bit. But you haven't actually had any witnesses testify. We're about to do that, and I'll make sure we adjust the monitor once the witness gets up there. You're moving that back?
He asked me to move back.
Who? Okay.
So that I can see my witness when I'm
That's
standing.
probably a good idea, to be able to see the witness. If you all can't see the witness, you're free to be in a different space in the courtroom.
Yeah.
Trying to think of other, maybe if we slid the monitor this way some, you'd have a better shot at seeing the witness. What if it comes this way? I don't want to block Mr. Williams. He needs to, I didn't mean angle it. I meant literally just slide it sideways. Because and you need to swing it back around because Mr. Williams can still see the witness there. Is that better or worse? Can't be worse.
The angling was good, but I get why you might not like that. So,
Well, if we angle it,
yeah.
then jurors over here will have a little trouble seeing it. So maybe if you go all the way to the end of defense counsel table, you'll be able to see that. Okay, let's give it a try. We can adjust it during the lunch break. We're ready for the Anderson's first witness.
We call Claire Anderson.
Ms. Anderson, come on up, please.
What you say? Can you raise your right hand? I just want to affirm that testimony will be the truth, the whole truth, and the truth of the God. Fill in your seat.
All right.
Can you state and spell your name for the record?
Yep, but first, let's make sure that the microphone is near you and that it's on. You can bend it right around. I don't see a little light on it. Does it have a light? It's working. Great. Okay. So if you would state your name and spell your name for the record, please.
Okay, Claire Anderson, CLAIREANDERSON.
Edwards.
All right, Claire, I know we kind of talked about the order of how I was going to do this, but I want to change it based on this term's opening.
Okay.
I'm going to talk about the elephant in the room, so to speak. The Algerian N-word. Is that a word or phrase that your husband would ever use?
Absolutely not.
Why not? Well, let me ask you this. Is he a racist?
Absolutely not.
Everybody denies being a racist. What can you point to support that?
Well, I was thinking about that when I heard that. Our daughter is a teacher, and this is an example. Our daughter is a teacher, and she taught at KIP Academy. It's by the airport, and it's a charter school, but very, very poor students are there. And she came home soon after she had started and was talking about a family. They had 11 children, 2 she had taught. And
Objection, Your Honor. Are we getting into hearsay on what the daughter?
Right, this is getting a little far afield.
It's leading to what she and her husband did. It explains their conduct and rebuts this totally.
Okay, you don't comment, you.
And it rebuts this allegation.
Okay.
and she was real worried because the mother was in jail, and she came home and was real upset about it. And Tracy, we were just talking about what we could do. Well, we took these children in. Tracy, it was his idea, bring them home, feed them, give them a good place, to sleep, take them back to school. And just to prove our relationship with them, my daughter, the teacher, just got married. They were in the wedding. It was Tracy's idea to take care of them, and, it's something that none of us will forget. So that kind of shows that he is not a racist at all.
Thank you. Now, let's kind of circle back to where I originally planned
Okay.
to start. Tell us a little bit about yourself, just a minute. Where are you from? What do you do?
I'm from here. I'm from Atlanta, have 3 kids, all have graduated from college. And since then, I've really just spent my time, with them, and painting, taking classes, and really selling my art, which I love. So it's a good distraction from not having any children at home.
And when did you and Tracy get married?
Right, 97, God, 97.
Okay. And y'all live where?
Andrews, West Andrews.
When's the first time y'all looked at buying the property that you currently live in?
Right when we were married, it was for sale, and we rode by, and we loved it. We looked at it, and then we just decided we were going to rent right when we first got married, so we didn't buy anything. Then when we were ready to buy, I saw that it was on the market again, and we just were excited and remembered how much we liked it.
You toured the house on both occasions, in
Yes.
97 and 18?
Yes.
Did you ever look at easement 2 on either occasion?
No.
Was it a big deal to you one way or the other?
No.
Did it appear to you, based on what you actually saw, that it had been used by the next door neighbors for any period of time?
No.
Okay. So you bought the house in 18, the David's bought in March of 20, right? Do you recall any, hey, we're your new neighbors, anything like that?
No.
What happened after well, let's strike that. In the year and a half between when y'all bought and the Davids bought, did y'all do anything to easement two?
No.
No? They bought their house. What happened next?
Well, you know, when, like we've talked about, when you buy a new house, you make improvements. So we started with the yard. We had noticed that area, easement two, was just a mess. I mean, all I remember thinking is there was just a huge pile. And it had debris and leaves and, you know, so Tracy said that he wanted to just clean it out, just make it look nicer. But that's all we did, was just clean it out. Got rid of the railroad ties, got rid of the bottles, I remember there were plastic water bottles. So just, that was our discussion. For safety's sake, the light, we did put lighting in over that easement, but we also put it on the other end of our property. So we just did all that at once.
Landscape lighting, is that what it is?
Yes, landscape lighting.
Did y'all put the David's property under surveillance?
No.
After the Davids bought the property, what was your first interaction with either I keep saying Davids, Davids? What was your first interaction either with them or people coming and going to their property?
I just remember when they were moving in and there would be all the cars parked in front of our house and people would be just walking in our yard, cutting through, but not down by the easement, just up on our grass, by our garage.
On both sides of the garage or the far side?
Far side.
The far side of the garage?
Mm-hmm.
But the east.
Just a yes or no.
Oh, okay, okay,
Yeah, thank you. I should have told you.
okay.
Saw them coming and going on the far side of the garage, but the easement's on the far side of the garage, right?
Correct.
Did they go all the way down to the easement area and go way down through the easement and then up to David's backyard, or did they cross over your yard?
They crossed over our yard. They did not go by the easement at all.
Do you remember what the street frontage of the easement looked like at that time?
Just overgrown?
Was there any path where workers could get in and out?
No.
So with your own two eyes, you saw people using your own property?
Yes.
And did you personally ever attempt to complain to the Davids about that?
No.
Okay. Did the Davids ever come and knock on your door and say, hey, we're having construction. If it's a problem, let us know?
No.
There's an incident with the trash. Do you know anything about that on your personal knowledge?
Yes.
Tell us what you know.
That we could not get to our garbage
Why not?
because of the cars
Why? Because-
blocking our garbage cans. And personally, I just remember one piece of trash that we had, and my son-in-law at the time was at our house, and he's 6'9", and he could reach over. Like normally, I couldn't have reached over into the trash bin. And we asked him to put a table in the David's trash bin.
Okay. So it took somebody 6'9" to do it. It's not something
Yes.
that even Tracy or I could do.
Right.
Okay. And did you ever have any discussions with either of the Davids about putting trash in their dumpster?
No.
Do you know where the dumpster was at that time? And by that, I mean, was it on easement 1 in the parking pad, or was it somewhere else, or do you know?
I think it was on easement 1, if not further down the driveway, but I can't swear to it.
Okay. Did you ever personally have any interactions with either Mr. or Mrs. David before this lawsuit was filed?
Only Mr.
Tell us about that.
He came to our house one night and he asked knocked on the door and asked for Tracy. Tracy was out of town and he said, okay. So he kind of turned and then he said, oh, you can't have anybody live over your garage. And I just went, I mean, I kind of was dumbfounded. I just, okay. And I shut the door. I thought, I don't even know how to respond to that.
Did he try to give any explanation?
No,
Did he knock on the door again and say, you don't understand?
no,
Were y'all having work done above the garage at that time?
not really. We just cleaned it out. I mean, it's studded for, plumbing and all that, but nothing has been done. We had just cleaned trash out of there. That's all.
Okay. And he didn't like you doing that?
I guess not. I understand.
Did you get a lawyer letter from somebody saying, hey, you don't have a right to do this? Knock it off? Okay. What about the trash? Did you get a lawyer letter about the trash saying, hey, knock this off?
No,
Stop. But you got a lawyer letter in February of 21, February 26th. It's written, I think it was delivered on the 27th. Does that sound about right?
I don't know what you're talking about.
Okay, I'll move on.
Okay.
Were you present at the house the morning where the incident occurred with the landscaping and the sod and Mrs. David?
Yes.
Tell me what you saw first.
Okay. I didn't see anything going on when I was inside the house. I came down, was going to the garage to get in my car, and one of the workers came up to me and he looked horrified. His eyes were he did not speak English very well, but he said, we can't plant. She said, we can't plant. And I was like, what? Well, by that time, she was gone. Stacy was gone. But then I didn't do anything else. I was just going to call Tracy, and then he had talked to Jose,
Okay.
head of the landscapers, and he took care of it.
And then a little while later, there was this interaction between Tracy and Mrs. David.
Yes.
Were you present for that?
No.
You didn't see it or hear it?
No.
Okay. Let me ask you this. I mean, you heard my opening that she said that he had multiple marriages. How many wives has Tracy had?
One.
So he's had one successful marriage?
Yeah.
Okay. You mentioned earlier that he was out of town when Mr. David came and knocked on the door. Tracy traveled a lot?
He used to. He used to travel a lot more than he does now.
So back in this 2021 timeframe, how much was he traveling?
Almost every week.
Okay. Other than this one incident, to your knowledge, has Tracy had any interactions with Mrs. David?
Not that I know of.
And before the TPO was served by the sheriff, did anybody come knock on the door and say, hey, we need to talk about this? Can we just agree to keep our distance?
No, I wish.
Have you ever intentionally interfered with the David's rights to use easement 2, you personally?
No.
What do you want to come out of this lawsuit?
I just want what's fair. I mean, it's just a little embarrassing to me that we're all here doing this, to be honest. We don't want the easement in their driveway. Why would we want that? And easement 2 is on our property. Tracy's paid taxes. It's just silly to me that all this is going on. I mean, I guess that's pretty simplified, but if they want to walk through, we've offered to give them a path. What's wrong with that? You take your easement on number 1, Easement 2, we'll make a path for you. Let us landscape it, make it look nice. You can see it from our house. I mean, I just don't understand.
Judge, I'm going to show this as witness. This has been marked as defendant's exhibit 14.
Okay, not in the binder?
That is that's my binder. I don't know if they've given you their binder.
No, right, so this is in your binder.
It is not in my binder.
Oh.
It's supposed to be in their binder.
Oh, okay.
That's defendant's exhibit 14. Claire, I'm going to share my iPad with you.
Okay.
It's showing you what the defense has marked as defendant's exhibit 14.
Oh, yeah, okay.
Have you ever seen that document before?
I saw this on Saturday.
How'd you get it?
I guess you sent it to me you sent it to me.
And did you go back and check your social media, your cell phone and other things to see if you had received that and missed it?
Yes, and.
Could you find it?
I'm not real tech savvy. I even had my college, 1 year out of college, student daughter come down and help me look for it, and she couldn't find it.
So until Saturday, had you ever seen that document before?
No.
Thank Nothing further, Judge.
Do you have any questions?
No, Your Honor.
Okay. Ms. Stern?
Yes, thank you, Your Honor. Good morning, Mrs. Anderson.
Good morning.
We've met previously.
Yes.
Okay, good to see you again. Your husband, he's admitted he called Mrs. David a fat bitch, told her he hoped she was going to die.
Your question?
You heard that?
Yes,
And
but,
you're aware he said that?
but the end, what I've heard and what I understand from my husband is he hopes that, or about dying, that he was going to die from being so,
She was gonna die because she's so fat.
yes.
Okay. So those are the kinds of
Not-
things that your husband says.
No,
He said it to Mrs.
said that,
David.
yes.
Look, this is gonna go poorly if you talk over each other. So, Ms. Stern, one, make sure you're posing a question. It can be a statement, but it needs to end with a question mark. And then make sure Ms. Anderson has finished answering before you move forcefully or not to your next question. Because our court reporter can take down only one voice at a time. So when Ms. Anderson is done, then you can go on to your next question.
Thank you, Judge.
Sure.
Ms. Anderson, you have an Instagram account, don't you?
Yes,
Okay. You're a painter.
yes.
Okay. What's your Instagram handle?
Well, I have a regular Instagram, then I have my art Instagram. It is, and I haven't posted on it in probably over a year. So, I think it's I think it's CH Anderson Art. I can't, to be honest, I can't even remember for sure.
That's the art Instagram?
Yes.
Personal one.
Art. But I maybe even a year and a half, I haven't used it.
Okay. So it's possible that if somebody messaged you at that account, you didn't see it.
Lately, but I did look at that account on Saturday when I was looking for that text. My daughter and I did look at that account and my regular.
Okay. Have you changed your Instagram account?
No,
Never.
no.
Okay. Let's talk about the purchase of your home.
Okay,
You purchased your home with your husband, correct?
yes,
Okay. And did you go out and look at the property prior to purchasing the home?
yes,
Did you walk easement too?
no,
You know Ann Nykirk, correct?
yes,
And you knew her before you bought the home?
yes,
Did you talk with Ann Nykirk about easement 2 prior to purchasing the home?
no,
When you purchased the property with your husband, you purchased the property subject to an easement agreement, correct?
Objection calls for legal conclusion.
When you bought the house, had someone told you that there were easements on the property?
I'm sure that they did, but not me personally. I don't remember a conversation about an easement, to be honest.
When did you first learn that there were easements on your property?
Kind of when all this came up,
Okay.
to be honest, yeah.
You didn't talk with the closing attorneys about easements on the property?
I'm sure we did, and that's just something that I didn't really zero in, to be honest. I mean, so I can't say.
When the Davids moved in, did you go over and introduce yourself to the Davids?
No, and I should have. I admit that. That was not nice.
When your husband called Mrs. David a fat bitch, did you go over and talk to Mrs. David?
No,
In fact, you never talked to Mrs. David about those statements.
no.
You talked about, were you ever actually on easement 2 before the Davids purchased it?
You mean,
Before the Davids purchased their property?
you mean physically walked in there? No,
So you had talked about, wait, I think you said was a huge pile
yes.
up here. Do you have any photographs of this huge pile you're talking about?
Mm-mm.
You see yes or?
No, I'm sorry. Thanks.
How we talk.
Okay.
You have 9 security cameras on your property, is that correct?
I don't know about the total number.
Are you aware of security cameras on your
Yes.
property?
Yes,
Are you aware of?
it's part of our
So
alarm.
you need to wait till Ms. Sturm is done with her question. You are anticipating the answers just fine, but she needs to finish her question, either because she throws you a curveball and says opposite of, but you can't talk over each other. So let her finish and then you'll get all the time you need to answer.
Thank you, Judge. Are you aware of how many security cameras are on your garage area?
I think either 1 or 2.
But it surprised you to learn that there's 4.
But I don't know. It's all tied into the alarm system.
Do you have any photographs from your security cameras on this garage that show any of these workers you were talking about or Mrs. David interacting with any workers on your property?
No,
Did you ever contact the Davids about clearing easement 2?
no,
Did you ever contact the Davids about putting lighting up in easement 2?
no,
Did you ever contact the Davids about installing a sprinkler system that encroaches on easement 2?
no,
The trash in the dumpster, if I heard you correctly, you testified that you asked your son-in-law to put it in the dumpster.
yes.
Okay. And you don't recall where the dumpster was located?
The general area.
Is it possible it was sitting on the David's driveway close to their garage?
Well, yes, that's that area I was talking about in the driveway.
And isn't it true that the trash that went in the dumpster was prior to any workers coming to the David property?
I don't think so. I don't think that that's true, but I can't say for sure.
You don't know?
I don't know.
Okay. Mrs. Anderson, you never approached the Davids and asked them if they would sell or release their interest and easement to you and Mr. Anderson.
No,
Did you ask Mrs. Nykerk if she would approach the Davids about selling their interest in easement too?
no,
You didn't? And after purchasing your home, did you ever approach the prior owners of the David property, the Darbys? Did you approach the Darbys about their use of easement too?
no,
You didn't ask the Darbys if you could clear easement too?
no,
Okay, and you didn't ask the Darbys if it was okay to put lights in easement too?
no,
And you didn't ask the Darbys if you could put a sprinkler, install sod, or do any of that on easement too?
no,
Did you ask the Darbys if you could fence off or block easement too?
no. I've never seen the Darbys. I don't know them.
Did you ever make any effort to reach out or contact them as your neighbors?
No, but they didn't live there when we were there.
You don't believe they live there
No,
at all?
I've never saw anybody in that house before.
You didn't see anybody in the house?
No,
Did you ever, you talked about an interaction, strike that earlier statement. You talked about an interaction with Mr. David where he knocked on the door.
yes,
Is it possible that you're misremembering the communication with him?
absolutely not.
Okay. Is it possible that you interacted with him some other time?
About that? About the garage, you mean? Or
Just-
just any time?
Just about, did he ever knock on the door and say, hi, I'm your neighbor?
He knocked on the door and Tracy talked to him. I heard them talking and he mentioned the trash in the dumpster and Tracy said, well, we couldn't get to our trash cans because of the cars. And he was very nice. He apologized and said, I understand. I heard that. I wasn't standing up at the door. I was kind of behind Tracy when that conversation went on, but that wasn't directly with me. That was between Tracy and him.
So those are the two times that that you know of, that Mr.
Yes.
David has knocked at your door.
Yes.
Once your husband interacted with him, you were partially in earshot, and the other time, you were the only one home, and that was the, hey,
Correct.
no one up in your garage.
Yes,
During any of the time, we heard you talk about what you want or how you would like this to resolve. At any point in time, have you gone over neighbor to neighbor and talked to Mrs. David about what you want?
no,
At any point in time, have you gone over neighbor to neighbor and talked with Mr. David about what you want?
no,
Are you aware of comments? Well, easement one, you're familiar with easement one?
yes,
Okay, and you agree that's the parking area on the David property?
yes,
Okay. Are you aware of comments by your husband about uses of easement one?
no. But us using easement one? No,
Do you have any uses you would like to make of easement one?
no,
Are you aware of comments that, oh, well, we could go play basketball on
Your Honor, I
easement?
object. We need to approach.
They're so comfortable. They're so ready.
Okay, how's that? Um, I'm happy to, you should keep going. I'm happy to look at the deposition language where that came up to see if I see a connection like. You ask the question again so that we reorient Ms. Anderson after that brief break.
Question, are you aware of comments over?
Oh, I'm sorry, Mr. Williams. I didn't mean you. Thank you.
Oh, I'm sorry.
Real time. I'm directing Ms. Sturm to say, I'm gonna do a little reset here and here's my question. She may want to move on. She may want to stay where she was. Free to do mine.
Do you think an appropriate use for easement one would be for you and your family to play basketball on it?
No,
Okay. Do you think an appropriate use for easement one would be for you and your family to have a barbecue on it?
Your Honor, objection, we're talking about speculation as to what we can and cannot do. Obviously, we can do anything on that easement as long as it doesn't interfere with what the Davids are doing. So all these questions are great, but if this is the path we're going down, we'll be here for days.
Well, let's not be here for days. You can ask a couple more of those questions.
Thank you. Do you think an appropriate use for easement, for the use of easement one would be for a hockey game?
no,
With regard to easement two, and let me grab one thing. I'm going to strike that for now, so I don't take up other people's time. But Mrs. Anderson, in talking about what you would like to accomplish here, is it your belief that the Davids cannot use easement two?
no,
Thank you. No further questions.
Any redirect?
Do you have anything? Yes, sir, just a few. I didn't ask you this. I showed pictures of nets and ribbons and stuff like that in my opening. Are those visible from your house?
yes,
How often do you see those?
every day,
All day?
all day.
Did you see any use, did they have those nets and ribbons and everything up there before the fat bitch incident? I mean, Ms. Stern asks that question all the time.
No,
Did they have nets and ribbons and chairs and all
No.
that stuff before that?
no,
That was not until after the lawsuit was filed.
right,
Okay. Do you like seeing those every day?
no,
You want them gone?
yes,
She asked you questions about whether y'all asked the Davids before doing this, that, and the other. Obviously, the Davids came over and knocked on the door and said, hey, we're getting ready to put these nets up. Do you mind? Obviously, that happened, right?
that did not happen.
Really? Why not? But never mind, that'd be speculation. The Darbys lived there, so well, strike that. The Darbys owned that house for 1.5 years before the Davids did while y'all lived there, right?
Yes,
Did you see any signs of life whatsoever from that house?
no,
Any lights on at night?
no,
How far is the driveway from your dining room?
Which driveway?
the driveway to the David's house? Approximately.
Very good. It's really close.
From me to you?
Yes, about, yeah.
Okay. Got big windows in dining room like
Yes.
for most people? Can you see people coming and going in that driveway?
Yes.
In the year and a half that you lived there, did you ever see one single car come and go out of that driveway while the Darbys owned it?
No.
Did the Darbys ever complain to you guys about, we have exclusive rights to easement 2, you can't do anything, period?
No.
Thank you.
Anything else, Ms. Stern?
No, Judge.
All
No, Your Honor.
right, jurors, do you have any questions for Ms. Anderson? And no cards? You do? If you've got, it's okay, if you've got a card, we just pass it to Deputy Gordon, you don't give it to Ms. Anderson directly. If you-
Specifically for her, it's kind of.
Okay, well, you'll need to figure out which witness you would want me to ask the question of, because it wouldn't be like, hey, Mr. Edwards, what do you think about this? I wouldn't ask the lawyers any questions. It may be a different witness who hasn't testified yet, so.
No, it's more of a general question.
Okay, well, you're welcome to write something down and give it to Deputy Gordon. The cards that you all pass to him will be questions that I vet for the witness who is currently testifying.
Once, going twice.
Thank you, sir. In a second. Okay, so counsel, the way we're gonna work this is you are gonna come around, I'll let you into the chamber so we can talk about these questions, and then I'll come back out and ask the ones that I'm gonna ask. Deputy Gordon will get you there.
Would that be a wall? Would that be a wall? Exactly.
Ms. Anderson, a few more questions, and then if the lawyers have any follow-up, they will undoubtedly follow up. When you first started answering questions from Mr. Edwards, you shared with the jury an anecdote about your daughter as a teacher and some students that she taught. You mentioned that they were poor, economically disadvantaged. You didn't indicate white, Black, Hispanic, Native American.
They were Black. The whole school it's Black.
Okay.
Yeah.
You referred to, or at least were asked about some landscape lighting that was
Okay.
installed on easement 2 or near easement 2.
It's way up in the trees down on easement 2.
Okay, is the tree in which the light is installed on easement 2 or on what we'll call Anderson property? If you know.
I don't know.
Okay.
I think it's on the easement, but I'm not sure. I
Okay.
think it's that far back.
And do you know if the lighting was installed up in that tree before the Davids moved in or after they moved in? And not knowing is okay. You don't look pained.
I know. I don't know.
Okay. Do you know who, if anyone, is responsible for maintaining easement 2? And who, I don't mean you versus your husband, but is it an Anderson responsibility to maintain easement 2? Is it a David responsibility? Or how do you think about that? If
We have maintained it up into this point. So I guess it's our responsibility.
okay, at least you have assumed that it's your role to do that.
Yes.
Okay. All right. Do you have any follow-up based on those questions?
I don't have a follow-up, but I have one question that I forgot.
All right, Ms. Sturm, any objection? You get to follow up if you want to, a question Mr. Edwards forgot.
To both the questions and what Mr.
No. I wanted, Mr. Edwards remembered something he meant to ask Ms. Anderson. Really, we've closed that. I don't mind reopening it. I just want to give you the chance to object, saying, no, he actually did direct and redirect, so he may not ask her another question.
I believe that's the case. We've done direct and redirect.
Okay. What's one question?
Yes, sir.
Ask you one question.
In the couple of years that those nets have been in your yard, can you give the jury an approximate number of times that you have seen any children or other people out there actually playing with the nets?
A handful.
I was allowed one question.
Mr. You can follow up on that question if you want, or any of the questions to which Ms. Anderson provided answers. And sure.
Ms. Anderson, just to be clear, you didn't do anything on easement two, no maintenance, nothing between the time you purchased the property in September of 2018 and the time the Davids moved in 2020?
I don't remember when we had it cleaned up. I don't know if they were living there or not, to be honest.
Isn't it true you don't actually know when anything occurred on easement two, or when people have been on easement two, or when equipment has been on easement two?
No, I do. Some things I know, but I don't know exact dates. I mean, I don't remember. I don't remember when we had it cleaned up. We just thought it was a nice idea to make it look better. And no idea that that would offend anyone.
But you didn't ask anyone about it?
No.
Okay, thank you.
The cleanup work that happened, I know you're not pinning a specific
Okay.
date on it, that's okay. But can you place cleanup time pre-Davids, post-Davids?
I guess it was after they had moved in, just because of all the issues that have come up.
Okay, thank you. I appreciate your testimony.
Okay.
You are free to step down.
Okay.
Mr. Edwards, call your next witness, please.
We're gonna call Daniel Venable. He is out in the lobby. He was subpoenaed.
Okay,
Want me to go to him?
you should, someone on your team should get him.
Okay.
Just to manage Mr. Venable's expectations, we're gonna go for about 8 minutes with the witness, then we have to break for lunch, because I gotta get to my office and turn on a Zoom to do my lunch meeting. So
Certainly.
he may get interrupted, and we'll do part one, pre-food for some people, and part two after we reconvene.
Sounds good. Thank you so much.
Sure. Hey, Mr. Venable, before you sit down, your face is recorded.
You swear affirm that the testimony you will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Go ahead and have a seat.
Judge, one sticky point, and I apologize, but we may need to approach quickly just to clarify.
Okay. Hold that thought, Mr. Venable,
Sure.
whatever it's gonna be.
Daniel, last name is Venable. Venable. Thank you.
That may open things up for you. We'll see how it goes.
Can you state and spell your name for the record?
I'm sorry. Is that for me?
Yes, sir.
Okay. My name is Daniel Venable.
Are you employed?
Yes.
All right. Who are you employed with?
Was asking to spell it, so
I'm sorry, I thought he was asked to state his name. I apologize. I'm sorry.
Sure, it's Daniel Venable, spelled Daniel. Last name is Venable.
Are you employed?
Yes,
Who are you employed with?
On Point Surveying and Mapping.
Okay,
And surveying and mapping.
and can you describe what your job is?
I'm a licensed land surveyor. We map out properties and commercial, residential, and do, plats and maps of those properties.
Okay, and did you say you're registered?
I am.
Okay. Will you describe your job duties?
I work in both the field and the office. The field, I'm more of a, I guess like a project manager. I oversee the field crews, and then the office, I prepare proposals and review the plats and maps that our CAD technicians provide.
Okay. And how long have you worked there?
Since 2016, so 8 years. Yep.
Have you ever been out to 3350 West Andrews Drive in Atlanta, Georgia?
I have.
All right. Do you know who lives there?
I believe it's the Anderson residence.
Okay. And do you remember when you first went out to that property?
I do.
When was that?
I want to say, well, I guess I do. It's April 2020, I think was the date. I can look, it's on my plat, the field date, but
Okay. And
it's been a while.
What's
Yeah.
the plat on this screen?
Don't
Or
put
the
anything on
survey
screen until it's
says.
Been admitted.
Oh, okay. Yes. Well, before it is that. Did you bring a copy of your survey
I
with
sure
you?
did.
Okay. And I believe it's a rather large survey, isn't it?
Yes.
Okay, we have a smaller copy. I'll show to the other side. Okay.
Your Honor, just a logistics, I'm assuming that it shouldn't be published yet to the jury until
Right,
it's
I
admitted.
said,
I apologize.
okay, nothing should go up on a screen until it's in evidence. I don't think there's anything that's gonna be admitted that can't also be published, so no one needs to ask about publishing. There are no autopsy photos or anything, so, once it's admitted, feel free to publish. If it's already been admitted, publish whenever you want, republish, but until it's admitted, jury shouldn't be looking at it.
All right. We'll take a look at that.
Sure.
Do you see the document I've handed you?
Yes,
Do you recognize what that is?
I do.
And what was the document I handed you?
It was the drawing or the plat that we provided the client after we performed the survey.
And is that what you brought? Is that a smaller copy of what you brought with you today?
That's correct. The size, the copy that I brought is a scaled copy, so it's the exact scale of the drawing, not reduced or anything, so.
All right, and I would move to tender that as plaintiff's 2.
And you're tendering the reduced size version, or we're gonna be taking from Mr. Venable, the big one?
Is that a copy that's available to stay here?
Absolutely.
Okay, we'll take the large.
Okay.
When
So
is-
you make sure you label it, because that's something that'll go with the court reporter ultimately, but we'll go back with the jury, if it goes back with the jury. But, any objection to admission of plaintiffs 2?
Not necessarily, but we have not had an opportunity to compare the two.
Okay, assuming what you've got in the micro version is the same as the large version, plaintiffs 2 is admitted.
Okay, thank you. Okay, and looking at the copy of your survey, can you just describe like what this is?
So it's basically a boundary topographic and tree survey, which the boundary shows the property lines and the dimensions around the property. The topography shows the elevations of the property, and then the trees, we identified all of the trees that were 6 inches in diameter and larger, and showed those on the map.
Okay, and that was for the entire, was that for the entire property?
Correct.
Okay, and it looks like that the easements are included on this, is that correct?
That's correct.
Okay, so you also have the ability, or would you have the ability by looking at this to describe how many trees are on easement 2?
I would.
Okay, and so does the survey identify what date you went out there to go do it?
It does.
And what date is that?
I'll have to look if that's okay.
Sure, absolutely.
Okay, if you look at under the survey notes, is item number 5, it says last date of field work performed on last date of field work. It says performed, go back to find it, on 04/02/2020.
Okay, thank you so much. And okay. Do you know, can you tell how many trees you identified on easement 2?
Sure.
For the less educated viewing public, are the easements the 2 gray areas?
That's correct, yes.
And easement 2 is the smaller or the larger of the gray areas?
Looks like it's the larger of the 2 to the far right of the page.
Okay.
Uh-huh. So it looks like there were 1, 2, 3, 4, 5 trees that were all the way on the property, and then there was one that looks like it's right on the property line. That would be tree number 12, it looks like.
Okay, and so if my math is right, that's about 6?
Correct.
Okay. And can you, does the survey include the dimensions of the trees?
It does. Well, it gives the size of the diameter of them.
And what, the diameter of what?
So that's going to be if you take what we call a tree measurement tape, and it's at your breast height. So you wrap the tape around the tree and it gives the dimension of that tree,
Okay.
whatever you read on the tape. So,
Okay, thank you. And can you describe the 6 trees that are on easement 2?
sure. Looks like it's going to be tree 14, 15, 16, 19, and 20. 14 is a 9. So it's a double tree. It's got 2, I guess, trunks coming up. It's a 9 and a 24-inch hardwood. Tree 15 is a 26-inch pine. Tree 16 is a 13 and 32-inch hardwood. Tree 19 is a 27-inch hardwood. And tree 20 is an evergreen, 6-inch evergreen screening. And then the one that was on the property line looks like tree 12, that was a 24-inch pine.
Okay. And do you remember when you were first contacted to do this survey?
Vaguely, it's been a while.
What's your recollection?
Basically, we either through phone calls or emails, most of the time we'll prepare a proposal for the client, they'll sign it, send it back, and that's basically our notice to proceed for the work.
Okay, and do you remember when you were first approached to do the survey?
I don't.
Okay.
I don't know why you're showing me.
Okay. Can you take a look at this for a minute?
Sure.
And let me know when you're done.
Okay.
Thank you so much. Did you have an opportunity to review that?
I did not.
This?
Oh, just now, yes,
Yes.
yes. I thought you meant before I got here.
No, I'm sorry. That's my
No.
fault. That was confusing.
No.
Okay. And did that refresh your memory on when y'all were first contacted about the survey?
Yes.
And when was that?
Well, I'll have to take another. Oh, I didn't take a date. I was just reading the thing. I'm sorry.
Didn't ask you to memorize.
So looks like on March 3rd, 2020.
Thank you so much.
Sorry about that.
Okay, you are all good. Did you ever go back to the Anderson property at 5530 West Andrews?
We did.
Okay,
Right. Yes.
when'd you go back?
It was a couple of years later. I was contacted by a gentleman, Robert Jenkins, I believe is his name. And he was asking me to fill out an affidavit.
Okay, and did you actually go back to the property?
I did. I met him on the site.
Okay,
I met him out there on the site. Yes, sir.
and did you have an opportunity to look at easement 2 on that date?
We did. We went around the property and reviewed each of the trees that were in question.
Okay, and do you remember the date that you went back out there?
I don't remember the exact date.
Okay. I believe you said it was a couple years later?
Correct.
Okay.
Yeah.
Do you recall when you went back out there a couple years later, were all the trees still there?
Yes.
They were?
Mhm.
Okay. Thank you so much. I have no further questions for you.
Right, this is where we're gonna break. Unfortunately, you, Mr. Venable, you're gonna get lunch downtown.
Okay.
Eat lunch, but we need to break now. It is at multiple clocks here. I'm gonna go by the phone clock. It's 12:25. Let's try to be back by 1:30, jurors, 1:30. So don't walk more than 30 minutes in one direction because you want to be back in an hour. You're free to eat wherever. You don't have to eat at all. It's fine to eat as a group or subgroups. Just don't talk about the case. No outside research. Don't look up what a 24-inch hardwood means. If you've got questions about that, here's your man. You can ask him after lunch. So let's all try to be back by 1:30. Any logistical questions? Seeing none, we'll see you in about an hour.
All right, sir.
And council, I'll take up any issues you all may have when I get back from my meeting. So let's be back at 1:45. Good, thank you.
Oh, Mr. Venable,
We're supposed to come.
wait.
Oh, I'm sorry.
We don't want you to actually end up with the jury.
Okay, yeah, yeah.
Yeah, sheriff will send you back there.
I
So what do we
think
do with
that
these?
he can exit the courtroom now, right? Or Venable?
Yeah.
Okay, yeah. Did he say what time he wants us to be back?
He wants us 125, jurors 130.
Okay, so 1:30 for you. Is that okay?
Yeah, it's fine.
Okay. Thank you so much. Oh, and you can leave, since that's gonna be
Okay,
evident,
keep
I'll
that
just
here.
keep it right here. Thank you so much.
Deputy, remind me, is the courtroom locked when we're at lunch or not locked?
You guys need me to lunch it, or? I don't know if you guys will get it out.
Yeah, I was gonna probably come back.
Okay.
Thank you. I guess I'll just try this quick one.
Out there, Eric,
Good. Good.
Yes, Debbie, go ahead. Okay.
You can stay in, is that all right?
Yeah, go ahead. All right, thank you.
Like.
Yeah, yeah.
Yeah, baby. What you doing? Oh, okay. Well. I don't, but if you want to remind them. Oh, yeah. Well, I just thought of my dresser, you know, I know what you're talking about though, and I'm trying to think. If like you gave it to me or I have it, it would be like sort of daily leases, I just don't know where that is at this time. What was it, what, not our present lease or the, alright. Yeah. How long? For what? Oh, okay, yeah. You know, I don't think. My dad would look at me the word I kept leases. I don't know, it might be up in my office somewhere. I'll think about it, okay? Yeah, no, I know you can. It's, um. But you know how I'm very ordinary, I keep those in, folder with like all the important papers and things that. I'm looking through it, finish. Oh, that's right, I see, yeah, I see what you're saying. It might be on my desk, I mean, folder that. You know, when I get home, I'll look for it, it might be right on my desk. Okay. Different, but yeah, nobody keeps those. Did you try to call social security and get send you on a duplicate? You can get one for any, you can get one for any social, I mean, you can literally go to city hall. What was social security? I'm done saying the social security, I'm there, the social security office. You can get one. They might just say they don't mail it out, but you can certainly ask. I'm just saying like you said, because that I don't know, nobody keeps. Yeah. Right, no, excuse me, like you said, yeah, I'm using exactly what the papers, I'm just, what they said, around my. And that's the kind of thing we should have told them before. Yeah. No, I understand, but it's always something that makes you be proactive. You just- Mhm. But why do they need the physical? I don't understand. I don't understand. Because you have the number, I mean. Yes, and you can, yeah. He said, you haven't done, it says you can replace, you are able to request a replacement social security card only 3 times in a year. And 10 times during your lifetime, and you have never done that. So that's why I said, I mean, you can push comes to shove, just. And you can, like I said, because I think. Yeah, this, because I'm trying to think, I mean, because I think, I guess, it might, yeah, well, mommy gave me mine, I don't even know. Like you said, the same thing with Boston, and I went down, when we got to Texas years ago. And they gave it to me right then. Okay, here it is, and I have it. Okay, listen, I said, you can probably go to www.ss.gov. Questions. You want me to send it to you? And all that. This would be a lot of mine. It says, how do you apply for the months? What are you gonna do for dinner tonight? Yeah. Yeah. Is there any more salad? Did you get dates today? Okay. Well, you know, maybe we'll do it tomorrow. Because I want to do usual dates. We should Sam Club set it, okay? All right, let me send this to you. I'm gonna do a little reading. I'm gonna read this case. All right, I'm gonna send this to you now. Okay, right, all right. And when I come home, I'll look for it, guys. Okay. I can't read my own writing. Hey, well, thanks a lot, bro. I got your message. Thank you so much. That was so beautiful. I appreciate it. God bless you. Yeah, you too. It's been a while. How you doing? How's your family? Yeah, yeah. Yes, he is. I'm doing better. Is she okay? Okay. I mean, I'm sorry to hear that, brother. Yeah, yeah. Yeah. Yeah, when something calamity, yeah, when they call on a lot, right? They don't call it line other time, but when they're in a calamity, everybody says, oh God, help me, right? But never say, oh God, I'm so grateful for what I have and thank you for life. I know they think we're fanatical, right? Yeah, they do. They think we're fanatical because we believe in God, but it's so funny, like you said, nobody thinks about their blessings or their mercy until something bad happens. I mean, even the atheist says, oh God, right? And you know, whether it's sincere or not, which is not for us to tell for right themselves. Because the human being has, they don't understand, has the affinity for that. So they don't even understand their nature. Mm-hmm. 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 Mm. Mm-hmm. Mm-hmm. Brother, what ayat is it? Like, I've been Surah Baqarah, I can't tell you how many times. Do you know what ayat that is? Thank you. Oh my God, because like you said, I never know, I don't even, yeah. I- Yeah. Is it that, you know what, let me, see, I'm on a break. Let me see if I can Google this. So you said, and there's scribe, you know, let me Google Zero. That's right. You said that was in Surah Baqarah? It's about 131. Yeah, I was listening to recitation this morning. Oh my God, brother, this brother was so bad. I was literally in tears the way he was reciting. Mhm. Yeah, yeah, well, we all fall short, brothers. Do that. You know, yeah, I think it says, the 19 to 20, Shaitan comes to do his enemy to disobey Allah and so. And it says children of Adam and 26 to 30. Correct full stops. And that's a little different. Yeah, that's when the baby, that's when we created this one. You know what, I'm gonna humbly look, I was like, yeah, that's, I should, because, you know, like I said, I said, he says, let me stay up on my reading, you know, for around. So I have to, yeah, I'm going tonight, yeah, you know, that's like one of my favorite, you know, chapters too is Bachman, like you said, it's, like I said, every time I read, I get something else, you know. And, yeah, I'm gonna take it, sure. Yeah. Excuse me. Wow. No, for me, brother, I'm sorry, I burped, I said, oh. I didn't. Okay. Yeah, and you know what, and we are not, you know what, it's funny, 'cause you know we come from the same GMAC. And, you know, that was always a bone of contention with me, because like you said, that was not the right understanding. Cause even the imam said to me, you know, the mosque said, do not break the ties of the womb that bore you. He didn't say Muslim, he said the womb that bore you. And the imam, he said, and right, and we don't go as very specific, so why I want to say Muslim when you said that. Like I said, even like you said, kith and kin, he didn't say Muslim kith and kin, he said from kith and kin. As a matter of fact, here, very severe to us as Muslims to non-associate and even with our families who are not Muslim. Because this is not our way. Yeah. Does it called Al Qasas? And yeah, a form of capital or no? Okay. Okay. Yeah. Right. Right. Mm. Mm. Wow. For the mother, right? Can you imagine, though, brother? How severe that is?
There's like,
I don't even want to, you know.
There's no time in the schedule, so I'm not encouraging any other.
So that means, can you imagine for us? Also, no lessons were spoken.
Can I come up there?
Oh my God.
Yes. Okay, I really didn't feel like going anywhere. I was like, I can't. Oh, it's so hard down here. I mean, there's just. It is. Well, I don't know how you are, but when I'm in trial, I just like can't have that much food in my stomach because it feels like it's weighing me down. The time seems like you're like go to lunch for an hour and it's a big deal, but when it's trial, it feels like it's like 10 minutes. You know what I mean? Like you're like, I don't feel like my heart. I don't even feel like I have a brick in my stomach. I did, so it's kind of funny, but got a parent that's sick, and I'm nephews. I was like, you know, it just hit me. My dad's having a hard time because it's pretty much immobile, but I'm sorry. I was like, you know, you should do those packets because you can just squeeze them in your mouth. And so I want something. How gross is this gonna be? Yeah. Those ones like upon a farm or something, they're actually I was like, I don't understand stuff. Right. Well, it was like, you know, all of a sudden the light bulb went and like, oh, there is an option. I know. Yeah, I was like, when I got home yesterday, I was like, hungry. Oh my gosh. Be nice to your draft attorneys. You don't know how much it's like just in general when I'm talking to people, you know, I'm like, you know, bring a little on it. You never done. No. Hey, how are you? No, you are. Yes. No. Yeah, I had a trial back in March.
This is the first time that's fixed it over and stuff in the courthouse.
Yeah.
They were just like.
Yeah, their company has been supposed to be really public for the last 2 or 3 years.
TV just is like.
Because pretty much every client,
Let me get back.
you know, I've had.
Right. Yeah.
My whole clinic, like, this is a lot.
Why would you do this?
I guess I have an underlying hatred of myself.
Right, sufficiently, both my children are like, no, thank you. We will go a different way. I'm like, your choice.
I might be, trying to fly in for that.
Expensive for a lot of things in this bag.
Oh, he's got, they're trying to do a private sale or something. Yeah.
No, I mean,
Yeah.
on Friday, bro,
Right.
I'm sure I'll call you back.
That's it.
Yeah,
It's
no, after,
it's easy because she knows she'll get her pay out.
It's probably, maybe you, brother.
If it works, it's right. If it works.
After,
Yeah.
like I said.
But there's only so many times we get lightning in a bottle like that, so.
Okay, okay, yeah, I don't want to interrupt. Yeah, I don't want. Okay, so.
It's going okay.
Skipping lunch and having.
I totally understand that.
Well, whatever.
Oh, with me? Okay.
Whether he was nice. So he found the money, which a quarter of $3. And it's in the corner of the other, he had that. I think $3 so all the money he thinks was on the gross, and he went one, looked at it, could find it. And including these guys. And he didn't have any problem finding, he didn't set it on invitation, easily identified. Look at his notes. If you look at the deed and Anderson, you'll see that it's the same reference, I would imagine, to the. Pretty good. In with him. It's already stipulated the authenticity. Excuse me. I think this is the guy to do. Something.
Okay.
I just think that it would be useful on, because the survey would be like, yeah, how did you, and you know, how did you come to locate it? I did a field survey as. Yeah. Yeah, that's not, you did first time.
You're sending me text messages. Not only do they call and spam you, they text and spam you.
What's that?
I don't know, you know. Is that this one? It's the tree.
Yeah, I would ask him that, they identify that. I mean, we're not spending a bunch of focus on it, but.
You just check that these are the same.
Yeah, he probably, I'm just asking what deed references he have in his notes. What do you think to locate the mutation? We verify the location of that.
Those are not mine. I don't even wear glasses.
No.
I just don't know what it is.
Mm-mm.
What is today? Tuesday.
That's from Vanessa.
Oh. That's the thing that Tony sent out, the lucky, non-participants.
I've not seen that.
That send something nice about somebody for me.
No.
It's a cool idea. I was like, I should probably send something, but it was, I think it was Tonya. Was like, I don't know how they're collecting them. She was like, you like click on the link and then it said to send something.
Hmm.
You know, like nice about, or like something while you're lucky, because it's St. Patrick's Day. Yeah,
Oh, it is?
while you're lucky, well, on the 17th, while you're lucky to work with somebody.
Yeah.
That was nice. Yeah.
I know, I didn't even recognize it. It looked like spam. She was being friendly.
It was very nice of her.
Water?
I'm so glad to have a bigger thing of water today.
Didn't move real big.
Did even,
No,
like, have you ever ailed you?
no, I'm a believer, but I just don't carry any with me.
Hawkins believes that you shouldn't use Advil after working out if you're sore, because you need to be
Yeah, that's, I don't subscribe to that. Call me when it's in the sixties and tell me that.
When you take Advil, it reverses what you just did to your muscles. That's what it says.
Yeah, ibuprofen's not great for you, but it's pretty effective.
I think so too. Better than Tylenol.
Yeah.
I bet that Joe was the door.
Easy. Nothing. Don't.
Did you get booted out of Zoom? Krista,
You're
not, you're not.
I'm not on. I didn't bring my laptop in. Figured we only needed one.
All right. Tell you what? You're not in it either.
Judge, do you think it's ending tomorrow or Thursday?
Tomorrow's the short day, I think.
Tomorrow's a short day.
Right. And then and we're on Thursday?
We're on for Thursday. I was hoping we'd be finished tomorrow, but I'm dubious.
Yeah. Okay.
Do you-
And,
Do you think you're gonna be done today? By any chance?
Well, it depends on how many times Tracy gets asked about fat bitch and Algerian N-words. I mean, if that's an hour's worth of question, we're gonna be here all day.
and we have to make the jury of the verdict, so that might be Friday, right?
If we spill into Thursday, I would imagine we're gonna be done before lunch. Yeah.
Yeah, my thought would maybe be complete the testimony. By the end of tomorrow, probably wrap it up Thursday morning.
I don't, oh, here's one of the things, Bob.
Look at this.
Which ones do you use?
Just the survey. It's number 2.
Booted us. Let's see.
So.
I keep thinking something's deflating.
Finish the questions before the break, right? Okay. Yes. Well, especially when we're sitting here not doing anything, then I'm tired. Oh, miss your wife's trying crazy.
Oh, shit. Get off the road.
Hmm. Yeah. Exactly. Yeah.
First, come here. Yeah. Where's this piece? See, yes. Yes, it is. Make it bigger. I don't like something related. That's halfway to go back and all the shit seems okay. Yeah. So that was 18. This is nothing but like I'm done clearing. Yeah. Maybe no clearing between October 18 and November 19. Yes, absolutely. Yeah. So you've got a note, you're gonna have a notebook up there. Yeah. I'll be using this thing. I'm gonna show it to the jury until the judge says admitted. But I'll ask you and you can authenticate it. Yeah. You can try to laugh that house from time to time over the years. Every now and then. Yeah. I mean, it wasn't like every week or every day, but you know, I would cut through and stuff. Yeah. Yeah. Good. That's two. Hey, Kristen.
Oh, congrats.
You know, you show them. So, yeah, that's my.
Gotta get up and stretch, right?
Oh, you good at this? I need to do a CLE with you on this.
So easy.
That's it. Yeah, that's really cool.
I had more than help me with deposition for this, and I know that 5 2
That's awesome. Yeah, I've really just only done it old school. This is like technology, front courtroom experience, because everything comes through with the cool, but that's awesome. I like that.
I don't know that I can do that with this, but on a laptop I can.
Is it a package that you?
It's called a trial pad drive.
Okay,
And you go back to it, it's a 3-pack.
okay.
It's got a transcript pad. So,
So you can like mark up your.
well, no, you load it up. You load the transcript up. Go here. You can load the transcript and you can read it. It has to be a TXT file. And you can read it. And as you're reading it, you can highlight stuff, make a note, and then it summarizes all the stuff by your topics. If you make a note regarding easement two, all of the notes regarding easement two are on there.
How helpful.
Yeah, it's awesome. And then same thing for, doc review pad. You can, look at your documents
Mhm.
and it's just great. I mean,
That's really cool. That's very helpful.
yeah,
That's really, like, and user friendly.
incredibly.
I mean, usually with Corona, I'm not a proficient in IT, but I'll get it. But yeah, that's neat. I like that. And I have no reason to believe that more courtrooms are gonna become like this.
Well, this isn't very good for that.
Oh, this court, like physically, no, no, but I
I mean,
would.
most courtrooms have them
Like
on
posted
the
up.
walls and have them there and have them all over the place.
Yeah.
So I absolutely love it because it's just so easy to do this stuff. And you can get your little laser pointer, you can put this right here. And that's your laser to show the jury you're highlighting this thing.
So cool. I like that. That's neat.
Yeah, so if you want me to pull something out to show the guy, just have to bring any of your witnesses to check it.
I appreciate it.
Because I've got all of our exhibits and there's.
Okay, awesome. Yeah, thank you so much. That's really neat. Thank you for telling me that. In the you learn something new every day category, I'm glad it was this.
Yeah. Normally when you're doing it through an HDMI, you have the option of showing it or not. Here, I have that option since we're doing it. It's got all, if I had notes, they could, in here, they could see my notes, but the notes up.
Okay.
Like, some of them I've got some long documents actually. Show you this, I loaded it last night. So. I can put more stuff function. And I just jump straight to that. Now. I have this, when I show you this, but it's on these 12. And it's so easy to pull it up.
That's unbelievable. That's awesome. And that's like a very exciting.
It costs like $350 a month, not enough, $350.
Oh, that's not that bad. It's not that much worse than like paying for Microsoft, the Microsoft Office package or whatever. So,
No, I wrote this.
yeah, that is really cool. That's very useful.
It's on the, yeah. But
I'm surprised you're not in the bathroom already here. Good God, that looked horrible.
that was greasy. Well, there.
I was just in there. It looked horrible.
Thank you. Right, that's what Rob said.
It's been texted.
Still broadcasting, people can still hear us.
Or saying anything exciting. But
People can see it says up there, where's the microphone picture? It's got that right there, that on the turn desk.
No, that's off.
thought it was muted.
Yeah, it's muted. See? Because that's us right up there in the top right corner and it says it's muted.
That one's green.
Yeah, that one's green, so yeah, because it says podium is talking, so who knows?
Oh. Just practice. Were you finished with my camera?
I was right before the break and that was the prompting of the break.
Yeah.
But I can't remember either.
No, I think that's what happened. I don't think we stopped you.
Yeah, I don't think so either.
Remain seated, walk on the water.
We all stayed seated this time. We all stayed in our chairs this time.
Call it Eric.
Right, okay. So let's go back on the record, please, in Anderson's versus David's. Two things. One, it's gonna be a little choppy. Mr. Venable may be on the stand for like 2 minutes before we need to break again. So our court reporter can take care of some things he needs to. Number two, juror 8, Ms. McCurdy, the fitness instructor, approached Deputy Gordon as lunch began to say that she thinks she may have purchased some of Ms. Anderson's art and that her kid or kids may know the Anderson kids, something she didn't pick up on when we were doing voir dire. I'd like to bring Ms. McCurdy out here so she can flesh that out a little bit. I'm going to ask her a few questions about whether that gives her any pause at all about being fair and impartial. And then I certainly need to give the lawyers an opportunity to explore any of that if they want to as well. Any concern with me bringing Ms. McCurdy out, Mr. Edwards?
No, sir.
Ms. Stern?
No.
All right, she's here. I don't know if we've got all 13 jurors, but we don't need all 13. We need Ms. McCurdy.
Okay.
Please.
Good. No, now, toward that way. Yes.
Hi there.
Hi.
How are you? You can take a seat. I'm standing just because I can see you better because that giant screen. Deputy Gordon shared with me that you now having maybe seen Ms. Anderson more closely or thought about it more, that you believe, and you're juror 8,
Yes.
that you may know Ms. Anderson or your kids may know her kids and or you may have purchased some of her art.
Yes.
So tell me, 1, what it is you think your connection is, 2, why you are thinking of it only now and not yesterday, and then we'll get to 3.
Well, my kids went to Christ the King, and I believe that hers did as well. And her daughter and my daughter, I think, played some volleyball together. And then her sister, who I always mix them up, kids were better friends with my kids. And I always thought that her daughter's name was Claire and her name was Beth, and every time. And then as she came up today, I was like, oh my gosh, I know her. And so that's why I didn't really kind of connect. But that's my connection.
Okay.
I mean, I don't, like I said, I knew it as she walked up. So we're not like hanging out. But,
Okay.
and I think we do National Charity Week together.
Okay. So don't ask her
Oh, sorry. I
questions.
think
That's
we
all
did.
right.
I don't know if she did it, but I think she did National Charity Week too.
Okay.
So.
So you all have overlap because of your kids and her nephews and nieces and her own kids.
Yes.
Also because of National Charity League.
Yes.
Sounds like you just may move in some of the same circles. What about, I bought her art before?
Well, I have some stuff that I'm not sure if it's hers or her sister's, but I know they both do it, that I bought it like Christ the King type Christmas stuff.
Okay.
So.
So it was through supporting the school.
Yes.
Where either Ms. Anderson or her sister donated it, and that's to benefit the school, et cetera.
Yes.
Okay, it's not that you were at the Anderson Gallery.
No.
Oh, I'm gonna write you a big check for this. Okay, got it. When is the last time you think you saw this Ms. Anderson before this trial?
Maybe like 4 years ago.
Okay, your kids, Christ the King is that all the way through high
He
school?
goes to 8th grade.
Okay, so when did they finish being in Christ the King?
Well, my daughter, that I think would line up as closely with her daughter, went through 8th grade, but I think her daughter left earlier and then they played volleyball. We saw them on the volleyball court against each other throughout high school.
Okay, when did your daughter finish high school?
2020, she's a lucky one.
Okay, so 4 years ago,
Yes.
most recently you would have been interacting with, if it's this Ms. Anderson as opposed to her sister,
Yes.
would have been 4 or 5 or more
Right.
years ago through volleyball.
Absolutely.
Even further back in time, if your daughter was in school with her
Yes.
daughter. Okay, all right. Any of these recollections coming back to you give you any pause about your ability to be fair and impartial to both sides? Okay. All right, Mr. Edwards, do you have any questions for juror 8?
No, sir.
Ms. Stern? Or Mr. Schneider?
If Your Honor, I get to speak for just a moment.
All right,
Just 1 or 2 quick questions. How frequently over the years would you say you would have crossed paths with Ms. Anderson?
None, you know. I said, I didn't even really realize.
And did you have any interaction with her husband at all? Okay. Have you ever seen him before today? Okay. All right, that's all I had.
all right. Thank you. We're gonna talk about this amongst ourselves, and if you come back with the other 12, you're still with us. Based on Ms. McCurdy, juror 8's answers, I think she should remain in the jury pool. Do you have any objection to that decision, Mr. Edwards?
No, sir.
Ms. Stern? Or Mr. Schneider?
Your Honor, I actually do have an objection to it. I don't think she seems biased, but there is a fair amount of crossover between their families over some period of time. And that to me gives rise to the prospect of some sort of a bias, even not a conscious bias.
Okay, so you had a chance to explore that with her. Your questions focused on any connection at all with Mr. Anderson, her answer, none. And the frequency with which she, I can't remember if you said overlapped, but interacted with Ms. Anderson, and her answer was her answer, but it was, she said infrequently, not often, whatever it was. I don't think there is anything in the record other than her statement that I will have no problem being fair and impartial. And this isn't something that affects me. So if you can point me to something else, I'll listen more to your concern. Otherwise, I will note it and overrule it and leave Ms. McCurdy on the jury.
Thank you.
Okay, you've perfected that for the record. I think what we ought to do, rather than bring Mr. Venable in and you ask him 3 questions and then we have to pause, is that we're gonna take a break now. I'm gonna have Deputy Gordon explain to the jurors that we're working through something. And when Mr. Williams is able to rejoin us, then we'll get Mr. Venable in here. So you can let him know this break is being extended. And you can do your cross-examination. I'm assuming you've got questions for Mr. Venable. It really doesn't matter. We're gonna break now anyway, but if you don't have any questions, have to keep them here in case the jurors have questions, just to be consistent on that front. Mr. Schneider.
Kind of, if we can approach just for a moment for more of an administrative issue.
Sure, if it doesn't require it to be on the record.
I don't believe it does.
Why don't we excuse Mr. Williams? We'll go off the record. Deputy Gordon can let the jurors know that we need to work through one thing and we'll get them in here soon. Okay, great. Mr. Williams, thank you. And Deputy Gordon, after you let the jurors know, can you get Mr. Williams back in? I think chambers will work better today. You
Okay.
should go where the jurors are. But there, when you go in the chambers, there's an office immediately to your right. I think the door's closed, but assuming that's empty, that's for Mr. Williams.
Okay,
All right?
I'll meet you out there.
Okay. You don't even need to approach now.
Well, it's sort of a symptom of the issue. It's apparently the tables are all mic'd and on YouTube, people are picking up even our interactions between counsel. Is there any way to create any barrier for that rather than just going out in the hallway to talk? I know this is kind of a symptom of where we are, but.
Sure. So a couple things. I forgot because I was in a hurry to get on this meeting. I can mute the big microphone and then that cuts off audio to the external feed. And I should have done that for the break. And I didn't. So.
I don't think we said anything interesting, but.
Well, you'll find out because it'll be out there.
Apparently so.
On X. Schneider says blah, blah, blah. So I will do that in the future for breaks, and mute, it's called the podium, but it's that mic there. Yours aren't on, actually, if there's a red light, because now mine is on, that's really loud. So you actually have to kind of speak up for that microphone to grab you, that's the one that's on. If your mic has a green light on it and it's on, and they're really gonna hear you. But if it's red, I don't think you need to leave the room to have a confidential conversation, but certainly during breaks, I will do my best to remember before I run out of here for whatever I need to do, is to mute that, because then you can speak in normal tones.
Okay, right. That way everyone now knows I hate Tylenol. Maybe I'll end up on some sort of hate list or something.
The Johnson hate list, whoever does that.
What does it mean when there's no light?
You broke it,
No, wait, now there's a red light, but there wasn't a light, and now there's a red light.
it's fixed and don't mess with it. That means don't touch. This is a particularly sensitive mic, I guess, the one on the podium, because it's picking up a lot of stuff. In my courtroom, if you're at that table and it's red, I could hear you this way, but folks wouldn't hear you over the system. And so, for example, when Ms. Nykerk is testifying, if she testifies via Zoom, you're gonna need to talk into a microphone, because that's whether it's the one at the podium or wherever you choose to be, you're gonna wanna make sure it goes through a mic, because that pushes them into the Zoom system. Okay,
Thank you.
you're welcome. All right, well, I'm gonna go back and do some work, and when you all can be at ease, how about this? It's easier than I thought. All right, we're back on. Don't say bad things about Tylenol. Yes, why don't you get Mr. Venable heading this way? Jurors can come in at the same time. Let's go.
Okay.
Well, let me make sure. Mr. Edwards, you ready for the jury?
Yes, sir.
Ms. Thurm?
Yes.
All right, Mr. Williams, you good to go?
Yes, sir.
He is. Let's bring the jury in, please.
All right, for the jury.
Second.
All right, sit here.
See ya.
Okay, I'll switch my seat.
Our jury, the president accounted for.
Thank you, Deputy Gordon. Welcome back, ladies and gentlemen. How was lunch? Anyone risk American Deli? Just kidding. Good spot. Good spot. It's the closest. You would think that in downtown Atlanta, there would be more food options here. And Mitchell Street used to have more. There's a kind of fancy Thai place, fancy as in it'll cost you a little further up Mitchell Street called Tate Tide. I'm not endorsing any of these, but there are options beyond American Deli. If you sprint, you can get the Broad Street, but then you're gonna get sick as you sprint back because it's good food, a lot of options. It's just not within an hour. You're free to bring lunch too. Don't bring it in glass because the glass won't get through security. And don't bring anything pokey because that won't get like a knife or a fork that won't get through security either. Thank you all for being back on time. We had to work through one issue that prolonged your break a little bit. So thank you for your patience. Thank you for mixing up your seats a little bit. I do have one request for juror number one. You like to sit right there and it's great that you sit there. Don't sit down right away. Let everyone else go in first because they're like, oh, I can't get past you. So if you want that seat, just wait and pop in there. You may recall, hopefully you do, but it's been a minute. Mr. Venable was testifying. He talked about some trees and a plat and this and that. He's had his direct examination. We're going to see if there is any cross-examination from the Davids and we'll keep moving.
Do I need to re-swear in?
You remain sworn.
Okay.
So be truthful.
I will.
Good afternoon, Mr. Venable.
Hello.
Judge, may I approach the witness?
Yes, so all the attorneys have a continuing authority to approach witnesses to hand things, not to stand right in front of them while you yell questions at them, but you can always go back and forth to drop things off.
I understand that's your.
Thank you. Thank you.
Okay,
I have a
good.
question for you, Ms. Stern. You had a chance, it sounds like, over the break to look at the big survey. Are you comfortable that the big survey can be Plaintiff's Exhibit 2, or you didn't look at it at that level of detail?
I actually didn't look at it all. Council just brought it to my attention that was here, but I will take a look at it shortly after.
Take your time.
Okay. Good afternoon, Mr. Venable. My name is Casey Sturm, along with my colleague Jeff Schneider. We represent the Davids. I don't believe I've had the pleasure to meet you previously.
Right.
Okay.
Nice to meet you.
Nice to meet you as well. And I understand you're a land surveyor.
Correct.
Okay. And you're not an arborist.
No.
Okay. And I understand that you went out to the Anderson property.
Correct.
Okay. And you did a boundary, topographic, and tree survey for the Anderson residence
That's correct.
on April 6th,
Yes.
2020.
Correct.
Okay. And if we pull up, I believe it was Defendant's Exhibit 2. Not showing up. That's a copy of your survey.
Okay.
Is that correct?
Yes.
Okay. And I believe if you need to is it showing on your
On mine,
screen?
it's not
too?
showing on mine, but It says something about stay muted or unmute.
Oh, you should click stay muted.
Okay.
And then what's that one say?
Got it or leave meeting.
It says what?
It says got it or leave. It's talking about a third party or
Oh,
something.
just say got it.
Okay.
Don't leave the meeting.
Okay, now I can see
Excellent.
it. Perfect, perfect.
Okay, now you can see it. Okay, good. Okay, and your land survey, your scope of work for this project, if I understood you correctly, it was to identify trees on the entire property.
Correct.
Okay, 6 inches DBH or greater.
That's correct.
Okay, and DBH again?
It's the diameter at your breast height. Yes,
So your survey would not pick up anything under 6 inches DBH, whether it was trees, shrubs, brush, what have you.
correct.
And am I correct in understanding that the survey is based on a site visit on April 2nd, 2020?
That's correct. Yes,
Okay. And did you perform that site visit yourself?
I did.
Okay. On your survey, well, let me ask you this.
Uh-huh.
Did you walk the entire property during that survey?
I did. Mhm.
Okay. You walked easement area too?
Yes, because inside the easement areas, I also had to identify the trees, so I would have been all in that area as well.
Okay.
And locating the property corners and that and such. So,
Oh, okay. And you walked through the woods to do that?
yes, ma'am.
Okay. Easement 2 had not been cleared.
From my recollection, it was, it was trees and maybe some tall grass and stuff like, maybe a few briars, but, typical for wooded areas out in that area, so.
And you were able to walk through, no problem?
Yeah, I mean, I would have to, there were a couple areas I would have to, I carry a machete, so I have to chop. If there's vines or stuff in the way, then I have to clear it. But I don't recall having to do too much clearing out there.
Okay. Do you have any photographs from your site survey?
Typically are photos that we take are of the house and the driveway and stuff like improvements. I usually don't take photos of the actual, the tree areas.
Okay, so you don't take photos of any of the trees that you
Correct.
identify?
Correct.
And on your survey, if we look down in the lower left corner, there's some notes. Is that correct?
Yes.
In the very bottom note, what does that note say?
Yeah. Do you mind if I look at it on mine? I'm having a little trouble seeing it on the screen.
I'm fine with that. Just for your benefit, I understand I may be wrong that it blows up. Is that correct on his?
I can kind of see it. I mean, I'll have to
But you
look real
can-
close.
I don't think he can magnify. He can circle something. You would need to magnify. His screen simply shares what's on your screen, but then he can use his finger as a.
Oh, that's better. There you go. That's a lot better.
Okay,
Okay.
thank you.
I'll just go ahead and read the note. Tree type label shown here on as requested by the client's design team and needs to be verified by the proper professional prior to planning or construction. On-point survey and assumes no liability as to the accuracy of these labels.
You said on point.
On-point survey, and yeah, yes. And so basically,
I need you to.
I'm sorry,
The
yep.
court reporter didn't catch all that. Start with.
Yes.
on-point
Okay,
surveying.
I'm sorry. Yeah, on-point surveying assumes no liability as to the accuracy of these labels.
Thank you. Let me hand you a photograph. And let me ask you if you recognize the image in that photograph.
I do not recall that image, but I've probably done 300 tree surveys since then, so they all kind of run together after a while.
Okay. Do you recognize any of that as easement area 2 on the Anderson property?
I don't recall that.
Okay.
So,
Thank you very much. Now, your survey, let me see if I can get it to zoom back out. Okay. It shows 2 easement areas, is that correct?
yes,
And those easement areas are highlighted in gray.
that's correct.
Okay. And those easement areas, were they identified using the Anderson's deed and plat?
That is correct as well.
Okay. And if I look, I'm going to try to zoom in over here on easement area 4.
Okay.
Sorry.
You mean 2?
I'm sorry, 2.
Yep.
Sorry.
No, it's okay.
I was thinking Blair Witch in my mind as I'm trying to enlarge this, and everybody's probably like, please stop. On easement area 4, am I on easement area 2? Sorry, Judge. Am I correct on the corners? Tell me what we see there.
So on 3 of those corners, you see, well, if you start, let's start on if you're looking at the screen, the top left, you see a little circle that has a leader to it that's identified as a 1/2-inch rebar found. So that was a found monument that we found on the site. And then if you go down the 60 feet to the right, you'll see a 1/4 inch rebar found. And then go down the 53.27 feet, you'll see a 1-inch rebar found. The other corner was not found, so it was actually, it's just a calculated point that's shown there.
Okay. And these found areas, you were able to find those in the field?
Yes, ma'am.
I don't have any further questions for you.
Does 1-inch rebar mean like that was a 1-inch diameter?
Diameter, yes, sir. Yes, sir.
Okay. Thank you, Ms. Stern. Any redirect or anything else from the Anderson side?
Very briefly, Your Honor. Mr. Venable, you were asked to read a note just a minute ago that said tree type labels.
Mhm.
Does that mean labeling what type of tree it is?
So a lot of surveyors will do it differently, the way they identify the tree. Some will actually identify, for instance, let's say it was a dogwood tree. They'll actually specify dogwood or maple or that. Because she asked me a question if we were arborists, we're not. So we put them in 2 classifications, basically hardwood or pine. I think we showed some evergreen screenings, which are like little holly bushes, but that's our way of like limiting our liability on the trees.
And that would be if there was this dispute as to what exact type
Right,
of
if
tree
it
that
was a
was.
maple or an oak or what, so, yeah.
Thank you so much. No more questions.
Anything else, Ms. Stern?
No.
Any questions from the jurors for Mr. Venable? All right. Thank you, Mr. Venable.
Thank you.
Sorry we had to break over lunch.
Oh, no worries, no
Appreciate
worries.
your patience.
Absolutely.
Mr. Edwards, next witness?
Do you guys want to keep this?
Yes, sir. Leave at where you were, everything that was there.
Okay.
Thank you.
All right, thanks, guys.
Tracy Anderson?
Mr. Anderson, this way.
Oh, sorry.
Come on.
Raise your right hand. Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth self you got?
I do.
Lawyer, have a seat. Can you state and spell your name for the record?
State and spell your name for the record.
What's that?
State and spell your name for the record.
Okay, Tracy, Tracy, Anderson, Anderson.
All right, Tracy, there's a couple of elephants in the room. I want to just jump on them right now, okay?
Okay.
Let's talk about the fat bitch incident. You admit calling Miss DeVede a fat bitch?
I do, yes.
Tell the backstory. Well, stop before you go there. Are you proud of that?
No,
Have you apologized?
I did.
Have they said, okay, thank you?
No, she didn't. We did it with the other judge in court
Okay,
when she tried to get a temporary restraining order against me.
okay. So let's tell the backstory as to how we got to this incident where you talked to her and cussed at her.
Okay. We were laying sod on the property alongside the garage.
When you say the property, you're talking your property compared to the easement or
My
what?
property, nothing on the easement.
Okay,
Okay? We were laying the sod across there, and I'd been in a hurry all morning. I had to get to my office.
and I'd pulled my car up to the front of the house, okay? And I'd gone back down, and I was looking for some documents I needed to get to take to my office for signature.
Let me stop you right there. Where were you when you're looking for these documents?
In my basement office.
Which way does your basement office face?
It faces due south, right toward the easement.
Okay.
In the side yard.
Was there sod, were there pallets of sod out there?
Yes.
Were they in the easement? Were they on your property? Were in the street, driveway? Where were they?
They were not. They were in our property and on the street, to the best of my recollection.
Okay. What happened next?
Okay, I heard some commotion all of a sudden, and I heard this, I'm going to call the police. I'm going to call the police on you. And then all of a sudden, I see her car just go screeching off. So she'd gone out, and I come subsequently find out because
Hold on, let's wait a minute before you get into subsequently found out. I want to lay the foundation for that. But you were there and you heard her threatening to call the police.
I heard a police action. Yes.
Was it Miss David's voice?
It sure seemed like it. It was her blue Tahoe.
Okay. Wasn't the landscapers threatening to call the police on her?
No.
Okay.
No, sir.
All right. What did you do next?
Well, I went back in. I got in my car. I had to go. So as I'm driving down Habersham to go cut over to my office is over off Windy Hill Road, I called my landscaper, Jose Lopez.
All right, now, before you say what was said during that conversation, I want to establish a few things.
Okay.
You called or he called you?
I called him first and he called me back.
He called you back?
Because his workers had gotten in touch with him and he was making a move to get over there to see what was going on.
Okay. And you spoke with him?
I did.
And did that calm your concerns or did that make you even more mad?
I didn't really understand the whole gravity of the situation until I got home.
Okay.
Okay. And then we were able to see that. I was able to talk to Jose and he said that Mrs. David had scared the living.
Stop for a sec.
Yes.
Okay, the objection is hearsay?
Yes.
Okay, as to what Mr. Lopez said.
This goes to affect Mr. Anderson's state of mind for how he was feeling when he went to see Mrs. David shortly thereafter.
Okay, it's not, I don't know what Mr. Anderson is going to say Mr. Lopez said. Is it being offered for the truth of the matter of what Mr. Lopez?
It's not we're not offering it for the truth of the matter asserted. We're just offering it for the fact that the statement was made and it affected Mr. Anderson's thinking as he went to talk to Mrs. David.
Okay, Ms. Sturm, anything else?
No.
Okay, for now, I'll let it in.
All right, go ahead.
Question again, please.
What did Mr. Lopez tell you during that phone call?
He told me that Mrs. David had come out there and was screaming at his landscapers.
Okay.
And telling them that they were on her property to get off. You got to quit laying sod. The whole thing.
Anything about the police?
I think, yes, she said that. I heard the police. She's going to call the police. And that's then all it was just her screeching off.
Okay. And then obviously you saw Mrs. David sometime thereafter?
I did, yes.
How did that happen?
So
I need your question, I'm sorry.
You saw Mrs. David sometime thereafter?
Yes.
How did that happen? How did you happen to see her?
Okay, I was in my dining room with my daughter Holly, who was teaching a class, and I was talking to her. She was on a break, and I saw her come pulling down her Tahoe. I said, I got to go out and talk to this woman. This is just not right.
Okay.
And so I started getting a little amped up with her. I freely admit that, because she was just screaming at me, telling me I was a horrible person.
Hold on, let's take it step by step.
Yeah.
So you walked out the back door. Where was she?
She was in her car.
Okay. She was in her car, coming from your right to left, so the driver's window is on your side.
I believe the driver's window was facing me, yes.
Okay. And
if it wasn't, it was her through the other side, but the window was down where she could talk.
And who started the interaction? Did you first say something to her or did she first say something to you?
I did. I said, ma'am, you cannot come on my property, tell my workers not to lay sod and do that and scare them to death. These guys were all very scared, as my wife pointed out earlier, because she'd gone down there after I'd left and was able to talk to one of them.
Hold on one second, Ms. Sturm.
Well, I don't recall Mrs. Anderson testifying that she went down there and talked to one of them.
Okay, but that's his recollection. The evidence is what the jurors heard the evidence to be.
Okay. And I'm sharing my screen. I hope everybody can see it. You went to see her,
Yes.
and I'm going to call out this area. The shaded area, what's your understanding as to who owns this shaded area, easement area 1?
So you get into, just want to make sure we use the right words. Who owns, who can use, and you may have said that purposefully, but just be thoughtful about how you're asking about who owns, controls, can use.
Just asking about ownership.
Okay.
Who pays taxes on it?
Okay.
Who owns it?
I pay taxes. I'm the rightful owner.
Okay. Did you, all right, keep going. You went to talk to her. You said what you said about don't confront my workers. Where were you standing at this time?
I was on my pathway across from the brick turnaround.
So somewhere around here?
Yes. No. Yes.
Okay. Did you ever jump the wall? Because there's, what is this area right here? It says neighbor's wall. What is that?
It's just a 4.5, 5 foot brick wall.
And did you jump the wall?
I did not.
Where did you end up? I'm going to use my little laser again and stop me when you stopped.
Go back into the circle. Kind of corner, caddy corner.
Right there?
No, yeah, just go back, straight back now.
Straight back?
Yeah, so right in the middle.
Right around there?
No, over here a little bit.
Which way? My right?
To my left.
This way?
Yeah,
Okay.
this way to the left.
Okay.
So it's over here, Randy.
So keep a mark on the screen.
Okay.
That may be more helpful if we have the witness mark it.
That certainly would be.
Yeah.
What you need to do, tap the screen once,
Yep.
and then there should be a little pencil icon in a circle that shows up on the left of the screen. You just mush your finger on the screen once, tap, and then take finger off. Is there a circle with a pencil in it in the left-hand corner?
There's a circle with a smiley face.
No, that's not it.
That's
Deputy Gordon's gonna help you with this, because I just
Yeah.
wanna.
Yeah, it's not there. The pencil's not there.
Once we empower you, then whenever you touch it, you'll be making a mark. That's not doing what it's supposed to do. All right, we'll get IT to fix it during the break.
All right.
It is a fancy touch screen when it works. Sorry, Mr. Brandon.
It's all right. Can I show him by going around?
Yeah, why don't you just go to the big screen?
Yeah, come here to the jury and I'll mark it on my iPad.
So here's our house, and this is the dining room, and this is the pathway. It comes around and goes down to here, and then across all the way to the detached garage. I was standing right about there.
Around here?
Yeah, a little back, actually. I was probably a good 15, 16 feet from the gate.
So you told her, don't confront my workers. Did she apologize?
No, sir.
She didn't say anything about apologize for the misunderstanding. It's not anything like that.
No, sir.
What did she say anything?
No, just when I went off after.
Well, what did she said something
About, to me?
Yeah, to you about you. Did she say anything to you about you?
She said I was a horrible man that had multiple wives.
Have you had multiple wives?
I have not.
How'd that make you feel when she said that to you?
It was an absolute insult. It was an insult to my wonderful wife of 27 years. And that also was a thing that got me kind of angry that day.
Okay. What did you do in response to that?
Well,
or what did you say? What did you say or do?
I called her a fat bitch, and I said, and you can die from being fat. And you got to put that in when she says I'm going to die. That's not it. There was context there. There was context to what I was trying to say.
Okay. What happened after that?
Walked off.
What's the context of you saying you could die for being so fat? But maybe
Well,
I'm missing it.
well, the context is I was very angry.
Okay, the context you gave as to here's why I may have said something indicating I was angry.
Yes, it was purely out of anger at the moment, and I normally don't do that. You know, I'm a former CEO of a biotech company. I had 265 employees in Miami of every type of person known to man. Okay. And I think if you talk to any of my employees, they would tell you that number one, I was a really good guy to work for, and they had a lot of fun working with me, and we did things the right way. I'm not a racist. I mean, for them to say that and to call me that, it just.
Okay, we're not.
All right, let me just
I was
ask a question.
asking about context.
All right, let me ask the question about is there anything else about this incident? Did you jump the wall? Did you threaten her? Did you attack her?
No, I was never closer than 15 to 20 feet from her.
Did you set foot on her property?
I did not.
Did you set foot on the shaded area that you own and pay taxes on, but they have easement rights?
I did not.
Okay. There's another elephant in the room. Let's talk about that. You heard Ms. Sturm in her opening statement say that let me stop right there. How many times in your life, from the date of birth until today, have you had interactions with Stacy DeVee?
Once.
Okay. We had a hearing on the TPO with Judge
Well,
Manning.
if you consider that, it'd be twice, but that was on a Zoom call. It wasn't like where I saw her in person.
Okay.
I've seen her once in person until yesterday.
Okay. So yesterday, Ms. Sturm, in her opening, said that you yelled at Ms. DeVee. I can't remember if she said either this is not the first time or the last time, but any other interactions where you yelled anything at Ms. DeVee?
No.
And Ms. Sturm used a very, very offensive term. Algerian, I'm not even going to say it. Did you ever use that term to anyone in the DeVee family?
I absolutely did not. I find it so reprehensible that that's being said, that this is being brought up. This is a land dispute and they're trying to make it into a racial thing. And it galls me to even think about that. I'm born in Atlanta, Georgia. I'm from here. I grew up here my whole life. I went to school here at the University of Georgia. I've tried to do everything, give back to our community. I've tried to be a good citizen. I've never had anybody call the police on me until Mrs. DeVee called police on me. And they came over and they were like, sir, I think the police officer, he said, sir. Okay.
Just
Keep them focused.
Just for the timing and not the all.
Okay.
Do you recall the first time you heard any claim by Ms. Sturm's office that you had used that slur in any way in this case?
Yeah, I think it was like about 10 days ago.
No, let me hand you.
Was it late, a couple months?
And the date of this email, I'm not going to offer, I'm just using this to refresh your recollection. What's the date of this email from Ms. Sturm to me?
November 9th.
Of last year.
Yes.
And she references this slur.
Yes.
In here, right?
Yes.
This slur, this racial slur. Is this the first time that you were ever advised or accused of using this slur in the history of this case?
The only time.
Well, until yesterday.
Yes, until yesterday.
Was there anything significant that happened in this case around this time that you think precipitated this false accusation?
So no speculation. You're
Okay.
welcome to.
Is there anything you can point to of significance in the history of this case around this time?
They were denied cert from the Georgia Supreme Court just days before that letter came out.
Okay. Thank you. Let's we also heard something about a gun with Hopkins. You remember Ms. Sturm talking about that in the opening? And I believe, at least in the email correspondence, they had referred to that as brandishing a gun. Do you know what brandishing a gun means?
I do.
1 second. Yes, ma'am.
But, counsel is testifying as to things in emails, but that's not coming from the actual witness.
Okay.
So
So.
rephrase his question.
Let me rephrase the question. Have I forwarded you an email from either Ms. Sturm or Mr. Schneider where they used the words brandishing a gun at Hopkins David?
Yes, you did.
Okay. Did you understand what brandishing meant at that time?
My definition of that would be waving something or holding it up and pointing or doing something with a weapon that I would never do.
Okay. And do you recall an incident where do you recall videotaping Hopkins on this occasion when you were allegedly brandishing a gun?
I don't recall that I was videoing at that time.
You videotaped Hopkins at some other time?
When he's out on the property, the lawyers asked me, just show if they're out there and let us know.
Okay. Let me,
yeah.
Plaintiff's Exhibit 45 is a capture, Plaintiff's Exhibit 60 is a capture of Hopkins David video that Mr. Anderson took. You remember you took at least 2 videos, right?
Probably 2, yeah.
Okay. All right, Your Honor, we're going to offer Plaintiff's Exhibit 60.
Okay. So 60, you're saying Mr. Anderson would identify because he made the video.
He made the video.
This is something we've talked about outside the presence of the jury.
Yes.
I don't have any authenticity issues, assuming 60 is what he's saying. We'll find out in a minute when it plays, assuming it is what Mr. Edwards is saying. Any objection to the admission and publication of plaintiff's 60?
No.
Okay.
Okay. All right, I'm going to play this and hopefully we can see from my iPad how it goes, and I don't know if we're going to be able to hear it. All right, come on, start playing. This is, let me go output. There you go. That's not working. All right. Judge, we're having technical difficulties. I was not expecting this.
You're having technical. You can have a colleague try to get it to work while you continue your examination of Mr. Anderson.
Well, do you recall when you were recording Mr. David, young Mr. David, that he picked up his camera and started taking pictures of you?
He did.
Have you seen any pictures that young Mr. David took, pictures or videos of you brandishing a gun?
No.
Okay.
Because I wasn't.
Did you have a gun that day?
I did. I'd been at Stoddard's at the range, and I had it in a casing, and I got it out of my trunk, and I didn't realize the young man was over there on the easement. And I pulled the gun out. It's in a case. You can't even tell it's a gun unless you were asked. Okay. I walked down to my mailbox, got the mail, and turned around and took the gun safely to the house where it was put in the gun safe.
Okay.
But to say I was brandishing a weapon around a young boy, that's just completely false.
Knowing the Davids the way you do you think, speculation, we'll save that for closing argument. Okay, let's kind of back up a little bit. That's not working either. All right, I apologize. All right, let's kind of back up to the beginning. Mr. Anderson, your wife talked about y'all looked at this property before y'all got married. Tell us about that.
So before we got married, we were looking at houses, and we were trying to decide whether we wanted to try to rush and buy a home quickly or lease a home and have time to take some time. So we didn't end up buying the house that time. We went and leased a home for a year, and then we bought another home. And subsequent to that, this house came up for sale back in 2018, and we acquired the house and moved in.
Okay. And in the intervening years, would you drive by the house from time to time?
Time to time. Just a lot of times that West Andrews and Chatham are cut-through streets between Habersham and West Paces Ferry Road, so it's there's a lot of drive-through there.
And when you drove past it on these cut-through occasions, did you kind of glance at it and think, hey, whatever.
Yeah, sure.
This nice house. During that time, did you notice what the frontage looked like on West Andrews over these intervening years?
Yeah, just south of the driveway, it was just all overgrown. Just all overgrown.
Okay. Plaintiff's Exhibit 22, Your Honor, is Google Earth screenshots, street view images. Oh, let me go back. Don't show that yet. Street view images. Mr. Anderson can authenticate those if I have to do that first and agree, or however they want to handle it. But
Which exhibit?
Plaintiff's Exhibit 22, Google Earth screenshot images, 5 pages, over several years. And I'm afraid if I go up there and show him, well, actually, you have the notebook in front of you.
If you'll open
Flip
that,
over to tab 22. Thank you, Judge. I almost forgot that.
I'm there? No, 21, sorry.
That's 21. Thank you. It's 22.
Yeah.
All right. You're looking at those Google Earth Street View images. The first one is, can you read the date on that, of the actual picture?
I don't see the date.
Should be the top left-hand corner.
No, it's not there.
Okay. Does that look like, do you recognize that as a street view image of what is now your property?
That's correct.
And same for the next 4 pages, is those street view images of what is now your property?
So where I can. Yes.
Okay. All right, Your Honor, we offer Plaintiff's Exhibit 22.
any objection to plaintiff's 22?
No objection.
Admitted.
All right. Mr. Anderson, I'm showing the jury the first page of Plaintiff's Exhibit 22, and let me use my little handy dandy call out feature. Street view August of 2012.
Okay.
Can you kind of generally describe for us, and I'll do this the easy way or the hard way. Roughly where is easement 2?
Easement 2, can you see the fence on there? Picture? I can't see.
No, this is before y'all bought it. This is 2012.
Okay. Easement 2 is down past here, kind of about halfway through the picture it starts.
Okay. Somewhere around here to this way?
Right, a little south.
Around here?
Yeah, a little south of there even.
Okay. Next page. This is from August of 2014, a couple of years later. Does it look like anyone is using this for ingress or egress or any?
No.
Objection. I mean, it calls for speculation.
So don't ask him his opinion on that. You can show the pictures.
Okay. Third page is an image taken from October of 2018. Did y'all own the property at this time?
We did.
Okay. Had you started any clearing of easement 2 at this time?
I'd started probably that time, I'd started going in there, it's like you heard earlier, Marty Paget, who was Ann Nykirk's yard man, he was with them for 20 plus years, and he had taken the easement area, he'd made a path that goes back through there, and he would just take grass dumpings, bottles, railroad ties, anything.
Okay, let's not talk about what Mr. Paget may have told you. I want to talk about what you personally observed with your eyes. When you bought the property,
Yes.
did you see any evidence of anyone from next door using it for ingress or egress?
Never.
Describe for the jury the condition of easement 2 when y'all bought it in September of 2018.
Well, it was just so overgrown with brush and vines and weeds and just all kinds of little nuisance trees, those little skinny little type trees that are about that big around that would go up, and we just started clearing it out. And There was huge stumps back there on the property that were in there. We had to get that removed and pulled out. I mean, it was a big pine tree that had probably fallen over years ago. And we just cleared the place up as best we could and tried to make it look better. Just like my wife said.
Okay, railroad cross ties.
Yes, they were back
Tell us
there.
about that.
But they're just, the house initially had a bunch of railroad ties around it. And they were starting to rot out, and I found a couple of copperheads up by the house where I was able to kill them and pull them out. But back when we were cleaning out easement area 2, I killed 12 copperheads.
Where were they at?
They were in easement area 2 and on my side of the yard as well.
Okay. And the railroad cross ties, well, had there been railroad cross ties thrown or trashed into easement 2?
Yes.
Okay. What about plastic and bottles and other types of trash? Was that in easement 2? Tons. How would you characterize easement 2 in this fall of 2018, spring of 2019? Was it an area of peace and beauty or natural beauty, or was it something else?
I mean, I thought it looked really horrible. That's why we wanted to try to fix it and make it look better.
The 4th page of this exhibit, November of 2019. This is after y'all have been there for over a year, is that right?
Correct.
And let me just call out all of this. Have y'all done any clearing or cleaning of easement 2 by this time?
Maybe a little bit.
Okay. And the grass, if we look at the grass in the yard from 2019 versus 18, has the grass been extended?
Grass has been extended, yes.
And has any ivy been removed from easement 2 between 2018 and 2019?
Yes, oh yes, definitely. That's where all the snakes are.
Okay. And the 5th page of this exhibit is dated also November 19. Where in relation to the property is this on the 5th page compared to the 4th page?
This more southern end of the property.
Okay. So is that the street frontage of easement 2?
Yes.
West Andrews?
Easement 2 is on that street frontage there, yes.
Now, Ms. Stern said in her opening, I believe, that the workers used easement 2 for ingress and egress, not your fee simple property. Did you ever see any workers hiking through this brush, or did they just walk around your house?
They walked up my driveway. They would come, if they were down the street or up the street, either way, they would walk down to my driveway, and I'd built a stone path up around the side into the back of the garage. And their workers would just come up and go right across my driveway, right across my property into their property. So it was just happening over and over and over, and we didn't know who was coming around the house or who wasn't. So then a bunch of ladies were like parking their cars down there and going over to see Mrs. DeVee, and they would come up there. And one lady, I asked her, I said,
well, don't get into what you talked to these ladies about. I'm just asking about what you personally observed. Did you ever observe any workers or visitors to the DeVee property go through all of this brush on easement 2 to access their property?
Never, ever.
But did you personally observe them using your fee simple property?
Yes.
Did you complain to either of the DeVees about this?
I have not.
Okay. We heard a lot of talk about the trash. Tell me what you know about that based on your personal observations, not what you've heard from third parties.
My personal observation is my now son-in-law took some items over there and threw them in the dumpster because we had no room in our trash cans because they'd been blocked off.
And did you have a discussion with Mr. DeVede about this at any time?
I did.
Tell us about that.
Mr. DeVede came over one evening while I was grilling for our kids and knocks on the door. I went to the door and he said, "Why are you throwing stuff in my trash can? Why are you throwing stuff in my trash can?" And I said, "Sir, my son-in-law put this trash in there because you all with your workers had blocked off blocked off this whole area, okay, where we can't even get trash pickup. So that was the case.
Okay. Did he apologize?
I think he might have apologized that time. I think he might have said, "Oops, sorry," and he said something to the line of, "It smells really good back there." So.
Talking about the cook, your
Yes.
hot dogs? Did he say, hey, we need to get together for dinner sometime or anything like that?
No, sir.
Didn't invite you over for a drink or ask for one or anything like that?
No.
Didn't ask for a hot dog?
No.
Would you have given him one?
Would you have given him one?
I probably have to, right?
Yeah, I mean, seriously, would you have given him a hot dog if he'd asked for one?
Sure.
Only on the easement.
Sure.
After the garage, not the garage incident, after this incident that you personally had with Mr. David, did you have any other incidents other than the one on the, with Mrs. David?
No.
Okay. Have you ever, other than that one occasion and being in court the last 2 days, have you ever physically been in the same room with Mr. David?
I don't believe so.
Other than that one incident, have you ever said anything to Mr. David?
No.
Did you see him out at your property a week ago?
I did.
When was that?
It was on a Sunday.
Sunday?
Yes.
Where was he?
He was walking across the easement area too with some other gentleman.
Okay. Now, after this incident with Mrs. David, what was the next contact or communication you had with either the Davids or anybody representing the Davids?
The next contact I had was with us going to court for the TRO to get it knocked out.
Do you recall getting a letter from Ms. Sturm?
Oh, yes.
Shortly after that?
Yes.
Plaintiff's Exhibit 3 is a redacted version of the letter that Ms. Sturm wrote on February 26th. We offer that, Your Honor.
Ms. Sturm, any objection to plaintiff's 3 as redacted?
No objection to plaintiff's 3 as redacted. I have given some broad birth here, but I think we've had a lot of leading questions, and I would just ask that council address that.
Okay, so let's keep the questions open-ended for your witness. They can be precision sharp when you're cross-examining, but we're hearing from Mr. Anderson and not from you.
I understand, and I will try to do better. All right, Plaintiff's Exhibit 3, let me share that with the jury. Is this the letter? Let me flip through it. It's 3 pages. Part of it's redacted. Do you recognize this as the February 26th letter that Ms. Sturm sent to you?
I do.
And the letter is going to be into evidence, so I don't need to go over this in detail. What was your reaction upon receiving this letter?
Well, I was pretty much kind of shocked.
Why?
Just because I just was like, what are they doing? What are they thinking?
She says in here, let me do a little highlighting, that you've trespassed onto David's property, unlawful clearing.
Stop for 1 second. Did you have this is just an excerpt from a letter that's in
Yes,
evidence.
yes,
And you can highlight as he sees fit.
yes, I don't disagree with that. Is he asking a question about it?
Okay.
If I was.
You don't need to read it. You're the last one really who should read it.
Okay.
It's in evidence. The witness can read it. It's on the screen.
I'll just highlight it and then I'll ask the question. Do you see here where she's accusing you of cutting down trees and unlawful clearing without an arborist permit and other vegetation?
Yes.
Is that in any way, shape, or form true?
It's 100% false.
Do you see where there's lots, this full entire paragraph is about surveillance cameras. Did you have any surveillance cameras pointing at the David property?
No.
Did you have any surveillance cameras directed at easement 2?
No.
Did you have any surveillance cameras directed at easement 1?
No.
And finally, did you view this as a message that you're about to be sued by Ms. Sturm?
Well, when somebody threatens to put a lien on your property, you have to expect that's the case. So yes,
Did you get a lawyer to respond to this letter?
I did.
Who was that lawyer?
Mark Ruschi from Alston and Bird.
Plaintiff's Exhibit 4 is a letter from Mark Ruschi to Kimberly Sturm. We offer that, Your Honor.
Any objection to plaintiff's 4? Okay, 4 is admitted.
All right, 4 is admitted. I'm not going to go over this in much detail. The jury will see this. Did Mr. Ruschi, who's Mr. Ruschi?
He's a real estate lawyer here in town.
Okay.
You know, retired now from Alston Bird.
Friend of yours?
Good friend, yes.
How long have you known him?
I've known Mark, I guess, about 5 years.
Okay. And did he basically respond to her allegations?
He did.
After this letter, did anyone from the Davids or Miss Sturm follow up and say, "We sorry for the misunderstanding," anything like that?
No.
Did you think this matter had been kind of put to bed by the time you sent, Mr. Ruschi sent this letter?
I thought so, yes.
Obviously not. What happened next?
Well, I mean, we filed suit against them.
Was there something in between Mr. Ruschi's letter and us filing the lawsuit, the TPO?
Oh, yeah. So yeah, I mean, they,
Objection, Your Honor. The counsel continues to lead the witness.
Well, yes and no. He does offer commentary, like obviously not, and then ask the question. But that's not your objection. I don't have a problem with lawyers on either side providing some context to get a witness oriented to where, not the answer they're trying to get, but where chronologically they're trying to get. And Mr. Anderson, it sounds like he's out ahead of Mr. Edwards. And so for Mr. Edwards to say, well, let me give you some framework here, I don't think there's an issue with that. So I'm gonna let you frame it to get Mr. Anderson chronologically where you are. And then I trust you will stay focused on asking open-ended questions when it's your witness.
I will certainly try.
Okay.
Do you recall being served with some papers from a Fulton County sheriff a few weeks after Mr. Ruschi's letter?
yes.
What was that?
She tried to get a temporary restraining order on me, and we had to go to court to beat it down.
And who represented you in that court hearing?
You did?
Okay. And who represented Miss David in that court hearing?
Ms. Sturm?
Okay. Actually, Brandon Arnold.
No, that's right. That's right. Brandon, what's his name?
Yeah, Brandon Arnold from her office.
Yes.
Arnold.
Yeah.
And Miss David testified, is that right?
She did.
And you testified.
Correct.
And during your testimony, did you say basically the same thing you said today?
Yes.
And the result of that TPO hearing was?
It was beat down.
And we filed suit. I'm not sure if it was before or after the actual TPO hearing, but we filed suit, right?
Yeah, I think it was after, I believe.
Was there any doubt in your mind that there was going to be a lawsuit one way or the other?
There was zero doubt in my mind, unfortunately.
Okay. Before the TPO was sought and obtained, did anybody from the Davids come over and say, hey, you know, we need to stand things down a little bit? Can you agree? Can you apologize to my wife or anything
No.
like that? Okay. We've heard a lot of talk about your intentions to do a lot of clearing and landscaping and all of that stuff on easement 2. And when did you begin planning to do more work on easement 2 than you had already done?
I think we started talking to Alec in sometime in late 2019, maybe. And we were talking about what we could do down on that area and what we could do also on the north end of the property.
Okay. And Alec's last name is what?
Nicolaitis, I think, something along that line.
Okay. And Land Plus Associates, is that his
Yes,
firm?
that's correct.
Okay. Plaintiff's Exhibit 5 is pages 1 through 7 of the documents produced by LPA to Ms. Sturm's office in response to RFP that they served on him. I offer that.
Ms. Sturm, any objection to the admission of plaintiff's 5? While you're thinking about that, ladies and gentlemen of the jury, an RFP is just request for production. Lawyers, while they're engaged in discovery, can send a subpoena to a non-party like Land Plus Associates saying, we'd like you to produce for our consideration documents X, Y, or Z. And what Mr. Edwards is saying is that whatever documents are in Exhibit 5 were things that actually the David's lawyers asked for from this landscape. That's all RFP means. Ms. Sturm, any objection to plaintiff's 5?
I'm going to object to the extent he's trying to get information within those documents into evidence.
Because it's hearsay.
It's hearsay.
Okay, so Mr. Edwards, I think I'll admit these. I don't know that they'll go back with the jury. And you'll need to be thoughtful about how you use them other than to provide Mr. Anderson maybe with a frame of reference for what all was involved. But these are, I find that they're statements of Mr. M, the landscaper, and not statements of your client.
Well, there's back and forth, but I'm just offering them for the purpose of establishing the timeline for when these plans began.
Great.
Okay.
So they're in, whether they go back to the jury or not, we'll decide later. And Mr. Anderson can certainly refer to them in response to your non-leading questions about when things happen.
All right. The first page of this exhibit, Mr. Anderson, is an email from whom to whom? That's not leading, is it, Judge?
It's from me to Alec.
Dated?
3/11/20.
Okay. So without really necessarily reading the document, tell us generally what's going on here.
So we'd talked to Alec about maybe doing a complete full landscaping of the entire property. And that's what we were doing. He made a landscape plan that he presented to us.
And the next page, the next couple of pages are a detailed proposal. And again, we're not going to get into the details of that, but the date of this proposal is what?
February 11th, 2020.
And then did you proceed to do anything in response to this landscape plan?
We didn't hire Alec for the plan. We didn't hire him.
Okay. Did you hire anybody?
No, we just brought in some workers and everything to help clean out that horrible area that was back there.
Okay. In the sod?
Yes.
And
that was later then.
Did you, when you were doing this clearing of easement 2, did you plan to do any installation of any type of vegetation?
Well, we were thinking about doing grass to get started with, and then we were going to probably hire a landscape company and try to figure out a plan.
Okay. And we've heard questions of your wife and some statements in opening statement about your intentions. You intended to do landscaping. You intended to do that. Did you in fact intend to do landscaping in easement 2?
Yes.
Have you since the sod incident?
Since the sod incident and the lawsuits, we haven't done anything.
Why not?
because we wanted to see this through and do it the right way.
Okay. Have the Davids reciprocated and said, we're not going to do anything either until this case is over?
No.
What have the Davids done on easement 2?
Well, they put up a lacrosse goals, some nets, some different, rotted out, these things they put out there. It's like a rotted piece of lacrosse equipment.
Let me just stop you right there. I've got a number of pictures I want to introduce into evidence. P Exhibit 6 is a photograph that Mr. Anderson took of some netting on easement 2.
So what would be great is if you want to get them in all at once, rather than we do one at a
Perfect.
time. So 6 through what would you like Mr. Anderson to look at?
6 through 11.
All right, so Mr. Anderson, if you just take a quick look at those 6 through 11, let me know if you're familiar with those photographs.
6, I'm familiar with that.
Okay, 7. Just take a minute, and when you're through, look up and I'll ask you just one question instead of a bunch.
Mhm. Okay,
Did you take all those pictures?
I did.
Why did you take them?
To get them to you.
Okay, we offer 6 through 11, Judge.
Any objection to plaintiffs 6 through 11?
No, Judge.
They're admitted.
All right. Plaintiff's Exhibit 6. What is this?
It's some like raggedy chair that was placed on the easement area.
Okay. Did you remove that?
I did.
And do you still have it?
I don't know if I have it or not.
Okay. Plaintiff's Exhibit 7, what is this?
Some type of lacrosse goal.
The ground in front of that lacrosse goal, is it nice, good, firm footing, or describe the footing for me?
Soggy and wet.
I'm curious about the easement. You've described it as impassable, impenetrable. Is what we see in plaintiff 7, is all of it the easement, or the net is on the easement, but all of this, I'm gonna call it leaves and whatnot, is that on the David's property?
No, that's in the easement. Where that goal is down at the very southern end of the easement.
So a whole bunch of the easement is actually wide open.
Wide open because I cleared it out. Cleared it.
I'm confused because you said you had never cleared it, and
No.
it was 100% false that the David said you were clearing the easement. I don't see, I may be missing it, but I don't see trees and snakes and bushes and whatnot between wherever the camera was and this lacrosse goal.
That's because they had all been pulled out.
Okay,
Let
and who pulled it out?
I did.
Okay, and when did that happen? Ballpark, I don't mean the specific. date.
Sometime in the 20s, 2020, 21, somewhere in there.
So parts of the easement then aren't, we saw some pictures where it looks like you would need the machete like Mr. Venable had.
Yeah, if you look at that picture and you go to the left, that's to the road to West Andrews. It's just all vegetation overgrowth.
Got it.
And then if you go to the very back along the David's property line, that's where you see their property.
Okay, but this area where it looks like leaves and whatnot.
Yes.
It is open, it's open because you made it open, but that is part of the easement. That's not, I think Mr. Edwards would call it your fee simple. It's not David property. This is easement. Everything we see on the screen.
That's correct.
Okay, thank you. That helps.
From the net forward, is that easement area?
That's easement area 2.
From the net backwards, all that trees and everything else, is that also easement 2?
No, the easement 2 ends at Dr. Elliott's property next door.
But have you cleared all the way to the edge of your property, or is there some portion of easement 2 that you've never done anything to?
Yeah.
All right, can you give us a ballpark for what the approximate cleared area is?
Maybe 60%, maybe
Okay.
40, 50%.
If
Okay.
you put up 8, you were probably gonna get there anyway, but Mr. Anderson can help there. Is that all, everything we see in there, easement 2?
Yes.
Okay. That's one of those split trees we heard Mr. Venable
Yes.
talk about, where he said one of them is 13 and the other is 32.
Yes.
Okay.
9?
What is this?
It's some lacrosse thing, and it's like, if you go back there and would look at it now, it's kind of like rotted out.
Okay. And we have the pine straw to the front of it and some weeds and stuff behind it. The portion to the front, is that easement too?
To the left,
But to the front of us, between us and the,
that's easement too.
okay, and behind it, is that easement too, or is that the David's, or is that Mr. What's his name's property?
That, I can't tell from that particular picture if that's the Davids or if it's to Dr. Elliott's.
Okay, that's fine. Exhibit 2 is another angle. We have 2 nets. What's going,
Yeah, that's south to Dr. Elliott's property.
because there's a pink ribbon back there. Is that the property line?
Yes.
Okay. And 11 is the last one. What's going on here? What is this a picture of?
Well, right after we started the lawsuit, within maybe a week or two, all of a sudden, they'd never been out there. All of a sudden, I see Mr. David out there with 2 construction workers, and he's like making a path and cleaning it and just then leaves all the junk out on the street.
Okay.
Just so I can be oriented, this path that's cut through there, would it lead to where then we'd see all that lacrosse gear?
Yes.
So this would be part of easement 2 that remained overgrown after you did some clearing work?
Yes.
And they did a little bit of clearing work with the Davids, which created that little path we see.
Yes. And I don't know what trees or anything were taken out there, if there were or not. I just don't know.
Did you ever do any clearing of the street frontage portion of easement 2 so that people could walk from West Andrews to easement 2 and vice versa?
Never.
Why not?
I just didn't want to do that. Didn't want to have that
Okay.
for myself.
Plaintiff's Exhibit 13 is a video of the street frontage of West Andrews. You familiar with that video?
Yes.
We offer Plaintiff's Exhibit 13. Hopefully it'll play on my iPad.
What year was this?
We're on plaintiff's 13.
Yes. Now,
Or the photo, I don't know who just asked that question. I couldn't see.
juror number 1, let me,
Don't ask questions out loud, jurors. You gotta write them on card.
Mr. Anderson, those nets that we just looked at, all of those pictures, approximately when did those first go in to easement 2?
Right after we filed.
So after the lawsuit?
Yes.
Did the Davids reach out to you and say, hey, we want to put our kids' sports nets on the easement? Do you have any objection?
No.
Did we complain about it?
We did a little bit.
Did they say, oh, we're sorry?
No,
Are they still there?
they're still there.
They were there this morning?
They're there this morning.
Approximately how many times have you, so shortly after filing the lawsuit to now, roughly 3 years?
Mhm.
In the 3 years that those nets have been out there, approximately how many times have you seen anybody using them?
No more than 5 or 6 times.
Okay,
Your wife testified that you travel a fair amount, at least you used to.
I do.
How often are you around on weekday afternoons?
Well, I stopped really traveling a ton, Judge, back in 2020 when I stepped down from my role as CEO of IVEX.
Okay, so you've been, some of them homebound.
I've been more homebound than previously, yes.
all right, so we haven't even talked about what you do for a living. You mentioned Vivex. What is Vivex?
IVEX is a biologics company and biomedical manufacturing company.
And you mentioned Windy Hill. Is that the headquarters?
We know that our main headquarters are in Miami, where we have 265 employees there. And then I keep an office in Atlanta with essentially our sales group and our accounting, because, flying out of Miami is a difficult footprint. So we use Atlanta for that. But to answer the judge's question, I was in Miami a lot up until 2019.
Okay. 2019, the Darby's still on the property. Did you ever see any signs of life from the then Darby's, now David property?
I have not.
Did you see any lights on at night or cars coming and going?
I never did.
I was going to show plaintiff's exhibit 13, a video taken August 12th, 2021. You familiar with this video?
It's not coming up.
I know, I'm going to wait. Are you familiar with it? And then I'll offer it. Well, I'll offer it now.
I believe I am, yes.
Okay, we offer plaintiff's exhibit 13.
Any objection to plaintiff's 13? Do you know which video this is, Ms. Stern?
It's street frontage one. August 12th. 30.
No objections.
All right, 13 is admitted. Good luck, Mr.
I know it works on my trial pad normally. I think the Zoom is to conflict.
So when you do share screen, there is a little box you're supposed to check in the lower left-hand corner, 2 little boxes about optimized video and audio. Make sure you.
Optimize for video, it says optimize for video off, so I need to click on. Thank you, Judge. Now, let me pull that back up. Everybody say hi to my wife and daughter. All right, let's try this again. Well, I know I can advance it second by second. Well, let's see, is it playing? All right. Well, I tried to optimize it, it's not working. All right, here we go. I'll just advance it 10 seconds at a time. And hope we'll get a computer for the jury tomorrow. That will be better. All right. August 12, 2021. Was there anything going on in the case around this early to mid-August timeframe? And let's not get into real details, but just tell me generally, was there anything going on as far as, well, tell me what you know.
I mean, I can't go back to that date and just think that I know. I don't know.
Okay. Shortly after, plaintiff's exhibit 14 will offer this clearing video.
No objections, Your Honor.
Okay, 14 is admitted.
And hopefully it'll play, but I'm not optimistic. All right. So I'll just have to scroll through this. These big pink and yellow ribbons, did you ever complain about these pink and yellow ribbons to the Davids?
No, I mean, I'd just say that just obnoxious looking. Claire and I both felt like they put those up just to say, you know, don't come across this.
Okay.
It's ours.
We see some people down here. What are they doing?
I think they were making that path.
Okay. All right, plaintiff's exhibit 15 is another copy of the clearing video. We offer that.
Looks like the next few are videos. Are they all similar? So you could offer them all up at once? So Ms. Sturm could say, I have no objection, or I do to the remaining videos? Not that you're gonna be able to play them, but you can get them in evidence.
Yeah, I'm going to get them into evidence, plaintiff's exhibit 14, 15, and 16.
No objection. I just want to make sure that, you know, there's audio with some of these and we need to make sure that's clear.
Okay, well, the whole file is admitted, and so should the jury want to review it during deliberations, I think if we play it through a different platform, it'll work. I don't control which platforms the lawyers select, but all the videos are admitted.
Thank you. And also 44 is a August 15th video. Plaintiff's exhibit 44, August 15 video. So I was at 15 is admitted. This is another video of the clearing, the workers. I'll just scroll through that.
Mr. Anderson, are you making these videos? Are you the producer of the videos?
Yes. Plaintiff's Exhibit 16. Tell us what's going on and I'll scroll through this in 10-second intervals.
So I'm out there and Mr. DeVee just comes walking on there and just starts setting up all this equipment on the property.
Okay. And I'll just scroll through in 10-second intervals. Do you recall Mr. DeVee picking up his phone and placing a phone call?
Once I started filming him, that's the first thing he did.
Okay. Did y'all have any interactions yelling at each other back and forth? You didn't yell at him and call him
I didn't say
racial
anything.
slur?
No,
Did he threaten to call the police or ask if he should call the police?
no, he didn't.
Okay. Okay. And then Plaintiff's Exhibit 44, the August 15 video, I offered that, was that objected?
We hadn't gotten to it. Any objection to plaintiff's 44?
No, Judge.
Submitted.
Okay. Did you take Plaintiff's Exhibit 44?
Yes,
Why did you take that?
just to be able to show that there was a path being cut through so I could get it to the legal team.
Okay. Let's see if that works. No, it doesn't. All right. Go back to my document side. Plaintiff's Exhibit 58, a before and after comparison of West Andrews. We offer that.
Which number?
58.
Stern, any objection to 58?
I object only that I don't have foundation. I don't know where the comparison is coming from. I don't know if this is for demonstrative or
Let me
put them.
do Mr. Anderson can authenticate the photographs if you want to ask him a question. Mr. Anderson, you see Plaintiff's Exhibit 58, that side-by-side comparison?
I did, yes.
Can you tell the jury what that is?
So that was before and after Mr. DeVee cut his path that's already kind of grown back over.
Okay. And the dates on that that are superimposed on that, are those accurate?
Yes.
Okay.
Sturm, anything else? I think he's laid a foundation.
No objection.
All right, I'll admit 58.
So what's the purpose of this?
What was the purpose of this?
Yeah.
But you can ask him what it shows.
What does this show?
It shows that a path has been cut through from the top of the easement area down to West Andrews.
Okay. All right, 1 second, Judge. Okay. Tracy, I just want to make sure we're all clear on the timeline. Stop my share. On the timeline of what happened. When did y'all buy the property?
We bought it in, I believe it's September of 2018.
Okay. And the DeVeeds, what's your understanding is when they bought it?
I think probably a year and a half or later.
Spring of 20?
Yeah, probably.
Between the fall of 18 and the spring of 20, did you do some clearing of easement 2?
Yes.
Did you continue doing clearing after the DeVeeds bought their property?
Yes.
Did you continue to do anything on easement 2 after you got the letter from Ms. Sturm in late February of 21?
No, I mean, I've taken some equipment and removed it and put it back over in their yard or put it down over in the yard, but other than that, nothing.
Okay. You have you planted any bushes or trees or anything like that on easement 2 ever?
No.
Have you, why not?
I haven't now because we've been in this lawsuit. and I want to get this adjudicated the proper way.
And the condition of easement 2, when you bought it, before the Davids ever looked at it, I'm talking the late 2018, first half of 2019, describe for the jury whether it was a natural beauty, nature preserve or something other than that.
Okay, it was not a natural nature preserve, it was a dumping ground. Okay, and it was a dumping ground for the guys, the local guys, yard men in the area. They would come back and do this, especially the one that worked for Ann and then worked for our neighbors across the street. So they would take them back, they would drive it across my driveway and take it back into there and dump. And that's what I had to clean
Stop
up.
for a second. Yes, ma'am.
It's hearsay, speculation.
Well, if you want to ask him how he knows these things,
Okay.
sounds like he could eyeball some of this stuff, as in he would see it, but if it's what, hey, my neighbor told me he was gonna dump some railroad ties there, let's not get into that.
I don't want to know about what people told you. I want to know what you personally observed in the last quarter of 18 through 19, through all of 19.
Well,
What was the condition of easement 2 when y'all moved in?
it was just a dumping ground.
Did it appear that anybody, based on your personal eyes?
Yes.
Did it appear that anyone had made any use of easement 2 from the adjoining property in any way, shape, or form?
Absolutely zero.
Okay. And why did you want to clear it? Did you try to track down the Darbys and say, hey, I'd like to clean this up? Do you object?
I've never met the Darbys.
Well, did you try to track them down?
No.
Why not?
Just, I didn't feel there was a need to.
Okay. So you did some cleaning. The Davids moved in. Did you continue cleaning, clearing out easement 2 after the Davids bought their property, finished their construction, and actually moved in their house?
Yes.
And approximately how long was that? Or do you know?
I don't know.
Eventually you built a fence.
I did.
Why did you build the fence?
I built the fence because when they tell you that workers were coming up the actual real easement area, they weren't ever. They would come up my driveway, cross our property. So what we had to do to stop that was we put the fence up, okay, and that stopped that problem immediately.
And did you reach out to the Davids and say, hey, we're building this fence. Do you have any questions or concerns or comments?
No.
Why not?
I didn't think it was necessary at the time.
Okay. Why did you stop landscaping or doing any work on easement 2?
Because of the lawsuit.
Who pays taxes, the property taxes on easement 2?
I pay the property taxes.
Have the Davids ever offered to share in the payment of the property taxes on easement 2?
No, sir.
Thank you, sir. Past witness.
Sir?
Get my water.
Good afternoon, Mr. Anderson.
Good afternoon.
We've met before. I believe we met when I took your deposition. Is that correct?
That's correct.
Okay. And it's your testimony here today that you used easement 2 prior to the Davids moving in.
Yes.
And you're certain of that?
We've been on it, yes. Cleaning some stuff up.
Okay. And you recall I took your deposition?
I do, yeah.
Okay. And I asked you questions under oath?
Right.
And you had an attorney there representing you to object?
Right.
Okay. Do you recall me asking you this question in your deposition? Do you recall me asking you this same question in your deposition?
Repeat the question, please.
Did you make any use of easement 2 after you purchased the property and prior to the Davids?
Other than doing some cleanup, not really.
So it's your testimony that you did do clearing?
We did some clearing, yes.
I'm gonna ask you to look at your deposition,
Okay?
page 52.
I don't have a copy of it.
I'm gonna.
It's coming.
Very shortly. And it's lines 22 to 25.
What?
Can you read the question I asked you and your answer?
20, what were the numbers again?
52, 22 to 25.
I'm having difficulty. I don't see a 52. Okay.
There's page
Page 52, right,
And then they do the lines on this.
21 through, okay,
22.
20, 22, okay. Did you make?
Can you read that out to the jury, please?
Okay, did you make any use of easement area 2 after you purchased the property and prior to the Davids purchasing the neighboring property? And I said no, but we did do some clearing. So that's just, that, if that's okay, that's just a mistake on my part.
Okay, so when I took your deposition back in January of 2022, you didn't tell me truthfully what had happened.
No, I told you truthfully.
Well, today you're saying you did make use, you cleared it, and in your deposition, you said you made no use.
Well, for when you say the clearing, we weren't actually on the EA2 except to bring stuff. We were clearing my property because that's where the bulk of it was, and it extended into the easement.
Let's talk about your property. You purchased your property, 3350 West Andrews Drive, September 27, 2018.
Correct.
Okay. And you purchased your property from Ann and Jeffrey Nykirk.
Correct.
Okay. Did you know Miss Nykirk previously?
I did not. My wife did.
You understand, and you closed on the property at the firm of Campbell and Brannon.
Yes.
Is that correct?
Mhm.
Okay. And during closing, you were given a copy of the easement agreement, correct?
I don't recall.
You don't recall?
No.
Okay. And at closing, you were given a copy of the plat to your property.
We were.
Okay. And do you recall the deed transferring title, conveying the property to you? Do you recall the deed for your property?
I don't.
You don't. Okay. Sometime after you purchased your property and moved in, do you recall the attorneys at Campbell and Brannon reaching out to you?
I do not. But they could have.
Okay. And I apologize, Judge, I just realized, Jeff, if you can give Judge McBurney the binder for the defendant.
Thank you.
When you were purchased your property, you were aware that there were two easements on the property, correct?
We were.
Okay. Easement 1 and easement 2.
Yes.
Okay. And my question to you just a moment ago is whether you recall, after purchasing the property, the attorneys from Campbell and Brannon reaching out to you about the property, your deeds, the easement agreement, and the surveys.
Is that a question?
Yes.
I don't.
Do you recall that?
I don't recall that.
Okay. Let me have you take a look at this document. This is, I'm not. Mr. Anderson, do you recognize this document?
Judge, I object. She didn't share a copy with me, but now she is. Thank you.
You know, I don't, obviously it was sent to me, but I don't remember this.
Okay, but it's an email from John Hocutt, attorney at Campbell and Brannon, to you,
Mhm.
your wife, your former attorney, Mark Rushi, and Alec, we have all been butchering his name
Nicolaitis.
today. Nicolaitis. And you see that? Is that correct?
Mhm.
Okay. And in this email to you, Mr. Hocutt references
Mhm.
that he is providing a courtesy copy of both the easement agreement and the survey, correct? And you can flip through it.
We'll get that for you, I promise. I'll write it down and get it for you.
Is that correct? You were provided, on June 23rd, 2020, you were provided another copy of the easement agreement and the survey you received at closing.
I believe so, yeah, it says here.
Okay. You responded to this.
Yeah, I did.
Okay.
Mhm.
And isn't it true, you responded to Mr. Hocutt saying, we understand fully the easement?
Judge, I object because I think we're trying to get to some admission that the easement has some magic legal language. The easement is what it is, and you're gonna tell the jury what it means, and I don't want her to get into some form of admission, oh, it means X, Y, Z.
Okay, I understand your concern. We're not there yet, and so Ms. Sturm's gonna need to not go that far. I think right now she's simply establishing the awareness of the easement.
Mr. Anderson, isn't
Yes.
that correct? That you responded back to closing counsel, telling him, I fully understand the easement?
Yes.
Okay. And this is a communication between, I think I identified all the parties. We would move to admit defendants exhibit 29.
Any objection to the admission of defendants 29?
Yes, Judge, it contains out-of-court statements from an attorney, which may or may not constitute legal opinions. And if they do, they're inadmissible because you are the sole source of the law for the jury. And I think we all know why this is being offered, and I object to the document. If Mr. Hocutt, if they're gonna call Mr. Hocutt, I'd certainly look forward to cross-examining him, but absent Mr. Hocutt taking the stand, his opinion is clearly not admissible and probably not even then. So I object to this going back. It's irrelevant and misleading and hearsay.
Okay, well, that was a lot of things. The hearsay piece, though, how do you get past that?
Well, we could, yes. This goes to show his state of mind. So they're talking at, yes, Mr. Anderson's state of mind and knowledge and awareness of these documents that govern the property.
Okay. So I'm gonna do two things. I will admit defense 29 for purposes of the record, so it's in the record. We'll sort out later if it's something that will go back with the jury for the very concerns that Mr. Edwards has raised. And I just want to reemphasize, I don't see an issue with you establishing that either Ms. Anderson or Mr. Anderson were aware of the easement. Where it gets tricky and you'll need to steer away from is then saying, so you knew the easement meant X. Because it's not Mr. Anderson's interpretation of what the easement is that is going to be what guides the jurors.
Understood. Thank you, Judge.
Okay.
So just to be clear, Mr. Anderson, when you purchased the property, you were aware of the easement agreement and the easements on the property.
Yes, we knew there were easement agreements.
Okay, and then in June of 2020, closing counsel sent you another copy of the easement agreements and survey.
Can't remember that.
That's what we just talked about.
Yeah,
That's
but
this email.
if that's it, they sent to me, but that's 4 years ago.
Now, you also had your own survey done after you closed on the property, correct?
You did? Yeah.
Okay, and your survey of the property showed 2 easements, correct?
Yes.
Let's talk about when you purchased the property. Did you walk the entire property?
Yes.
You walked easement 2?
I walked easement too, yes.
Okay, and you were able to walk easement 2?
No, it's pretty tough.
But you did it?
Yeah, but you needed boots and you needed to keep stuff off of everything. It was horrible.
You've talked a lot about the plastic bottles and the copper heads and the piles of debris that were back there.
Mhm.
Do you have photographs of those?
No, I don't have any photographs that we took. There's some photos of when we cleaned out took the stump out, I believe. There was some from that, but
Did you produce those?
I don't know where they are.
At the time you purchased the property, easement 2 was wooded.
With tiny
Yes or
little
no?
vegetation. No, not really.
It wasn't wooded.
It had those nuisance trees, but it wasn't with hardwoods.
Were you aware that the neighbors, the Darbys, enjoyed easement 2 in its
Yeah.
natural state?
Objection, assumes facts not in evidence.
I can re-ask.
Okay, ask that a different way, without testifying for the Darbies.
Did you reach out to the Darbys at any point in time to ask them how they used easement 2?
No.
You didn't,
We talked with Ann Nykirk though, and she told me nobody used it.
Don't talk about what Ms. Nykirk said. If she's gonna talk, she'll
Okay.
do it tomorrow.
you didn't knock on the Darby's door?
The Darbys didn't live there. Nobody
Didn't
lived
knock
there.
on the Darby's door, did you?
No, no,
Okay. You didn't send them a certified letter?
no,
You didn't call them on the phone?
no.
Did you renovate the interior of your home after you moved in?
We did renovation, yes.
Do you recall ever making an offer to buy the adjacent property, the David property?
No.
Okay. You were aware that it was for sale?
I was aware that it was for sale.
Okay. Did you make any offer to purchase easement 2 from the Darbys?
I did not.
You didn't did you contact the Darbys to see if they would modify the easement agreement?
I've never spoken with the Darbys.
So you didn't reach out to them to see if they would modify the agreement?
No.
No more questions about, he's never spoken to the Darbies about anything, even offering him a hot dog when he was making hot dogs. So you don't need to ask any more about his contact with the Darbies.
The Davids purchased their property in March of 2020, a year and a half after you purchased.
Mm-hmm.
So, Mr. Anderson, just like with your wife, when you're answering, make sure it's a yes or a no or a maybe, or I don't know, but the or court reporter, he can't guess or simulate those.
Totally understand, Judge.
Thank you.
That's hard. We all do it. After the Davids purchased their property, did you contact either Mr. or Mrs. David to discuss use of easement 2?
I did not.
After the Davids purchased their property, did you contact either Mr. or Mrs. David to discuss clearing of easement 2?
I did not.
After the Davids purchased, did you reach out to either Mr. or Mrs. David to notify them that you were going to clear easement 2?
I did not.
And you admit you cleared a portion of easement 2?
I have.
And we don't have any actual photographs of the clearing taking place. Is that correct?
There are probably some out there somewhere. I just don't know where they are.
You do recall that you were sent requests to produce, in this case, asking you to produce documentation related to these claims. That would include any
Right.
photographs that you have. Did
All right.
you?
Well, Mr. Edwards does have any and all photographs that I have.
Did you have photographs of the actual clearing occurring?
I don't believe so.
You don't?
I think there was one photograph I've seen somewhere that had the stump guy back there. And that was it.
Okay, and you provided that to Mr. Edwards?
No, I don't believe I did.
I thought you just said that any photographs.
I did, but I thought I saw one yesterday that had that. I thought I was looking at a photograph yesterday that had that machine and equipment back there.
A photo you took?
I don't know if I took it or someone else.
I'm asking you about photos you took. Did you take any photos of the clearing of easement 2?
Not that I'm aware of.
You don't know,
I don't know.
but you were asked to turn them all over.
Ma'am, we would turn over everything we were asked to do. So,
You put lighting in a tree on easement 2, is that correct?
yes,
Did you contact the Davids to inquire or to ask about placing lighting on easement 2?
no, is the fee simple owner of that property? I could put that in the tree.
I'm gonna object.
So, he's free to answer and you can explore why he thinks that if you want. I mean, he is opening a door to exploring legal advice he's received. So, you should move forward as you see appropriate.
Do you still have defendant's exhibit 29 in front of you?
Yes,
Okay, and this is the email from John Hocutt to you and some other folks. And Mr. Hocutt's your closing attorney, correct?
29 is a picture. You said 29.
I
So
did,
you're in the
sorry.
wrong binder. That's your exhibit binder, and I don't think you've got the defense one. So the only defense exhibit you've got is the paper she's handing.
Okay, thank you.
These complaints. Okay, so we talked about this document earlier. This is Mr. Hocutt forwarding you another copy of the easement agreement
Mhm.
And the survey to the property. And reaching out to you to make sure you understand, correct? And if you need to read through the whole thing, please do so.
No, I mean, it's fine.
Is that correct? He's reaching out
Yeah,
to you to make sure you understand.
I don't know that he was trying to make me understand. I think he was reaching out.
Okay, well, can you please take a look through the document?
Yep.
Do you know Erica Eaton?
I do not.
I'll represent to you that she was a real estate agent for the Davids.
I don't know her.
Did you have a chance to look through?
Yeah.
Okay. You may recall when we did your deposition, there's some Bates numbers at the bottom. That may be the easiest way to get to the page, or I can help you. But at the very bottom, there's an LPA 000282.
Mm-hmm.
Okay. And in this email from Mr. Hocutt to you, he provides, well, you tell me what he's telling you.
Well, objection, are you asking him to read
what the attorney says to him?
Well, he tells you, right, that he's reaching out. Is that correct?
Yes.
And he's reaching.
Okay.
Okay.
Yes.
Reaching out.
Before you go a lot further, Mr. Hearsay, still hearsay.
Sure.
So he can certainly review it and tell you what he thinks is going on, but I couldn't tell from your question. I think Mr. Edwards had the same concern. Were you asking Mr. Anderson to just read straight from it? But he can read it and then give you his synthesis of that.
Did you have an opportunity to read it?
I did.
Okay. Would you agree with me that Mr. Hocutt is reaching out to ensure you have an understanding of the easement agreement and surveys and how they apply to your property?
I agree that he was asked by Erica to do that, yes.
And would you agree with me that you responded to Mr. Hocutt and
Yep.
told him you had a full understanding?
We do have a full understanding.
And with regard to that, in this communication, there's reference to easement 2, correct?
Mhm.
And there's reference to whether folks are using easement 2 or not, correct?
Appears that way, yes.
And this is regard to, you're indicating that you're not talking about easement 2, is that correct? That you have a full understanding of the use easement 2, and that's not what you're talking about.
I said, John, we fully understand the easement and want you to know it's at the south end of the property.
Okay. And with regard to that easement agreement, did you read the easement agreement again?
I've read it.
When you obtained it from Mr. Hocutt in?
No, Judge, I object to this. We went through this in his deposition. His understanding of a contract or a deed that is an issue of law for the court is irrelevant. We spent a lot of time in his deposition asking his understanding.
Okay.
He understood they existed, and what the boundaries were as far as legal understanding is irrelevant. And I would ask Ms. Sturm to move on to something that is relevant and admissible.
Well, I do want her to move on, but Mr. Anderson answered a question. As a fee simple owner, I don't remember exactly. I can go ahead and put that light up there because I'm the fee simple owner. That injects into our case Mr. Anderson's perspective on what he's allowed to do or not allowed to do in the easement. And I guess really what you need to do to make the finest of points and not belabor defense 29 is have Mr. Anderson share with you what he thinks he's allowed to do under the easement. That's relevant. That doesn't control. That's not necessarily what the easement means, but his understanding of what it allows him to do and maybe what he thinks the Davids can or can't do. You can certainly ask, because that would explain perhaps some of the steps he took or decided not to take.
Thank you, Judge. Mr. Anderson, what was your understanding of easement 2?
My understanding of easement 2 was that it had been abandoned.
And yet you accepted a deed and a conveyance of property that was subject to an easement agreement.
And I'm the fee simple owner of the property.
Okay, but you took conveyance of that property. You purchased it subject to an easement agreement. We just discussed that, correct?
Yeah.
And you were provided a
Yes.
copy of the easement agreement.
Yes.
Judge, 1 moment. Yeah, you take a look at that. Stop.
Thank you.
Yeah, they want to go over there.
You know what I'm gonna do? I'm gonna take our afternoon break right now. So that'll give Mr. Anderson a chance to look through that. I didn't realize how late it had gotten. We're all gotten wrapped up with your examination on Mr. Anderson. I want to make sure we do have a quick break before the end of the day. So ladies and gentlemen, we're gonna take a 10-ish minute break. I may try to keep it a little shorter than that, but I want to make sure you get the refresh you need. Can't remember if I mentioned before, tomorrow is gonna be a little different. We're not starting till 1:30. I may not have told you that. I'm a drug court judge and I have to attend to drug court business every other Wednesday, and tomorrow is one of those Wednesdays. So I'll be working with clients and participants all morning, and we won't start till 1:30. It would be great if we could go till 6 tomorrow, but that's not a requirement because I told you all normally 9 to 5. So during your break, think about whether we could go 5:30 or 6 tomorrow, because it's a shorter day. The lawyers knew that when they were given the time estimate. I'm not suddenly saying, uh-oh, this case is gonna go into next week, because it won't. I hope. We'll see what the lawyers tell me when we're done today with how quickly things have been going. But tomorrow we don't start till 1:30. Eat lunch before you get here tomorrow, because we won't take a lunch break tomorrow. More on that at the end of the day. Let's take our afternoon break. Please don't talk about the case or engage in any outside research.
All right, adjourn.
All right, Mr. Williams, are you ready? Ready. Great. You're back on the record. Mr. Anderson, if you could get your way back towards the stand.
Got a record address, man. Thank you, brother.
Sure, hold on one sec. Yes, sir, Mr. Schneider.
There's some concern that a woman here has been suggesting responses to the witness. Several of us have seen this, and we don't know that it's in her intent. We all sometimes try to, wish upon our witness that, but we'd ask some direction that there not be any of that.
Excuse me, I didn't hear the first part of that, but I think I know the gist of it.
Yeah, sure. Mr. Schneider is suggesting that somehow someone, I'm assuming associated with your team, is helping.
No, not you. This young woman over here.
Is assisting Mr. Anderson with his answers. And he just wants me to provide guidance. I'm happy to provide guidance. There are very few questions that have been asked that someone could, absent like a microphone in Mr. Anderson's ear, could provide guidance because they are, tell me what happened. Well, no one asks that open question, but he's providing multi-word answers. I did notice that when Ms. Anderson was asked a question that was about recall, hey, when did something happen? She tended to make eye contact with her husband to see if maybe he remembered. It wasn't a big deal, and I didn't comment on that. But that was to me innocent enough of like, hey, do you think it was last year or the year before? It's important that witnesses provide their own independent recollection of the events about which they are asked. So let's make sure that's how it plays out. Did you have anything else, Mr. Schneider?
That's it, Your Honor.
Okay. Mr. Edwards, do you have anything before we bring the jurors?
No, I fully and 100% agree that nobody should be giving signs, and I certainly wish that Mr. Schneider would have mentioned it to me before mentioning it to you.
Okay, well, he wisely didn't mention it in front of the jurors, so here we are. It's all good. Let's see if the jurors are ready.
Yeah.
All right, the jurors.
Thank you, Deputy Gordon. Everyone else can be seated. Great job, Juror 1, coming in at the end to get your special seat.
You got it. I waited, yes.
All right. We are still in the midst of the cross-examination of Mr. Anderson, who remains under oath. Ms. Stern, when you are ready.
Thank you, Judge.
Before we broke, Mr. Anderson, I believe I handed you a document.
You did.
Recognize that document?
You did?
Okay, and that's the easement agreement?
Yes, it appears to be.
Excuse me?
It appears to be, yes.
Okay. And this is the easement agreement you received at closing and from Mr. Hocutt following.
Okay.
Your Honor, we would move to admit we've identified it as Exhibit 1, Defendant's Exhibit 1.
Oh, so this is in your binder. Really small print. You able to read that?
Barely.
Okay.
It took glasses, Judge.
Okay. Any objection to Defense Exhibit 1 being admitted to the record?
Being admitted into the record, no objection whatsoever.
It's admitted.
Showing it to the jury, yes, we have an objection because that gets into legal conclusion and argument of legal arguments and all of that. That's an issue of law for the court. We don't want the jury to get confused by trying to figure out what these meets and bounds mean and what the language of the easement means. I think that's improper. She can ask whatever questions she needs to ask, potentially that might be proper, but I don't think she should show the jury the document and start asking, did you see this? Do you understand this word? Do you understand this phrase? That's
So
completely
I agree
improper.
with a little bit of what you said. One, D1 is admitted, so it's in the record. Two, I think you can publish any part of D1. Three, it probably will go back with the jury. Don't have to decide that right now. Or you can ask Mr. Anderson questions about different parts of the document, especially if you can make it legible. But five, you may not ask him to share his sense of what the legal significance of any of that language is.
But Judge, beyond that, under 13-2-1, this little novel legal theory called parole evidence rule is inadmissible to add to, take from, or vary a written contract. That's the whole purpose of this. She wants him to say, do you see this? Do you see? Of course he sees it. But asking him his understanding is directly prohibited under 13-2-1.
Okay, so fair point. I guess it depends how she's gonna ask the questions. I just want to make clear, I don't think that any of this shouldn't be published if Ms. Sturm wants to publish it, but you're right, she's gonna need to be careful about what she asks about that document. All right, D1 is in.
Am I able to share or on this system through the Zoom?
Are you on, you're Jeffrey Schneider, you can share. Why don't you start asking some questions while Mr. Schneider tries to figure this out? We got a witness just sitting there looking at himself on the screen.
Rather, I have.
You got it? All right, Mr. Anderson,
Yes,
what we've labeled as B1, this is the easement agreement
yes,
for your property, correct?
yes.
Okay, and were you able to share it, Jeff? And you were provided this agreement at closing and following,
I believe so, yes.
okay? And if you read down on the first page, it says we have two easement grants. On the first page, we talk about easement 1, is that correct?
It's hard to read, but it looks that way.
Okay, let me, it appears.
I can't read this.
Okay, it appears Mr. Schneider's having a problem. Let me, there it goes. No,
Yeah,
Yeah, there it is.
there you go.
Done for the day.
And I,
Drops the mic, walks out of the room.
well done. And I believe, Mr. Schneider, if you can, you're able to zoom from your, yes. Is that showing up on your screen as well, Mr. Anderson?
Yes, ma'am, it is.
Okay, very good. And can you tell us what easement 2 says?
Which paragraph?
You're gonna need to guide a little.
Yeah, I mean, this is going up and down like a yo-yo.
There you go. We're on the second page of the document. You see number 2?
Yes,
Okay. Can you tell us what easement 2 says?
grantor hereby grants, bargains, sells, and conveys to grantee, his successors, and assigns for the benefit of all pertinence to the guarantee property a perpetual exclusive easement over, across, and under easement area 2. Grantee may use easement area 2 for any legal purpose whatsoever, which uses may include, but shall not be limited to the construction,
Don't
installation,
read too fast, because the court reporter needs to take all this down.
but shall not be limited to the construction, installation, and use of a driveway connecting the grantor property to West Andrews Drive, provided that such construction, installation, or use is not in violation of then current building and zoning requirements. Grantee shall have the right to maintain or cause to be maintained all improvements and structures it elects to construct within easement area 2. Grantor acknowledges and agrees that grantor shall have no right to interfere with grantee's use of easement area 2.
And if you scroll down, Mr. Schneider. You've gone too far afield, go back up, thank you. Nope, right there. It is number 4 as part of this easement agreement. Can you tell us what that says?
Grantor shall be obligated to pay ad valorem taxes on the grantor property. Shall be obligated to pay ad valorem taxes on the grantor property, including but not limited to those taxes applicable to the easement areas.
Okay. And this agreement was provided to you before and after you closed on the property?
Yes.
Is it your position, Mr. Anderson, that it's okay for you to clear easement 2, but it's not okay for the Davids to be on easement 2?
No, I haven't said that. We have the exact access to both the easements that the Davids do. And that's what the appellate court told us.
So let's not get into what an appellate court may have said or may not have said.
I would move to strike that portion of the answer.
All right, so you all, members of the jury, should strike, not recall, not rely on Mr. Anderson's non-lawyer opinion as to what an appellate court may have said in this case.
Mr. Anderson, is it okay for the Davids to sit on easement 2?
Right now, today it is, yes.
And it's okay for the Davids to walk through easement 2?
Today,
And it's okay for the Davids to have sports equipment on easement 2?
I mean, I look at easements differently than you do. I view an easement as a way to pass across an area, not go and put sports equipment and all this stuff on it. And so, no, I don't agree with that.
And you read the easement 2 on the easement agreement?
I did, but that's why we're in court.
You've taken a lot of pictures of the Davids on easement 2, right?
Not a lot,
No?
a few.
You photographed their son on easement 2, correct?
I have, yes.
Okay, and he was out there practicing lacrosse?
No, he was just running around doing stuff. He wasn't even throwing the ball around then. Last time I saw him.
You've not ever seen him out there playing lacrosse?
I told you earlier, maybe 5 or 6 times in this whole time. Okay.
We're gonna pull up a video, Defense Exhibit 12.
That's already been admitted.
It's been produced, it was taken by Mr. Anderson, it's
Okay.
been
It
produced
wasn't
to
one of-
us.
okay.
It's not one of the ones that
They admitted.
they admitted.
Okay.
Objection.
I'm sorry, it's D16, Randy.
I think that's already in. So if you're able to make it play. Oh, D16.
D16.
Oh, you're switching to you now.
Yeah.
Okay.
But we'll,
Your Honor, may we approach for a minute?
Because
Well, if, before anything's published to the jury, perhaps she needs to move the view of her laptop.
Okay, let's just do that. What would be great is if the David team could figure out, you got two lawyers here, if someone could pull something up and you keep asking Mr. Anderson questions. We have a lot of pauses.
Jeff, are you able to pull that up? Okay. Mr. Anderson, do you recall filming the David's son when he was out on easement 2 with his lacrosse equipment?
Yes.
Okay. Do you recall him telling you he did not like that?
No, I didn't recall him.
You don't recall that?
I don't recall.
Okay. And do you recall him telling you his age and how he didn't like you filming him?
I don't recall, but the reason we filmed is because the lawyers wanted me to get, anytime people were over there and we saw it, to get it on tape. And that's what we did. It's nothing against that little boy or anything else. It's just anybody that was over there. If I had a video, I was going to get a video of it.
Okay. Did you film any of your workers out on easement 2?
I haven't had any workers out on easement 2 since we started this lawsuit.
Did you film any of them out there on easement 2?
I don't believe so.
Did you film any times you've been out on easement 2?
Just other than showing like where the path was that Mr. David cut and the other stuff, that, other than that, not really.
We will work on getting the video up to play. In the meantime, I will continue on. Jeff, if you'll let me know when you get it, we will take a moment to listen to it. Oh. And if you can turn up the volume. Judge, I think it. We will have to work out the kinks, and so you can hear the audio from here.
That was progress, that video actually.
Video played. Mr. Anderson, you took that video?
I believe so, yes.
Now, you testified earlier that in this video, we do see Hopkins, the David's son, picking up his phone.
Yes. He started videoing me.
You don't know that he was videoing you,
Boy, he was holding the camera up like somebody's videoing it.
but you don't know whether he actually videoed you.
I don't know, but it sure appeared that.
Okay, and you don't know if he actually took any photographs of you at that time.
I don't know that.
See, I've got it.
Oh, we're gonna try again.
Sorry, everybody.
Oh, excuse me. They're muted the corner. Maybe that has something to do so.
Do you know whether it has to be unmuted on the big screen?
No, it's not the big screen, it's how you share it. And if you check the two boxes, share audio and share video, the audio should go through, but you need to have the various microphones and speakers on your computer muted. That's why we're getting that
The
feedback.
feedback, okay. We will let Mr. Schneider play around with that for now. Let me move to a different area for a moment and we'll come back and address,
Sorry about that.
yeah, you're gonna have to mute on your end.
Go ahead.
Let me move to a different area for a moment and we'll come back and address, yeah, you're gonna have to mute on your end. Go ahead.
Go ahead.
Okay.
Go ahead.
Let me move to a different area for a moment and we'll come back and address, yeah, you're gonna have to mute on your end. Mr. Anderson, you installed a fence along the border between your property and the W property, correct?
Correct.
And when you purchased the property, there was no fence there.
No,
And it was your intent, was it not, to extend that fence all the way down?
we were going to extend with a chain link fence from the wooden fence down and put a gate in the middle of it.
So you built a fence between your property line and the David line, property out of wood.
That's correct.
Okay, how tall is that fence?
6 feet.
Okay, and then it was your intent to fence, chain link, install a chain link fence from where the easement 2 starts along the property line between your property and the David's property, all the way down.
That was the intent.
Okay, and then it was your intent also to put a fence on the opposite side along West Andrews, correct?
We discussed putting a fence along there.
So we is you and your wife.
My wife and I, yes.
I mean, that was part of your landscape plan, is that not correct?
Well, I mean, you say part of the landscape plan, that was a presented plan to us. We never approved that final plan. And we haven't acted on it.
But you asked for the landscape company to put it together, correct?
Yes, I did.
Okay. Is it also your intent to put sod on easement 2?
We were discussing that, but nothing was finalized.
It was part of the landscape plan though, was it not?
It could have been, yes. I'd have to go back and look at it.
Okay.
I know they wanted to take a lot of stuff down. They wanted to clear out all that frontage on the street of all the junk and potentially put a wall in there.
Let's take a look at your landscape plan. Mr. Anderson, tell me again, who were you working with on landscaping? Is that Alec?
Alec Michelatis.
Okay. And I'm gonna bring you up a copy.
Just give me the number.
Okay, D33.
33.
33. D33. Mr. Anderson, you familiar with that document?
I believe so.
Okay.
I think I've seen it before, yeah.
And you know the folks from Land Plus, that's Alec's company, is that correct?
Correct.
Okay. And this is a landscape plan for a portion of your property, correct?
That's correct.
Okay. And it shows from the house or most of your house all the way back to the end of easement 2. Is that correct?
Mm-hmm.
Okay.
Yes.
Yeah. And just by way of reminder for the court reporter, yes or no, but, and you had a landscape plan for the front portion as well at the same time. Is that correct?
No,
No?
no.
Okay.
We were looking at the north and southern ends of the property.
Did
Not
you have
the
a
middle.
plan at one point in time to put a pool on the front end?
No, not yet. We've discussed it, but we haven't planned it.
Okay. D33, this is the landscape plan for about your house going back to easement 2.
Mm-hmm.
Yes.
And
Yes. Sorry, Judge.
I'm about to, Your Honor, we would move to admit D33.
Edwards, any objection to defense 33?
Other than relevance, but no.
Okay, I'll admit it.
Excuse me. We're only seeing half of it, Jeff. There you go. Okay. Now, can you show us the wooden fence portion and what you were talking about, the chain link fence?
Yeah, so it goes down from, here's the garage. You see the garage. The fence behind there goes all the way down the property line right to easement area 2.
think you have a tool on there that may allow you to mark.
Not working right
Oh,
now.
it's not working.
No, we've made a request to IT and I don't know where IT is.
Okay. So I will come up here and can you tell me if I am correct? This area down to here is the wood fence.
That's correct.
Okay, and then here to the end of the property is the chain link fence.
That's what we were looking to do.
Okay.
We never did it.
And this break here, this marks the start of easement 2, correct?
I believe so.
Okay, and if we take that and compare it roughly with the easement and go down that area, once we draw that line perpendicular across, the area to the left of there would be easement 2, correct?
That's correct.
And that shows a landscape plan you had designed for the use of easement 2, correct?
That's correct.
And if we look down along West Andrews on this landscape plan, there's an indication of stone columns and a wood rail fence. Is that correct?
That's something we were discussing.
Okay, and that extends all the way from near the end of your garage down to the end of easement 2, correct?
I don't recall the plan, but that looks like that's what it is. Yeah.
Okay, I mean, you can look on the plan.
Yeah, no, I see it right here.
Okay, so it
Yeah.
shows up on the plan now.
Yeah.
And Mr. David was in town when workers were out there installing the fence. Is
Mr. DeVee was in town?
that correct?
I believe he was, yes.
Did you have an interaction with Mr. David that day?
I don't believe I did.
You don't? Okay. Do you recall any of your workers contacting you about the fence?
No, I can't recall.
Did you ask the workers to stop?
Yes, I did.
You did?
I did.
Okay. And when did you do that?
Well, I called Mark Rushi, okay, and he told me, he says, go easy on the,
Hold on.
Don't talk about attorney-client privilege.
okay.
Once that cat's out the bag, it's out.
Do you know what date you contacted the fence workers and told them to stop?
I do not.
Okay. Were you on site when this was happening?
I was in and out that day.
Do you know whether Mr. David asked the workers to please not put the fence along the easement area?
I believe he might have done that, yes.
Okay. You didn't have any discussions with the Davids about installing the fence?
I did not.
And you didn't have any discussions with them about putting it down easement 2?
I did not.
Were you upset that Mr. David asked them to please not fence the easement area?
I wouldn't go like really upset, but I wasn't happy about it, no.
He handed you, it's D34. Do you recognize that document?
Yes.
And this is an email from you. Who's Mr. Mullins?
He's at Land Plus.
The company that did this, the
Andrew Mullins. Yeah,
same company that did the landscape plan.
he works for Landscape Plus.
Okay. And did you make a comment to Mr. Mullins? It's also Mr. Galitis?
Now, I wrote to Mullins for sure and Alec. And what I told them was I'd spoken with counsel and they said, hold off on the fence for now. Just hold off on the fence for now and we'll we're going to probably have to litigate it out.
That's what you told Mr. Mullins and Mr. Mikolitis.
Yes.
Okay, what's the date of this email?
10/5/2020.
And you tell them, stop the fence, I'm gonna begin my legal fight.
I said we're going to have to probably have a legal fight. I will begin the legal fight, yeah.
I will begin the fight with my legal team shortly after, but the polls must be removed for now. Is that correct?
That's correct.
We would move to admit D34.
The objection to D 34?
No, sir.
Okay. Admitted. Let's admit before we get into contents next time, sort of, I don't know what
Sorry.
Mr. Edward would object to by now. Contents already.
Mr. Anderson, you had some communications with, well, before I ask you that,
You did in fact bring a lawsuit. You brought this last lawsuit.
Yes, I did, and it's because you threatened me with putting a lien on my land.
we didn't file a lawsuit, did we? The Davids didn't file.
You threatened me with a lien. You used a very threatening letter to come at me where I felt I had no choice. You did that.
Okay, Mr. Anderson, you filed this lawsuit, correct?
Yes,
The Davids did not proceed with a lawsuit against you.
they didn't because I went first. And I did that strictly to protect my property and my home.
You didn't contact or reach out to the Davids and say, let's talk about easement 2 and maybe even my landscape plan.
No,
Okay. You just filed a lawsuit.
no, we filed a lawsuit, yes.
Let me ask you about these communications with Mrs. David. You've only seen her once?
Well, I've seen her from the house driving in, but after that one time, that one incident, I haven't seen her at all. I haven't yelled, talked to her, haven't done anything.
After calling her a fat bitch, you haven't seen her again.
I've told you, you're putting words in my mouth. I told you that I've seen her driving in or driving around the neighborhood and maybe a time or two saw her get out of her car from the house. But other than that, nothing.
Okay. I'm just wondering, because when Mr. Edwards was asking you questions, you stated that you'd seen her one time in person.
That's true. But I mean, if you call in person is in person being there. It's not through the window of a house.
Okay. So if she was getting into her car and you yelled Algerian niggers, that wouldn't be in person.
Number one, I never did that. I flatly deny that. I resent that. I resent that so badly you have no idea. I really do. I resent that. And the jury needs to know that's false.
And you didn't see her or her son getting into their car?
I've never seen her and her son getting into the car.
Okay.
You can't see people getting in the car because it's 10, 12 feet below. I can't see anything that goes on. When I walk from the house to our garage, you can't see anything that they're doing up there. I would have to go all the way up to be able to see that and to see them. So no, I haven't seen them.
Okay. And so it's your position, it didn't happen and it didn't happen in front of her son?
My position is I've never said that.
And the gun, we heard you with Mr. Edwards. Is it possible that, I mean, you don't deny you have a shotgun?
No,
Okay. And you don't deny that you took it out of the car and brought it to the garage?
no, I took it out of my car. It was encased. If any of you have shotguns or know, you know, you put them in a nice case. Okay, that case is sealed. Okay. I went from my garage. I didn't even notice the boy was over there until I went down to the mailbox and I looked over and he was there. So all I did was simply walk back up with my firearm and put it in safe storage in the house. We have gun safety.
Is it possible
that Miss Hopkins David would have. Are you?
We'll finish it. I'll
Okay.
check.
Is it possible that Hopkins David may have interpreted that in a different way?
Objection calls for speculation.
Correct, sustained. Don't answer the question. The objection's been sustained.
Let me hand you defendant's exhibit 26. Is this a survey of your property?
Appears to be, yeah.
Okay, and you have several surveillance cameras on your property, is that correct?
Yes.
Okay, you have 9.
7 active.
7 what?
7 active.
7 now active?
7 now active and 2 have been out. I took them out for probably about a year. The one on the front of the garage, it just picked up too much road traffic on West Andrews.
Number 3.
I'm sorry.
You may not know. I'm just looking at this exhibit. So that would be number 3 on the exhibit.
Number 3 would be the driveway. Yes, sir.
Okay.
Did you identify the location of the surveillance cameras on here?
Yes.
And when is it that number 3 was removed?
It got knocked off probably a year ago. It's in my garage.
And Mr. Anderson, have you produced any video from camera 3 or any of the other surveillance cameras that show you taking this gun from the car to the garage house area?
No.
No. Okay. Now you do have surveillance cameras that capture the entry of all your entry points.
Yeah,
Is that
but
correct?
we erase those daily. Those get erased daily unless there's something you think you need to keep.
So if you didn't want somebody to see the gun, then you would erase it.
Number 1, you couldn't see a gun because there was no way of telling it was a gun because it was in a case. So Mr. Young David did not have any idea if that was a gun. He could only speculate.
Did you produce any pictures of the workers going across your property, not easement 2?
No.
From the surveillance cameras?
No.
And you talked about Mr. David and a gentleman that was out on the property recently.
Yes.
Week from Sunday or so
Yes.
ago?
Yes.
Do you recall talking to them while they were out there?
I said, yes. Hey, see you next week.
Did you say, see you in court, big boy?
No, I said, I'll see you next week.
Okay.
That's pretty much what I thought I said.
And I believe you indicated that you have readjusted some of those surveillance cameras. Is that correct?
Yes.
So during the time that the Davids have lived next door during the pendency of this suit, you have adjusted the angle of some of those cameras?
Yes.
Let me consult a moment. Mr. Anderson, that is all I have for you this afternoon.
Thank you, ma'am.
Yes.
You redirect.
Yes, sir. What? Mr. Anderson, Share my screen. Just pick up where we were a minute. Oops. Pick up where we were. You mentioned, in Ms. Sturm's questions that you have seen a picture recently of some work being done on easement area 2. Do you
Yeah,
recall
I
that?
saw a picture of that, yes. Somewhere.
Okay. Defendant's Exhibit 8, I assume there's no objection to Defendant's Exhibit 8?
Sir?
I assume there's no objection to Defendant's Exhibit 8?
Is that what's on the screen?
Not yet.
No.
Okay. Defendant's Exhibit 8
All right, it's admitted.
is admitted. Is this the picture you're referring to that you've seen recently?
I'm not sure I'm following the question.
You told Ms. Sturm that she's asking you about pictures that
Yes.
you may have taken in this.
Yeah, that's the one that has the, now I see. That's the one that had the stump remover.
Is that the picture you're referring to?
Yes, the
And
picture I was referring to.
when we produce documents in a case, we put these little Bates numbers at the bottom.
Right.
Is this a document that they produced or we produced?
Well, it looks like they produced it.
Okay. Let's stop that. Defendant's Exhibit 29, I'm not going to show it to the jury, but do you have that in front of you? You have that with you?
I have it, yes.
Okay. And talking about the conversation, did you take a moment and look at your email to Mr. Hocutt on June 23rd at 7:36 p.m.? Take a moment and look at that, then I'm going to ask you some questions.
Understand it?
Okay. Did you express any concerns about the workers using your property for ingress and egress outside of the easement area?
I did.
Did anybody apologize to you for that? Say, we'll
No.
stop it. Did you indicate one way or the other was whether you wanted to be good neighbors or bad neighbors with the DeVeeds?
I didn't indicate, there was no indication either way.
Well, look at the third line. We want.
We want to be good neighbors. Yeah, I mean, I agree with that statement. But when you get yellow ribbons put up on you and goals and other stuff, it's just kind of untenable.
You asked about times you've seen young Hopkins playing lacrosse out there. We've seen a couple of videos. Have you ever actually seen him practicing lacrosse, slinging the ball and that stuff?
Not really. I mean, it's just so wet back there. It's kind of hard to do. So.
Okay. The alleged gun incident, we saw the video. They got it to play better than I did. Defendant's Exhibit 12, no objection?
Objection.
No, objection.
Do you remember in that video that Hopkins appeared to pick his phone up and either start taking pictures or videos?
Yes, it appeared that way, yes.
Defendant's Exhibit 12, it's my understanding from defense counsel, this is the photograph that he took that day and that there are absolutely no other photographs or videos that he took. Do you see a gun anywhere?
No.
Given the history with the DeVeeds, let me withdraw that. I was going to ask you to speculate. Did the police show up at your house shortly after this incident of the alleged gun waving?
No.
Waving. Or the alleged gun incident, did the police show up?
No.
All right, Plaintiff's Exhibit 38 is a picture of the fence from the easement taken by Mr. Elrod as part of the inspection. No objection to that?
No.
Plaintiff's Exhibit 38, this is a picture of the fence from, well, tell us what this is.
This is the fence I constructed from easement area 1 down to just before the beginning of easement area 2. And that was done to keep construction workers and other people from coming up my driveway and going, if you look along where the side of the garage is, there's a path there, you can see it. And when I built that path and there wasn't any fence, people would just walk up across there and across into the David's yard.
Okay. And did you intend to extend that fence across easement 2?
Yes, I wanted to, again, we were going to put the chain link fence in at the very southern end.
And did you in fact extend the fence?
Did not.
And same with the landscaping. Did you intend to do a lot of landscaping in easement area 2?
We wanted to, yes. We intended to.
I haven't seen those pictures. Has that landscaping been done?
Nothing.
Why not?
Because we are in the middle of litigation right now, and I don't want to do anything that could upset that.
So what you intended or hoped to do, you didn't actually do. Is that correct?
That's correct.
Pretty leading.
I apologize. I knew you were going there halfway down the sentence. Let me rephrase the question. Well, the jury knows the point. Let me go back to defense exhibits. Defense exhibit 33 was the landscape plan, just so we're on the same page. Do you know the date of this landscape plan?
It was like within the first 12 months of us living at 3350, I believe.
Okay. And again, why was this never implemented?
Well, the cost was astronomical, so we were looking at that, and I think Claire made the decision she wanted to get the inside of the house taken care of before a lot of the outside.
So your wife made the decision and you saluted smartly.
I did indeed.
Okay. Talking about, obviously, we filed this lawsuit. The record will reflect when it was actually filed. What was the precipitating event immediately before filing the lawsuit? Or was there one?
The letter?
The letter?
Ms. Stern's letter?
What about the?
Threatening?
What about the stalking order?
Yeah, I mean,
Objection, Your Honor.
they were trying to say I was stalking and all this other stuff. I've never seen this woman more than one time.
Okay.
One time.
So you can ask them if there's anything else, but let's not feed them the answers.
Nothing further.
Okay. All right, Ms. Medwick, did you have anything?
No, Your Honor.
Ladies and gentlemen, if you got any questions,
Can I do one cleanup on, it was
if it's 2 questions or less, you can do 2
Oh, no,
questions.
D26, can we just get it moved to admit it?
Yeah, it's not in. We didn't close the loop on that.
I don't think we closed the
Okay.
loop.
Defense 26 is admitted.
Thank you.
All right. So ladies and gentlemen, I'm going to ask you to write your questions if you have any. We're not going to go through them today because we're out of time. But if you've got questions, take all the time you need to write them down. And what we'll start with tomorrow will be your questions for Mr. Anderson.
No more questions?
Well, we can actually get through these. There are not so many. I thought there were going to be more. So let's knock that out. Why don't you quickly look at, I plan on asking all 3 of these. Next to that. Oh, thank you. The issue is getting the touchscreen to work.
I tried earlier, it didn't work.
Sorry.
It's okay.
Yeah.
Great. Yeah. If it's not an easy fix, you'll actually have all tomorrow morning to fix it, because we don't start till after lunch. Is it not playing nice?
Yeah, no. It might be better to do another question.
Okay. Can I get that on your list for tomorrow morning?
Yes.
Thank you. Appreciate it. All right, Mr. Anderson, you don't need to read that yet. That'll come into context in just a moment. Couple questions. Did you, in one of your answers to one of the many questions you fielded this afternoon, mention that you adjusted the angles of some of the security cameras?
I did.
Okay, why'd you do that?
We adjusted them because they were saying that we were pointing them at their house, and we weren't. I was just putting it, it's on particular points of the property where you can show going into doors, entrances, and other things. There's not a single thing that points to their property at all.
Well, what
Nothing.
did you adjust if nothing was pointing at their property?
Well, I think one of the cameras in the back, on the side of the house, might have been a little angled up more than it should have been, so I brought it down.
Okay. There was a situation where you yelled what you yelled to Ms. David.
Yes.
After she had been allegedly talking to the folks working on your yard.
Yes.
You know, the one we're talking about. Do you know how much time passed from that exchange and the restraining order, TPO, whatever we're gonna call it, being taken out? That's just the document. That was to give you a framework.
So it was, I believe it was a couple weeks later, if I'm correct, but she called the police that day and they came to the house.
Okay, and then a few weeks later-ish.
All of a sudden, the sheriff's deputy show up. I was in shock. I mean, I've never had anything like this ever happen to me in my life.
But the answer to the question is, it was probably a few weeks later.
It was a few weeks later.
Okay. Last question, explain to the jurors, if you will, if you can, why, as a CEO, guy who runs a big company, et cetera, you didn't simply tell your neighbors, hey, we can't get to our garbage cans. You need to move your stuff, or have people park in a different way, because we need to be able to get to our garbage and get it out.
Right. That's a fair question. We really, I don't recall doing that and probably should have, but Mr. David, after it was happening, he came over to the house and he saw clearly, you know, that our garbage cans were being blocked by pickup trucks and other construction workers that were along the way. So that was.
Do you have any follow-up based on those questions, Mr. Edwards?
Yes, Tracy, briefly, the document that I handed you a moment ago, the TPO order. What is, at the top of it, it's got a filed date from the courthouse. What's the date that was filed?
3/19/21.
And if you flip back a few pages, we've got the petition. And then there's a page where Miss David signed it, got a little notary thing on it. Says sworn to and subscribed before me.
Yes.
What's the date of that?
8th of March, 21.
Nothing further.
Any follow-up, Ms. Stern?
No, Judge.
Okay. Ladies and gentlemen, we are about done for the day. Tomorrow, we start at what time?
1:30.
1:30, so be here. The shuttle doesn't run as frequently in the middle of the day. So if you're relying on the shuttle and think, hey, if I get here at 1:28, I'll get on the 1:29 shuttle. There's not a 1:29 shuttle. So get here in time enough if you're parking in one of those lots to catch a shuttle, so you're here by 1:30. Feel free to bring a lunch, but don't expect to get a lunch break. Are we able to go a little past 5 tomorrow? Did you all talk? Okay, we'll see. We may have a natural break point at 5:10 and we'll just stop at 5:10. But if we've got some good momentum, you're into what's happening, I'd like to use as much of your time as we can get. After you leave, I'm gonna talk to these lawyers about where we are in their time estimate, because they represented to me and then I represented to you a certain time frame. And I'm gonna see if they feel comfortable with what they had represented, so that I can feel comfortable with what I told you all. But that's it. This has been your first day of receiving evidence. Tonight, don't go do any research. I'd want to not think about easements anymore if I were you, but I can't tell you not to think about them individually. But don't talk with your spouse, your girlfriend, your pet, whatever it is about the case, because someone may give you feedback that you ought not to hear. We want you to stay in that healthy bubble of getting information only in here about this case. 1:30 tomorrow, I'll let you know then and there where we are in terms of the schedule. Any logistical questions from anyone? I'll start here, sir.
The bus is it roughly runs every half an hour or is it like every hour?
Let's ask our subject matter expert, Deputy Gordon.
Every 30 minutes.
Every 30
Every
minutes.
30 minutes.
Yeah.
On the top of an hour and a half an hour or is it? Okay.
No, 1:17 and 1:47. Yes, it's at 1 and 1:30. So you don't want to get here, like if you get here after 1, then maybe you have a scooter or something. But that last bus to catch would be 1 that will get you here in time for the 1:30. Great question, sir.
You leave these all here, right?
Yes, I forgot, this is your first day. We've been together for so long at that, and you know this already. Please take your pads and leave them in the jury room. They'll be safe in there. That's your space. You can leave anything you want there. If you've got a particular Yeti thing that you refill with water, you can leave it here if you want to do that. That's your space, but don't take your notepads home. No studying. So you leave your notepads there and you'll grab them tomorrow afternoon when you get here. Any other questions? Thank you for your time. We'll see you tomorrow.
All right, adjourned.
Leave the.
Okay, you can leave it. Mr. Anderson, hold on to that stuff and walk around. There's a shelf in front of where you're testifying. Put it right there.
I will.
Thank you. Perfect. All right, Mr. Edwards, I need your best estimate as to how much more time you think we have, since you were the first to say, we're putting this case up on Tuesday. And here we are. And you know what, I get it, there are two sides, and so I'm not fussing at anyone.
Yeah.
But I want a more accurate time estimate.
We got to start with Ann Nykerk at 1:30. So I need Ms. Niles to give me the Zoom link for tomorrow ASAP so I can get it to her so that we can start.
Okay, what I'm gonna ask you to do is to reach out to Ms. Niles tomorrow. You've got all morning while I'm doing something else, and she'll certainly get that to you.
I will do so.
And it's great that she's going first, because then we're not worrying about, oh, wait, she's in the waiting room, not in the waiting room, so that's good timing.
Yeah, and I'll of course copy all counsel on that. Then I think 1 or 2 witnesses after that. I've got to testify as to attorney's fees. Hopefully that will not take very long. Hopefully we should be finished 1:30. My direct of Ms. Nykerk will take 10 or 15 minutes. Hopefully we'll be ready to rest around before the end of the day, hopefully, and I'm very disappointed.
The other witnesses you have to call, you don't expect to be, you don't control cross as long as Mr. Anderson.
No.
Okay, got it. Okay, Ms. Stern, you still have a case to present as well, so we're clearly going into Thursday. I'm asking for 2 reasons. 1, so we can be honest with the jurors, but 2, to figure out when we're gonna have our charge conference, because you guys have made a mess of the charge. A lot of non-pattern charges. Poor Ms. Niles pulled a lot of hair out putting together her draft. What's your forecast? Assuming
they're gonna rest tomorrow and we start Thursday. I would like to think that we could get the bulk, if not all of our case done on Thursday. Again, some of that may depend on how long we want to spend with folks. If we go into Friday, I would I would think it would be very short. So I would think we could get to the charge conference Thursday. Or we could. No, we could get to, I think we could rest our case Thursday and I think, well, well, I would think we would be able to rest our case Thursday. I don't know if that means we'd also get closing in.
No. I don't mind if Friday is closing and I charge the jury.
Yeah.
But we told these folks Thursday,
Yeah.
because you told me Tuesday, Wednesday, and so I said Thursday. I think they're good through Friday. I can't remember if we've got some folks where we said, don't worry, you're gone Friday evening. I mean, you all are running into that issue if that's what happens. So you may want to check your notes as to who got on the jury and who didn't. But I was very clear that they weren't going to be here next week. So we just need to make sure that when we've got witnesses on the stand and we've got exhibits we want to share with them, those exhibits are ready and they're on the screen and they play and all that kind of stuff. So we can compress. I think we have some compressible space in there. We will see Ms. Nykirk at 1:30 and take it from there. Mr. Edwards, anything procedurally?
Just one question. I understand Your Honor's rule on if we call somebody for cross, they get to ask direct. Is it wide open direct or is it redirect limited to my cross?
No, it's wide open because ideally, from a juror's perspective, that witness never takes the stand again. The jury hears the whole story through the exchange of the lawyers. So it's not limited to just your, so if you call a David tomorrow, should Ms. Sturm want to put on her whole set of counterclaims through her follow-up to your questions, I'm okay with that and the jurors will be okay with that. But the other connection to that is Ms. Sturm may decide to ask some questions, but not all, and still call that David to the stand to ask more questions. Of course, you'd be able to ask questions of the witness then as well. Just your cross in round two would be tied to the direct of round two, if that makes sense.
That's good.
Okay. Anything else? Ms. Medwick, I didn't mean to skip you. Are you planning on having yet a different presentation? Or the way it's been flowing so far, you think that you'll get in what you need to either through witnesses that Mr. Edwards is calling or your examination of witnesses that Ms. Sturm calls?
We did my one witness today.
All right, Mr. Venable.
Yes.
It's a one short and sweet one. Excellent.
Yes.
All right, sounds good. Ms. Sturm, anything from the David side?
No.
I don't know, when are you gonna open this courtroom up tomorrow? When would you all like the courtroom opened up tomorrow?
One would be great.
Okay, we can have it before one. We'll be in a different courtroom doing other stuff, but we can get it open by one, because jurors may be showing up by then anyway, so we'll need someone here. All right, then I will see you all as close to 1:30 as I can make it.
Thank you, Judge.
Thank you.